May I have your lordship?
Please hand over all the slips. Hand over all the slips. Hearing matters, appeal hearing matters will appear in the February list of monthly list of February. Hearing matters we are taking, but those will appear in the monthly list of February. Whatever. I mean, hearing of appeal matters will appear in the monthly list of February.
This is a CAN application, Your Lordship.
Rest, please hand over the slips.
My lord, to be mentioned.
I think we have made ourselves clear. Yes. আপনি একবার এদিকে আসুন। Yes, yes, we said hand over all this.
Correction also, man. Rectification of Your Lordship. Your Lordship, may mention one matter, Your Lordship. There's some urgency. This is regarding a refusal of ad interim injunction. I have filed the misappeal on the last Thursday. I'm mentioning if Your Lordship can give it some precedence.
No upgradation, no. Call on the list.
Lordship,
Yes.
Number one, my lord, I'm sorry, I had mentioned.
What is the correction?
Correction is in the 5th line. It is mentioned a book, but it should be.
Please use the
4
microphone, ma'am. In the
Ma'am,
5th line,
fifth
a
line,
book, yes.
It should be 4 books.
Very good. In the order dated January 7, 2025, comma, it was mentioned in the 5th line of the first paragraph of the said order that double inverted with a book, double inverted clause, authored by the defendant appellant was the genesis of the suit. Full stop, next para. It is pointed out by learned counsel for the appellant that there were 4 books which were the root of the cause of action of the suit. Full stop. Accordingly, the order dated January 7, 2025 stands corrected to the effect that the expression double inverted a book in the 5th line of the first paragraph of the same shall be read as within double inverted 4 books, double inverted clause, full stop. Let this order be treated to be a part of the order dated January 7, 2025. Yes, that matter.
Child custody matter, my lord. That I have filed an affidavit, my lord. And furthermore, my lord, the pursuant to your lordship's direction, my lord, 5 days, the child went to the residence of the.
Have you given copy of this to them?
Yeah.
You have got copies?
Only Friday, my lord, at 5, my lord, I have received.
Well, we'll keep it on Wednesday for orders. Go through those and we'll pass our orders on Friday.
But, my lord, may I use any exception?
No further exception.
Well, may I be use any exception to this?
No, we'll hear you verbal. You are not recorded. You are the special officer. The affidavit filed on behalf of the respondent mother today be kept on record. Full stop. Copies thereof has been circulated on the learned advocate for the appellant and the learned special officer. Full stop. Let the matter be listed on January 15, 2025 for passing further orders.
Under the same head.
To be mentioned, to be mentioned. Yes, same heading.
Grateful to
Respondent applicant.
Yes, Mr. What is the application for?
Application for recall of the lower court's record. Not earlier, there was an order directing the appellant to file paperwork. but they have not yet filed. That's why I have filed this application for call for the records by special messenger at our cost.
Records have not yet come at all.
No, because they have not put in the special messenger cost.
Cancel. তাহলে করে দিচ্ছে ওদের রেসপন্ডেন্ট prepare the paperwork, Mr. Okay.
Yes.
Very good.
I'm fine.
Can 3 of 2023 has been filed on behalf of the respondents in the appeal, which of learned counsel appearing for the respondent submits that despite a direction of the court, the appellants have not yet put in the special messenger costs for bringing the trial court records, nor filed any paper books. Which of in order to expedite the appeal, the respondents seek to take upon themselves the burden of doing so. Full stop. Next para. Accordingly, can 3 of 2023 is allowed, thereby directing the respondents to deposit special messenger costs. Full stop. The trial court records be brought by such special messenger at the earliest. Full stop. Next para. Upon the records arriving before this court, examined and found to be complete, a notice of such arrival shall be served on the learned advocate on record for the respondents, which of the respondents shall, within 8 weeks thereafter, prepare and file the requisite number of informal paper books without comparing with the records. Full stop. Next para. Liberty to the parties to mention the appeal for inclusion in the list for the purpose of hearing, as and when the same is made ready for hearing. No rest to cost.
This is can 2.
Can 3?
Can 3 is application for injunction.
No, the other way around. We have the application before us.
That is can 2.
Injunction is can 2.
Injunction is can 3. No.
Your learned junior has committed a mistake in copying the number. We have the original applications before us. Yes, next.
And the can application for injunction, already there's an order for maintain status quo.
Let it be there then.
Yes. And my lord, only they are enjoying the use facts of the property as well as the appellant. And they are not.
It's their application, Mr. Rokit. You cannot hear without them. Let it be as it is when they mention the matter. Next.
Item number 5.
5.
And I'm appearing for the appellant herein. My lord, on the previous occasion, my lord had directed that GS can 7, my lord, and affidavit is to be filed by me within 24th of December. My lord, I'm out of time in filing the affidavit, but my lord, I have been able to
So,
contact with
affidavit in reply.
in opposition, my lord.
You are the
Respondent, my lord.
You are the appellant in the appeal.
I am the appellant in the appeal and the respondent in can 7, my lord. My lord, this is an application for appointment of receiver. My lord, I'm out of time in filing the particular affidavit, but however, my lord, I have been able to I could not. The reason was I could not contact with the client. I had made endeavors and then finally have been able to contact, and I can have it affirmed and filed today and serve a copy. But in the meantime, my lord, I had a word with my learned friend. My lord, both the parties.
You're for the other side.
Yes, sir. This is a 2019 order from which we have come up in appeal. My lord, the matter is otherwise ready for hearing.
What is
All-
the decree for?
My lord, the decree is a preliminary decree in a partition suit in respect of a the respondents are claiming their father Baroda Prasad Mondal.
Appeal is ready for hearing means paper books have been filed and all.
Yes, my lord, it is filed. All of it is ready. my
So what do you want regarding this
lord.
application?
Perhaps, my lord, it would be better if we can have if this application or the appeal may be taken up for final hearing and both of them may be considered together.
Very well. On the prayer of learned counsel for the respondents stroke opposite appellants. You are the appellant in the
I'm the appellant. respondent.
on the prayer of
Appellants.
learned counsel for the appellant in the appeal and the opposite parties in the present application, the time for filing affidavit in opposition to the application is extended for a week from date. Full stop. Reply, if any, shall be filed within a week thereafter. Full stop. Next para. Since learned counsel submit that the appeal is otherwise ready for hearing, let the appeal along with the application be listed for hearing in the monthly list of February 2025.
Much obliged.
এটা appeal hearing এ আসবে ফেব্রুয়ারিতে along with the application.
I'm appearing on behalf of the husband respondent.
How are you now? You are not well. Very
Recovering.
recovering. Very good.
Lordship, I'm paying for short.
No short passable. No applications. No time. You are for the petitioner.
Respondent.
Respond.
Opposition.
Yes.
The reply.
What is your reply?
Reply I have served, Lordship. The brief has not come, Lordship.
No. Your problem. We'll hear out the what is the application for?
Lordship, they are not paying the maintenance, Lordship. Last occasion, the court directed to pay 10,000 per month. 3 months they have paid. After that, they stopped paying anything.
Have you filed your affidavit of assets?
Yes, Lordship, I have filed. They have also filed. I have a son, Lordship.
No, you have also filed your affidavit of asset previously. So why this affidavit in operation filed later?
Last occasion, it is fine that there is an application pending. Your Lordship was pleased to direct it.
Oh, this application is for violation of the order of court.
Yes, Lordship. The order, there was an order to pay 10,000 per month to the wife and the son.
They are not paying.
Only 3 months they have paid. After that, they have
Opposition
not.
as well as my affidavit of asset, my lord, I have already stated I am not in a position to pay that much of money, but I am paying, my lord. I am paying.
No, but the
10,000
No, but the difficulty is there was an order of the court. You have not asked for modification of that or recall of that. So still the order stands. You have to comply. Otherwise, we'll attach your property.
I have
We'll attach your salary. Your salary. What do you do?
my lord, just private tuition for
Private tuition. What is your income? Disclosed income. What is your disclosed income?
He is an B engineer, Lordship.
In your affidavit in opposition, what did you disclose as your income?
I don't have any asset, my lord. I don't have any,
At present, your monthly income is not more than 3,000 per month.
my lord.
No, there is no application. You have to pay whatever are the dues, and you can file an application for modification of our order. But the order stands, and you have to comply. As of date, you have to comply with the order. Otherwise, we'll send you to jail if you don't have assets.
Possible for me to
We can grant you a limited time. I mean, but then you'll be imprisoned. No other option. Why didn't you ask for modification of that order at the time of hearing of when was the order passed? Modification, the alimony order. What was the date? On 19th of April 2022.
and at that time I was not appointed as a lawyer, my lord. Later on I'll appoint it and
No, it's not your issue, your client's issue.
yes, my lord.
But your client was represented
Yes,
by
my lord.
counsel. And upon a contested hearing, this was directed.
Yes, Lordship.
Yes, my lord.
No, then we'll send you to civil imprisonment if you can't pay. We'll give you a fortnight's time to pay up whatever are the dues. And in the meantime, you can file an application for modification of that previous order also.
And in both of my affidavit in opposition as asset, I already said that I don't have any capacity to pay. Kindly that thing, my
No, in the absence of any modification application, we cannot do anything in that regard.
Lordship,
That order has attained finality. It was a 2022 order, and you have paid for some months.
yes, my lord.
Yes, what do you say?
Lordship, I have a son, Lordship. He's 18 years, 17 years old, Lordship.
What does he do? Studies, obviously.
He studies, Lordship. I have also no income. He is a B engineer, Lordship.
We'll give you a fortnight's time, Ms. Banerjee, if you can't comply, and then we'll take up we'll adjourn it for a fortnight. When the matter is moved, learned counsel for the petitioner seeks an adjournment to file reply. Next para. Upon query of court, learned counsel appearing for the opposite party, husband, submits that the husband, even as per his disclosed income and affidavit of asset, has a meager income to the tune of rupees 3,000 per month from imparting private tuition. Next para, as such, it is not possible for the husband to meet the alimony amount directed by this court. Next para, upon hearing learned counsel, we find that by the order dated April 19, 2022, a coordinate bench had directed, upon hearing both sides, to upon hearing both sides, the husband to pay alimony to the tune of rupees 10,000 per month, although for 3 months, such order was complied with, comma, thereafter the husband faltered in doing so. Full stop. Next para. Since till date there is no application for modification of the order dated April 19, 2022, directing the husband to pay rupees 10,000 per month, comma, nor is there any further challenge to the same, comma, the said order has attained finality as of today, full stop. Next para, hence, comma, the opposite party husband is duty bound to pay the arrears of alimony in terms of the order dated April 19, 2022, in addition to current alimony to the same tune. Full stop. Next para, unless such payment is made, comma, the opposite party husband shall have to face consequences of law. Full stop. As a last chance to the husband to clear off his arrears in terms of the order dated April 19, 2022, comma, the matter is postponed for a fortnight and shall next be listed on January 27, 2025 under the same heading, full stop. The appellant wife shall file her affidavit in reply on the said date, full stop. Next para, leave is granted to the respondent husband to file any modification application if so intended, comma, in the meantime, and mention the same before the court for being listed along with the present application on the returnable date.
Sir, I'm led by Mr. Amitabh Mukherjee.
Mr. Amitabh,
Mukherjee.
Mr. Mukherjee is in court. Yes, give his name also.
You filed today.
Have you said that? আমরা কি বলেছি affidavit in opposition? তাহলে প্রথম লাইন ওটা হবে। Thank you. Affidavit in opposition filed by the opposite party husband today be kept on record. প্রথমে বোধহয় বলেছি কোথাও। Next.
My lord, I want this little more possible in this matter. Mr. Samal Chakraborty engaged in this case.
No passover in applications.
Just 10 minutes possible.
No, no, no.
He's on the way, sir.
No, no. What is the application for?
This is an application for injunction, Your Honor.
Right.
Still
This arises from what appeal? Appeal against?
appeal against a decree passed by the order of dismissal passed by the London 10th, 13th bench.
What was the suit for?
Suit for declaration and injunction.
Why was it dismissed? On what ground? That you don't have any title?
Sir, we have the grounds, sir. Let me just to close.
It was an ex parte dismissal.
Yes, the suit was proceeded ex parte and yet it is dismissed.
Let us see. It was regarding shares.
Yes, my lord.
200 equity shares.
Yes, we have prepared and supplementary affidavit, my lord.
Have you given copies to them?
So we have not signed.
Supplementary affidavit?
Just we have prepared it. Right.
No, you don't have a right to file supplementary affidavit. What is a supplementary affidavit? If you have not given copies, then you may not permit it.
Annexing an application, annexing a letter, just nothing well more.
What is the letter about?
Issued by the defending company.
Was this a part of the trial court?
I
No.
think My,
No.
I think, sir, it is so, sir. I think it is so.
Anyway, give her a copy of this supplementary affidavit. Consider this, and you have filed your opposition to this.
No, I sought for instructions from my client on this. This is a very old matter of 2003, my lord. I did not get any instruction on that, on the subject matter.
So we'll give you 3 weeks time to file opposition.
Already they have granted so much time, sir.
My lord,
You're using this supplementary affidavit without a copy to
It's
them.
just filing an annex, just a document simply, I think.
A supplemented affidavit is filed in court today, full stop. However, comma, no copy thereof has been handed over to the learned advocate for the respondent, full stop. The learned advocate for the appellant shall hand over a copy of the supplemented affidavit to his counterpart appearing for the respondent during the course of the day. Full stop. Next para. A composite affidavit in opposition shall be filed to the injunction application and the supplemented affidavit within 3 weeks from date. Full stop. reply, if any, shall be filed within 1 week thereafter. The application shall be listed for hearing on February 12th, 2025.
Lots of there are many respondents. I am only for respondent number 1.
যেখানে respondent বলছি, respondent number 1.
Others are
Our copy shall be served on the learned advocate for the respondents করে দেবেন. Serve on all the respondents. Thank you.
not.
কিছু কেস নেই। কাউন্টার চাই, একটু শেয়ার ফেয়ার সেই সইনি সার্টিফিকেট। এটা করতে Bhattacharya, what is the matter?
I am for the appellant. But I am submitting before lordship.
Yes.
Since I have filed an application for custody of child, since the matter itself relates to custody of child, section 7 and section 25 of the Guardians of Rights Act, both the appeal and application will be disposed of by you.
You have filed this application for custody.
There is
Custody was refused by the trial court, that's why the appeal. Very well. Then we'll direct them to file
the composite objection and the
composite. Why?
This is supplementary affidavit.
Oh, this is supplementary.
They have already replied to the supplementary affidavit.
Very well, Mr. Bhattacharya, your client will file a reply to this composite affidavit now.
But,
Will
one point arises, subject to lordship and sanction, that I took a point. My daughter has been put to a particular home.
home.
Now the evidence, now the documents have been placed by my learned friend that it has been put to a hostel and a school. My client inquired into the matter yesterday, and it was found this is not a government approved hostel. There is actually a home.
Mr. Bhattacharya, you can put that in your reply because you have not yet filed your reply to this.
In that, otherwise on question of law and facts,
Lordship,
I can
I have submitted the
please,
papers,
madam,
documents with it that they are saying in their supplementary affidavit that the appellant has no knowledge about the home or hostel, whatever it is. But from the home itself, it was informed to my client that once the son
We'll consider this because Mr. Bhattacharya, you yourself said that this will appear along with the appeal. Let us hear all.
my submission, the home, if my learned friend claims that she has been put to a hostel, who is funding the hostel?
We'll consider that at the time of hearing.
Clients are funding.
Composite of affidavit in opposition
Then I file a reply.
to the application as well as the supplemented affidavit filed today be kept on record. Full stop. The supplemented affidavit filed by the appellant is also kept on record. Full stop. Next para. Learned senior counsel appearing for the appellant submits that since the application itself pertains to the merits of the appeal itself, as the appeal arises out of refusal of custody to the appellant father, comma, we are of the opinion that the appeal that the application should be heard along with the appeal. Full stop. The appellant shall file his composite affidavit in reply within a fortnight from date and prepare and file the requisite number of informal paper books within how much time? Only to annex these documents. So we'll give you 4 weeks time. Within 4 weeks, without comparing with the records. Full stop. Records have been directed to come. Records have come. Do you have any idea? Very. Let's see. Records.
And say the school and home may be added as parties.
No. Custody matter there. Stop. Next para. The appellant shall also put in special messenger cost for bringing the trial court records at the earliest, and the trial court records shall be brought by such special messenger. Full stop. Next para. Liberty to the parties to mention the appeal along with the application for inclusion in the list as and when the records are examined and found to be complete and the other appeal is otherwise ready for hearing. But paper books, the paper books you can file within a fortnight. You get those prepared, put in the special messenger cost immediately so that the records come. Thank you. Next. Section 5 first.
As per direction, my lord, I filed the affidavit to police.
Opposition to Section 5. What is your reply?
So I have not received it.
Why didn't you give a copy?
Oh, yes.
So we'll proceed without the reply then. Yes. What is the substitution application? Substitution.
The substitution for death of the two respondents. Because after the filing of the appeal, they died, and the matter was not within our knowledge. And it came to my knowledge as and when
The substitution has to be allowed first, because we cannot pass orders in the name of dead person. Substitution has been filed beyond time.
Beyond time.
What is the reason that you came to know later?
Only as and when I came to know from the learned register that the two persons have died.
How did you come to know from the registrar?
Because there was the summon was issued, the summon returned, and then we contacted. Then the learned
Summon of what?
Means notice. Notice was it.
Notice of this application.
Notice of the original application. Appeal.
Notice of appeal had been issued already.
Had been issued.
How could it be issued before Section 5 was allowed?
No, this is not. The Section 5 come later on.
Section 5 is for condonation of delay in filing the substitution.
Condonation of delay for substitution.
All right. What is the delay about?
There are more than 1100 days for one and 344 days for another. Because one died in 2021 and another died in 2023.
But both died after the filing of the appeal.
After filing of the appeal.
Yes, what do you say? What is it?
Is the partition issued, my lord?
So then we should allow the substitution application. You have filed an objection, that's why you are.
Yes, objection, my lord. Like me.
Okay. Learned counsel for the appellant stroke applicants, appellant stroke petitioner submits that the delay in filing the substitution application took place because of lack of knowledge of the appellants regarding the demise of the deceased respondent numbers 26 and 27 during pendency of the appeal. Push up next para. Although there is a huge delay in filing the application, it is contended that the appellants learned of the demise of the said respondents only from the registrar as and when the notice of the appeal could not be served on them in view of them having met their demise. Push up next para. Upon hearing learned counsel for the parties and taking into account the affidavit in opposition filed today by the respondents, we are of the opinion that the delay occasioned in filing the application for substitution was beyond the control of the appellants. Full stop. We also find that the present application is bona fide, and as such, the delay ought to be condoned. Full stop. Accordingly, Can 2 of 2024 is allowed, thereby condoning the delay in filing Can 3 of 2024. Full stop. Next para. The same logic as discussed above also applies to the delay in filing the substitution application. Push up accordingly, Can 3 of 2024 is allowed, thereby setting aside the abatement and directing substitution of the heirs and legal representatives of the deceased respondent numbers 26 and 27 as enumerated in Can 3 of 2024 as respondents in the appeal. Push up. The necessary consequential corrections shall be carried out to the memorandum of appeal by the concerned department of this court within 3 weeks from date. Pushed up. Next para. You are appealing for all the respondents?
No, my lord.
Yeah. The office shall also file a report.
I am 1, 4, and 6 to 8.
As to the fate of the service of notice of appeal on the surviving respondents within 3 weeks. Full stop. Next para. The matter be placed under the heading to be mentioned for passing further orders in that regard. The office will carry out the corrections, give a report to us whether all have been served. When it comes as to be mentioned after 4 weeks, you just check up in the meantime. Please check up in the meantime what is the report of the office and apprise us on the next date. If all have been served, we'll direct paper books and whatever other days. Well, then we'll fix the appeal for hearing if all have been served. If all the respondents have been served and the office gives a report to that effect, we'll treat the appeal as ready for hearing and direct it to appear in the list. Thank you. Partition should দেখুন আরো একটু মরে গেছে কিনা। Yes.
That is on by order dated 17 December 2024.
Right.
My lord's pleasure was to direct the Commissioner of Police, Chandanagar Police Commissionerate, to open an account and deposit the monthly sum as your lordship is directed by the husband. When that was done, my lord, if your lordship kindly allow me to file the report. আর একটা দিয়ে দেবেন। এটা নেবেন।
So now you're that you are getting that amount.
No,
It is being deducted only.
maybe, my lord, I have no knowledge, my lord. I took instruction, nothing has come down to my account.
Account number, everything has been given.
Yes, yes. Let us check that up. Yes.
What account number?
No, that was not the case. This account has been opened in the name of
Police Commissionerate.
Police Commissioner. We will direct you to go on paying the monthly amount of alimony as directed from this account to them.
Right.
You go on deducting and depositing there, and since it is under your control, or we will direct an ad hoc amount.
Bank, lot.
Bank is not a party here.
State Bank, no, we are also not party, but your lordship is directed. That's why we have come.
No, there was a direction on. Oh, very well. What is the dues till date?
My lord, in the last order, my lord, it is 1,56,000 was the area.
No,
And
2,56,000.
2,56,000, and my lord, the identity was, my lord, 20,000 per month.
For the time being, Mr. Rai will direct the current monthly amount to be disbursed to you from this account, and we'll wait till the entire arrears are realized, and then we'll pass appropriate orders. For the time being, you will get 20,000. You will be permitted to withdraw that account.
But my lord, I will permit, madam, the account, the money will come down to my account. If that be so, then my lord, I will have to give the particulars to the bank or to the commissioner.
Yes.
My lord, whom shall I, my lord,
Because it has been opened in
because
the name of the
my
commissioner.
bank particulars have to be given.
Put it in the give it to the commissioner as well as the bank. We'll give you
Kindly direct that.
liberty to approach
And
both.
both may be
Then in
directed.
that event, my lord,
We'll direct both the commissioner as well as the bank. Otherwise, either of them won't be bound.
then which bank branch and which bank, my lord, I need to know.
We'll record in our order.
Because I have
Can you give a copy to them, Mr.
Yes, yes. Yes, no, I'm-
grateful.
Well, Learned Counsel appeal.
report that I have-
Obviously, we will. Learned Counsel appearing for the state submits that as per the direction of this court, the salary of the respondent husband, who is an assistant in charge, special branch, Chandanagar Police Commissionerate, amounting to rupees 89,866 for the month of December, 2024, has been transferred to a newly created account bearing number 436641062008. Full stop. Next para. Necessary documents in that regards filed in court to be kept on record. Full stop. A copy thereof is also handed over to the learned advocate for the appellant wife.
State Bank of India, Chinsurabra.
Appellant wife. Full stop. Next para. Since the account has been opened with the Chinsura branch of the State Bank of India, situated at Chinsura, Hooghly, the said bank is directed to disburse an amount of rupees 20,000 per month to the appellant wife within the last day of each month, the first of such disbursals being by January 31, 2025, to the tune of the current alimony at the rate of rupees 20,000 per month. Full stop. Next para. The said bank as well as আরেকটা line add করেন তার আগে। The Chandanagar Police Commissionerate, comma, in the name of which the said account stands, comma, shall also make the necessary communication to the bank to facilitate such disbursal in favor of the appellant. Full stop. Next para. The said amount shall be disbursed online and transferred directly to the bank account of the appellant wife, the particulars of which shall be furnished by the appellant wife within a week from date in writing to the Chandanagar Police Commissionerate, comma, directly or through its counsel and the concerned bank, that is the Chinsura branch of the State Bank of India. Full stop. Next para. Such payments shall be on an ad hoc basis without prejudice to the rights and contentions of the appellant in the main appeal and the application. Full stop. Next para. It is made clear that further orders shall be passed subsequently as and when the entire amount of arrears as enumerated by this court in its order dated December 17, 2024, that is rupees 2,56,000 is realized. Full stop. Disbursed for the time being 20,000 to them, and further orders will be passed when 2,56,000 is
Further report, Lord, may, our Lord, we shall be
liberty to the parties as well as the Chandanagar Police Commissionerate to mention the matter for further orders if necessary. If you find it necessary, we can pass further.
But affidavit of service, ma'am.
Affidavit of service file to be kept on. Thank you. Great.
the report be kept on record. The report. file.
Yes, yes.
My application.
Yes,
Because I'm for the respondent.
right.
There was a direction for service, my lord. I have served, my lord. And kindly grant me leave to file a supplementary affidavit that is also served, my lord. In connection with the stay application, certain document was not there, my lord.
This is a Section 5 application we are
Section
hearing.
of application was allowed, my lord, last occasion.
Acha.
Thereafter, there was a direction for service of the stay application and order 41 rule 27 application. Both are served along with the supplementary affidavit.
The application is not appearing.
My lord.
Can one টা appear করছে না কেন? এটা কি 11? Can one list নেই কেন? Can one তো pending? List নেই কেন? না, 2 disposal হচ্ছে। Can 2 or 3 appear করছে? 2 তো already dispose of হয়ে গেছে, 1 or 3 তে appear করবে। এরকম হচ্ছে কেন? Anyway, both of you are ready in the matter. What is the appeal against?
Suit for eviction of license, my lord. Degree was granted, my lord. Against that, I have preferred this appeal, my lord, from the city court, my lord. First
But
step.
then you'll have to file an opposition indicating the occupation charge.
The application itself is not maintained.
Why do you say that?
Because it is stay of operation of the judgment and decree. This is
You have
not,
put
my
it
lord,
into
clear-
execution.
Yes, my lord, I have put it into execution, but they have not paid for, my lord, stay of execution proceedings.
That does not render it non-maintainable. We'll pass orders staying operation as well as the connected execution. But you have to file your opposition disclosing the occupation charges because we'll. How soon can you do that?
2 weeks.
The supplemented affidavit filed on behalf of the appellant today be kept on record. Post of next para. The appeal arises out of a decree for eviction of licensee. First of next para, it is contended by learned counsel for the appellant that unless an order of stay of operation of the decree is passed, comma, the appeal will be rendered infructuous. First of next para, learned counsel for the respondent submits that the application is not maintainable in view of the impugned decree having already been implemented by levying execution. Full stop. What is the execution case number?
Thanks.
Full stop. Next para. However, comma, we find that merely because execution case has been filed, comma, the appeal cannot be treated to be infructuous. Full stop. Accordingly, there shall be stay of operation of the impugned decree as well as connected execution case, comma, if any, till disposal of the application, till disposal of the, till disposal of the application, full stop. However, comma, it is made clear that the question of imposition of occupation charges as a condition of the stay is kept open for being decided at the final hearing of the application. Full stop. The respondent shall file his affidavit in opposition to the application within a fortnight from date, comma, disclosing therein relevant materials to show the current market rates at which occupation charges may be imposed. Full stop. Next para, reply if any shall be filed within a week thereafter. The application shall be listed next on February 10, 2025 under the same heading.
Plus title execution number 52 of 2023.
We have said connected execution case. You are also present. আচ্ছা প্রথম লাইনে একটা অ্যাড করে দাও. Although can 1 of 2023 is not appearing in the list, comma, since both parties are apprised of the facts, comma, the said application is treated to be on the day's list. তারপর যে অর্ডারটা দিলাম সেটা এই পরের দিন এনশিওর করবে যে এই অ্যাপ্লিক্যান্টটা যেন ওয়ানটা যেন আসে লিস্টে. Thank you. আচ্ছা, can 3 should you dispose of by directing that to appear along with the appeal? It's a order 41/27 application.
Again, Malas, that also, Malas, two documents has been annexed.
So we'll permit you to file opposition in that also. আরেকটা লাইন অ্যাড করে তারপরে যা হলো তারপরে একটা লাইন, the respondent opposite party shall also file an affidavit in opposition to can, what is that, 3 can 3 of 2024 can 3 of 2024 within a fortnight. Full stop. Reply if any thereto shall also be filed within a week thereafter. Full stop. Can 3 of 2024 shall also be listed along with can 1 of 2024 on the returnable date.
I owe an apology to your lordship. I was supposed to put in opposition, which I could not.
No, this is the first time you are
Asking for the extension. The 23rd, I was supposed to put in opposition to the Section 5 application and also to the other application.
leave to appeal. Who is appealing for the appellant?
I am for the appellate.
Oh, sir. So if you accept that apology, we will also accept. On the prayer of learned counsel appearing for, sorry, on the prayer of learned counsel appearing for the respondent, you are for the plaintiff respondent.
Yes.
There are two respondents.
Yes, yes.
On the prayer of learned counsel appearing for the plaintiff respondent, comma, the time for filing opposition to the applications bearing can 1 of 2024 and can 2 of 2024 is extended for
Maybe for 10 days.
for a fortnight from date. Full stop. Reply if any shall be filed within a week thereafter. The applications shall be listed next on February 10, 2025.
Thank you.
Thanks.
There's a additional service of notice upon the opposite parties, my lord. Service has been effected except 2, 5, 6, and 7. So, but the plaintiff was the contesting and we are the contesting, and other two contestants are defendant number 1 and 2. They have been subject to
The partition suit.
suit for this is a plaintiff suit. We are we as my lord, I have served.
Affidavit of service file.
No,
Aff- Affidavit of service file today be kept on record. We will continue this order till disposal of the appeal. Proceedings will continue, but no final degree.
In fact, for defendant number 1, there's no title deed.
That will be decided in the appeal.
8, defendant number 8.
He is 8.
Title and interest. What is the observation of the order?
That has been subject to challenge.
No, he has no.
What will be your primary ground, Mr. Rai?
If your lordship can turn to internal page 16 of the appeals court judgment. Learned trial court judgment.
Internal page?
Internal page 15 minutes. Can you turn to internal page 15? Last portion. The defendant number 8.
Yes.
My lord, got it? In view regarding the it is further pointed out the solemnity connection such and such was ended with an order which was final degree was passed between the parties. The plea that the said degree was not registered is not acceptable by virtue of section 17 of the Registration Act, which provides the degree for order expressed to be made for a compromise immovable property does not require registration. After
You got a share in the property by virtue of that compromise.
no, by virtue of compromise, somebody else got, I am entitled to get. And my case is that it is third party who got the property by way of compromise is required to be registered.
This is a valid point, arguable point.
I have a look to the order, impugned order, my lord, ordering portion, my lord.
Yes, that is.
It is hereby declared that the plaintiff.
Yes, this is the reason for so declaring. They take a point that if a portion of the property is given by way of a compromise degree to a third party, then registration is necessary.
Yes, my lord.
So that is the point which is to be decided in this appeal. So therefore, they have a prima facie case. If that compromise degree was bad, they would have a share.
Then I will have a share.
Do you get our point?
Yes, I have got. My lord, in the compromise that he is not party to the compromise.
That is the precise point.
Yes.
But he was one of the owners.
Yes, originally he was in possession. My lord, in this appeal, my lord, defendant number 8, I mean appellant, my lord, has no right. It is categorically stated in the trial court, by the trial court. My lord, kindly have a look to the property right. The property rights.
Priority of rights.
Page number, my lord, running page, my lord, ordering page 15 to 17.
Yes.
It is further appear that the plaintiff and the defendant number 1 and 2 has acquired possession of possible property on the strength of the purchase deed, which are earlier documents than the defendant number 1, defendant number 8, which are earlier document than the defendant number 8. It is established principle of law as contained in section 48 of the Transfer Property Act that the earlier document executed by a property prevails over subsequent executed documents for some same property. In the light of the above discussion, this court is of the opinion that the plaintiff has discharged the burden of proof in respect of her share, and the defendant number 1 and 2 have similarly discharged their burden of proof. Now the defendant number 8 in this suit has referred to some proceedings under section 50 of the WBLR Act pending before the land authority. This court does not express any view regarding the preparation of ROR, which is the exclusively jurisdiction of the concerned revenue department. It is further pointed out that the Sullivan decree in connection with title suit number so and so was ended with an order dated 23/5/63, by which final decree was passed between the parties. The plea of the said decree was not registered in is not acceptable by virtue of section 17 of the Registration Act, which provides that a decree or the order expressed to be made on a compromise and compromising immovable property, comprising immovable property, does not require registration. Well, this is the point, Malak.
That is not the only point. Please come to internal page 12. Argument by defendant number 1. Defendant number 1, the last sentence of page 16, page 12.
Yes.
It is a submission of defendant number 1 that he has produced the deed of 71. Now, this deed of 71, defendant number 1 got his title by virtue of deed of 1971. 1971 deed was subsequent to the compromise decree. Compromise decree was of 4th of December 1962.
Yes.
Now, therefore, the 1962 Solenama decree, that was the premise of the title of defendant number 1, because his vendor got title, that share in the property which was sold to defendant number 1 by virtue of that 62 deed, Solemnama degree. The question is whether that Solemnama degree is required to be registered. If it was compulsorily required to be registered, then this right could not have flown to the vendor of the defendant number 1, and then the rest of the premise becomes bad, because then defendant number 8 would be entitled. Because if defendant number 1's predecessor. Now, Mr. Rai takes a point that if a right is created in favor of a third party in a Solemnama decree, then registration is necessary. Although if it is merely an arrangement between the parties, then may not be registrable.
That is something where I did not argue on that, because that is
the premise.
that is
the
another point
decided.
which we are waiting.
Yeah, my submission is not a.
We'll record the submission, but extend the degree. Well, you are enjoying an interim order.
Yes, there is direction subject to question. No, that the proceedings will continue, but no finality.
No injunction was granted to you.
No, my lord, your lord,
There's a
precisely my
connection-
lord is of the opinion that you have to serve notice about the opposite party for getting an order of injunction. But the application itself, my lord, will find.
Yes,
No.
we'll grant status quo in regard to the property. Whatever, whoever is in, if you are in possession, you are in possession. We'll dispose of both then. You have not served copies of Can 1 injunction.
Yes, I have served.
You have served Can 1 as well as Can 2.
Okay.
What is the stay application?
Can 2 কোথায়? Can 2?
There is no Can 2, only Can 1.
Subject to question, my lord, there is.
There is only one application.
না আরেকটা কোনো ইয়ে ছিল। One
আচ্ছা
application.
আচ্ছা।
Only injunction application. Interim order was passed at the time of direction of service of notice.
Right. Very well.
In the degree matter, that is a status order. In the
It cannot be.
Suit, in the suit. There is already a status quo order. Then
Partition suit ballot previously granted by directing parties to it is status quo.
that status quo is sufficient. So Can 1 is not necessary then.
In the meantime, both the parties are direct to maintain
Till the
status quo in respect of the nature and character of the suit possession of the suit property.
This will be redundant.
After passing of the degree, whatever this status quo.
Yes, why not? The suit remains. Status quo will
till
be
the-
disposal of the suit. Yes.
Record that
record that.
portion.
We'll record that
record that
since-
portion. my lord, that will.
Learned counsel appearing for the affidavit of service filed to be kept on record. Full stop. Although all the parties have not been served, the plaintiffs, against whom the principal relief has been sought, have been served and are represented in court today through counsel. Full stop. Next para, learned counsel for the defendants, the plaintiff stroke respondent number 1 opposes the application for injunction and contends that the learned trial judge, in the impugned preliminary degree, categorically held that the defendant number 8 stroke appellant does not have any title in the property. Full stop. Next para, it is submitted by learned counsel for the appellant that the said observation was premised on a finding that a Solemnama decree, by virtue of which the predecessor of the defendants of the plaintiff's respondents got title, was not compulsorily registrable, which according to the appellant is an erroneous proposition of law, since by virtue of the said Solemnama decree, rights were created in favor of third parties as well. Full stop. Next para. Apart from raising such arguable point, it is also contended that the defendant number 1, in whose favor title was declared, obtained a portion of the property by virtue of a deed of 1971, which took place after the 1962 Solemnama decree. Full stop. It is argued that in the event the Solemnama decree is held to not have any binding force in law, the defendant number 8 would automatically have a share in the property. Full stop. In view of such arguable questions having been raised, the appeal is required to be heard on its merits. Full stop. Accordingly, we dispose of heard on merits. Full stop. Next para. However, at this juncture, learned counsel appearing for the plaintiff stroke respondent 1 submits that there is already a subsisting status quo order in the suit. Full stop. Next para. In view of such subsisting status quo order, we are not inclined to pass any superfluous order by passing further injunction, which accordingly can 1 of 2024 is disposed of in the light of the above observations. Full stop. As observed earlier, the trial court shall continue with the final degree proceedings, but shall not draw up any final decree without leave of this court prior to disposal of the present appeal. Full stop. Next para. It is made clear that in the event for any reason, the status quo order granted by the trial court is varied or vacated, it will be open to the appellant to challenge the same in appropriate courts of law, as well as approach this court with a fresh application for injunction on such changed circumstances. For next para, the appellant shall, in view of the appearance of the respondent number 1 through counsel, further service of notice of the appeal is dispensed with on the said respondent. Full stop. However, the appellant shall put in requisites for service of notice of appeal on the other respondents. Full stop. The trial court records shall be brought by special messenger at the cost of the appellant, also to be deposited within a week from date. Full stop. The appellant shall, within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, prepare and file the requisite number of paper books. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the appeal is ready for hearing.
What an I will on that. For the respondent, I think led by Mr. Kaushik in this matter. Your Lordships directed us to file our affidavit in opposition to the stay application. It is otherwise ready, only the affirmation is pending. I'm praying for a.
Directed you long back.
On 10th December, Your Lordship.
10th December, more than 1 month back. So why not prepare till late?
Only 3 days, just the affirmation is required. Only just 3 days.
You are enjoying a stay order?
Yes, yes.
On the prayer of the respondent, the time for filing opposition is extended for a week from date. Reply, if any, shall be filed within a week thereafter. The application shall be listed in the monthly list of February 2025.
Grateful.
Maybe Razi.
Yes, Mr. Bhattacharya.
But I saw copy of the application, section 5 application.
All have been served, Mr.
No, only 6 has not it.
My client received the same only on Thursday, my lord. I have been on Saturday.
6, only 6, my lord. 6, my lord, we have not get the postal tag report.
This arises out of what suit?
So for partition, my lord.
6, what is the endorsement of the tag report?
Tag report was 6, not delivered.
Then?
Only 6.
But even then, 6 has a right. 6
Yes,
is one of the co-owners.
A suit for partition, my section 5 application.
6 was represented in the court below.
Yes.
Represented commonly with other defendants.
Only my lord, appellant did not represent, my
lord. Only different 9 only did not appear. All 1 to 8.
No, Mr. Mukhopadhyay, if the defendant number 6 appeared along with the other defendants in the.
No.
I appear
1 and 2 to 8.
2, 3, 4, 5. Defendant number 2, 3, 4, 5 by brothers and 3 sisters, my lord. I was there.
No, written statement was filed. 6 filed written statement with whom?
6, 7, and 8. 6, 7, 8 separately.
7.
6, 7 and 8 filed written statement together.
Separate.
No, let us know. The defendant number 6 filed written statement with
Just a minute. Just a minute, my lord. Yes. No. 7 and 8 filed one written statement. 3 to 6.
3 to 6 filed one common written statement.
And 1 and 2.
And 3 to 5 have been served.
And
3 to 5 have been served.
1 and 2. Myself is 2, my lord.
That is different.
Father of appellant.
3 to 5, sir.
The rest have been served.
Yes. Only 6.
Only thing, my lord, the copy of a section 5 application is incomplete. I presume, my lord, because
why?
The delay has not been categorically written over there, my lord. And
about 1 year, I have.
Paragraph 5, my lord. First time came to know dash, my lord. Nothing said it.
No.
Paragraph 5.
These are not complete, my lord.
No, you should have. Even our copy is not complete. Mr. Bhattacharya, this is not informed. You have, the date is blank. The date is blank.
But paragraph 6 I have mentioned. Paragraph 6.
How many days delay is not mentioned, my lord.
The 1 year is a prior, I have said more than 1 year.
Specifically, it is not given out.
But someone has not been served upon
So
me.
you have stated in paragraph 5 the defendant came to know for the first time
that
on
is
such
blank.
a
I
blank
have
date
also, yesterday in the night I have also
that he was the defendant.
Where
And
is
this
that
is a
blank?
separate statement. Only on such and such date.
Yes.
Para 6 says
6.
Ask
On
the-
11
to
January
apply for
2024.
apply for certified copies later, but first you
Yes.
came to know. No.
Well, but summons has not been served upon me. The father, defender
Mr.
one.
Bhattacharya, we cannot entertain this application.
Then I have to file my supplement affidavit.
But you have to serve again then.
I have to serve.
All.
You have to serve. I have to file a supplement affidavit. I have seen, my lord.
It is rightly pointed out by learned counsel appearing for respondent number
3 now.
Respondent number 3 that the averments in paragraph number 5 of the application for condonation of delay are incomplete inasmuch as the first date of knowledge of the suit of partition attributable to the appellant has been left blank in the said paragraph. Full stop. Next para. Accordingly, the appellant is directed to file a supplementary affidavit incorporating the necessary averment to the said paragraph within a week from date. Full stop. Copies thereof shall be served on the respondents, indicating that the application shall be taken up for hearing in the monthly list of February 2025, when a fresh affidavit of service shall be filed by the appellant. The affidavit of service filed today be kept on record.
I have served upon all the respondents.
I've said that.
If I have, if any advance copy is served upon me, my lord, I may be given.
Let us have copies will be served on all. Since you are appearing, you
Yes.
save some money by handing it over to.
Then, my lord, kindly let them be limited to file opposition.
But unless I file supplement affidavit with the opposition.
If supplementary is filed, I may be allowed to file opposition.
Section 5.
As you assume.
Not now.
No.
Let us see one.
As you
No.
fine, good.
This arises from partition suit.
Declaration, partition, and my lord.
Continuing cause of action.
Suit for partition, but only
cancellation of deed.
cancellation of that does not mean what I mentioned in the degree.
It's
No,
not primarily for.
it has been basically about the deed, but that is 3%.
You're injuring other people.
Oh, yes, I thought well, you're also asking me why not.
No, we asked you. Mr. Bhattacharya will consider that at the time. Because if you simplicity of partition, we could be more lenient. Anyway, we'll hear. Next matter. Yes.
Now the person is Raja Dixon matter, the copy has been served. Debit service.
All have been served.
All been served.
Plaintiff respondent has been served only.
Lordship,
Directed to
direction
serve on
was
all.
there.
This arises from partition suit.
Partition.
Partition suit. So all must, you are appearing for?
No, along with me.
Oh, along with you. Now, did you direct it to serve on all the respondents?
2 to 5. All the respondents.
And one, what about one?
One was the appear on filing caveat.
You have served on one.
Yes. Last one.
What is that receipt?
No, the caveat.
They appeared on the last occasion.
Last occasion appear.
Right. This is against a preliminary degree.
Preliminary.
So did you direct pass the usual direction that?
Your Lordship's usual direction has been given.
So we'll continue that till disposal of the appeal and you file your paper books.
Short date be given.
You are appealing for one.
One of the respondent.
Must be one. The others are represented.
One.
One and two.
That is.
1 and 2.
And I have
Only one is the plaintiff.
respondent number 2. Defendant number 1, respondent number 2, before your lordship.
Very well. Affidavit of service filed today be kept on record. Full stop. Although none appears for the plaintiff respondent number 1, comma, we find that the said plaintiff the said respondent has already been served and was represented on the last occasion. Full stop. Next para. The present appeal arises from a preliminary degree of partition. Full stop. upon considering the materials on record, comma, we find that since the first appeal involves adjudication both on questions of fact and law, comma, the appeal is required to be heard on its merits. Full stop. Accordingly, can 1 of 2024 is allowed, comma, is disposed of, comma, thereby directing the learned trial judge to continue with the final degree proceedings, but the trial court shall not draw any final decree without prior leave of this court till disposal of the appeal. Full stop. Next para, there will be no arrest to cost. Next, the appellant shall prepare and file the Asana, the appellant shall put in the requisites. All the respondents are represented, all the defendants.
We are appearing for defendant number 5 to 7.
And you are for 2. 2 and you are appearing for?
No, along with.
You are for
Along with
with you. Then you have to put in requisites. The appellant shall put in requisites for service of notice on the respondent numbers 3 to 5 within a week from date. Full stop. The trial court record shall be brought by special messenger at the cost of the appellants, also to be deposited within a week from date. Full stop. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Full stop. Liberty to the parties to mention the appeal for hearing as and when the same is ready for hearing.
Thank you. Not sufficient. Not sufficient.
Lordship, for the appellant.
I am put the respondent number.
As per your Lordship directions, I have served upon the respondent. Your Lordship, only respondent number 19, I have not got any track report, your Lordship.
When did you serve?
On December 24th.
Hand over application. What is the appeal about?
It is arising out of a suit for partition.
You are appealing for which of the respondents?
I am 1 to 11.
Also, then there 17 is
19 is only left.
on 19 is there.
The only thing is by registered deed we have got the property, my lord. The appellant has
So the defendant number, the left out defendant 19, he appeared in the court below.
Yes, your Lordship.
He appeared along with whom? He filed
With other defendants.
with other defendants. So why are you not appearing for 19 also? Let us check up from the impugned judgment whether they appear together. No, defendant 2 filed a written statement.
Who is the appellant?
Who is the appellant hearing?
They have not appeared.
They have not appeared.
They have not appeared.
They had not appeared.
They have not appeared. Ex parte against them. No, in the impugned order, my lord, page 5.
No.
Ex parte against race. 1 and 2 appear.
1 and 2 appeared, your Lordship.
1 and 2, you are
I am plaintiff appellant, plaintiff respondent before your lordship.
oh, plaintiff respondent 1 to 11.
1 to 11.
And you are 12 to 18.
And I'm
So
defending.
where since 19 in any event did not appear, will dispense with service of appeal also on them. And so that the appeal can be expedited. This is against preliminary degree of partition.
Preliminary degree of
Was there any injunction in the court below?
No, your Lordship, on the last occasion passed an order of injunction.
No. When the suit was pending, was there an injunction there?
No, your Lordship.
Now we are hearing the injunction application finally. Therefore, you have to satisfy us on that also.
In the meanwhile, once he sends some Bangla money already disbursed.
No, that will be without, because that will be subject to the result of the appeal. And the main suit is also pending because this is a preliminary degree also.
Construct the building, it is the public money back.
Oh, acha. You can file opposition to that, to this application disclosing that. Affidavit of service filed today be kept on record. Full stop. we find that only the respondent number 19 has not been served properly, although the other respondents are represented through counsel. Full stop, next para. Since respondent number 19, comma, in any event, comma, did not contest the suit in the court below, comma, further service of notice of the application on the said respondent is dispensed with. Full stop. Next para, learned counsel appearing for the different numbers, for the respondent numbers 12 to 18 submits that they have received money under a scheme floated by the government for the purpose of constructing a building on the property, which would lapse in the event the status quo order is sustained. Full stop, next para, learned counsel appearing for the respondent numbers 1 to 11 submits that there was no injunction order subsisting in the trial court during pendency of the suit at any point of time. Full stop, next para, be that as it may, comma, since an ad interim order of status quo was passed earlier, comma, let the same is continued till disposal of the application. Full stop. The respondents shall file their respective affidavits in opposition disclosing their cases within a fortnight from date. Full stop, next para. Reply, if any, shall be filed within a week thereafter. The application shall next be listed for final hearing on February 10, 2025. In your opposition, please annex all those relevant documents regarding whatever scheme so that they can also reply. Thank you.
February 10.
Number 18, I think to appear.
18 is my
led
appeal,
by
my lord.
Mr. Bhutindu Narayan Roy.
Mr.
Mr. Bhutindu Narayan Roy. My lord, I am for the respondent in this matter. Today I just received the
file it in the department.
I will file.
Otherwise, it will be misplaced here. Later on, it will be in difficult.
I will file it.
We'll give you that liberty to file in the department.
Yes, my lord. My lord.
So only one respondent. Very well. What is your
Yes,
application?
My lord, before submission, one point to be in the last order there is some mistake.
Yes.
Nobody appearing on behalf of the defendant. But in spite of that, some name of some learned advocate has been inserted in the order sheet.
Yes, Dutiman Banerjee Vishal
Yes, my
Mullik.
lord. That is the
should be
wrong.
There
That
was a
to be
direction to serve.
corrected.
There was-
Direction.
The direction to
There
serve.
was also a direction to serve.
Yes,
That's
yes.
why
You are right.
it didn't appear.
We'll start with that. In the order dated December 12, 2024, comma, appearance was erroneously recorded for the respondent, whereas, comma, as rightly pointed out by learned counsel appearing today on behalf of the respondent, comma, none had represented the defendant stroke respondent or had appeared for the said defendant on December 12, 2024. Full stop. Accordingly, let the appearance for the respondent in the order dated December 12, 2024 be deemed to stand deleted. Full stop. Next para. The application is now taken up for hearing. Yes, Mr. Mukherjee, what is the application on it? This appeal is from?
This is an application for injunction arising out of a partition suit.
Preliminary?
Dismissed.
Dismissal.
Partition suit dismissed on the score that I am unable to prove the title of my predecessor. Even though both the parties are admitting that they are brothers and the property belongs to their father.
No, but this may be a collusive suit. You have to give something in by way of.
My lord, my humble submission would be the question of title in a partition suit would not arise. Civil court would not go into that unless it becomes fundamental to the suit. That is, there is a challenge to it. And
but your title has to be declared in this.
Since the decree in partition suit in my humble submission does not bind a third party.
True.
Therefore,
did they admit your title?
They admit my title in the written statement.
The plaintiff stroke appellant has raised a fundamental question as to whether the partition suit filed by the plaintiff appellant could have been dismissed in view of the title of the plaintiff to the suit property having been admitted by the defendant, and since a decree passed in a partition suit operates in personam. Full stop, next para. The appeal is required to be heard on the said ground as well as the other grounds taken in the memorandum of appeal. Full stop. Upon being satisfied that there is a prima facie case to go for final hearing of the appeal, and that there is urgency, as well as that the balance of convenience and inconvenience and irreparable injury factors inure in favor of grant of injunction, comma, can 1 of 2024 is allowed, comma.
My lord,
Yes.
that I have submission.
What submission?
In the injunction application, the appellant made so many allegations against me. I admit there is
Will record that you are not admitting any of this.
yes, my lord. That is my submission.
Is
I am
allowed,
not
comma, thereby restraining the respondent, restraining the parties from selling, transferring, encumbering, and or creating third-party interest in
false
respect
allegations.
Lordship may also record that there was an injunction during
in
the
respect of the suit property and or disturbing the possession of each other in respect of such property till disposal of the appeal, full stop. Since no affidavits have been invited, comma, it is deemed that none of the allegations made in the injunction application are admitted by the respondent. Full stop, next para. In view of appearance of the respondent through learned advocate, comma, service of notice of the appeal on the respondent is dispensed with. The trial court records be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Puts up liberty to the parties to mention the appeal for inclusion in the list for hearing as and when the same is ready for hearing. Thank you.
My lord, lordship. Grateful.
Thank you. Next. Yes, Mr. Banerjee, how are you? You're not keeping well.
Well, I should be very kind to accommodate on that day.
No,
in fact,
yes.
I'd given Mr. Banerjee a call also, and he had indicated that your lordship in court.
He has responded to your call. Yes, Mr. Banerjee, what is that?
Hello, this is CCTV matter. Now, we were just discussing the matter that your lordship was listening to before, had such an interesting question, and then we come up with a matter like this, which CCTV in corridors.
Snooping into people's.
I know the interim order didn't get extended, but it didn't get vacated. If I can just go back to that
Nothing
order
hinges
once.
on that. We don't treat it to be vacated.
If I can
In
just
that
go
case.
back to that order once, because it sums up my case. It's a story building, boy. It's a 3-story building.
Yes.
With a courtyard in between, corridors running all along. Your lordship will visualize this High Court building only, with rooms which alternatively or maybe adjacent to each other, family members are residing. Now, admittedly, there are CCTV cameras which are placed that look into the room and cover the entire corridor. The ostensible defense is that there are artifacts and there's a large statue and all that. So we are agreeable to have CCTV cameras face the courtyard. I mean, outside to have security guards also. At every floor, if they want a security guard to protect the artifacts, they
So
can
they
do
probably are afraid of you only.
that I will only take it and run away. Possible. So they can instruct the security guards not to let me take and run away with the artifact. That also we can do.
They can deploy security guards inside also. You agree to
Keep
that?
it at the beginning of every floor, they can have one. If this is their fear, Mr. Gora had himself gone, and I think so did Mr. Mollik. No,
See the artifacts or the CCTV?
Mr. Gora must have gone to eat. Others would have just gone.
Mr. Gora eats so much.
Your lordship cannot.
Has a very good
comprehend.
metabolism then, we must say.
Unimaginably good. For our table lunches, less than 12 to 13 pieces of anything is less for him.
Mr. Gora?
Yes. And I sit and have 2 pieces of whatever I'm having, and he'll have 13 to 15. Consciously, I'm there.
You have a very good metabolism. That's supposed to be a compliment, actually. Anyway, I mean,
So he can have those. So those artifacts are not possible for someone to remove and run away. Even if I did, the security guard will catch
artifacts
me.
in the nature of what? I mean,
Yes,
trophies and all. Those heads of
statues,
animals.
yes. Heads of animals. No, heads of animals, no, the large paintings.
Human beings also. Maybe some 1 or 2.
So they can have security guards, but the CCTV cameras that
This
face
is in North Calcutta. I mean,
North Calcutta, my lord, I'm told
these
there's
are
a
the
very-
Malliks of. I mean,
which has that large
they must be
ghodi,
having the.
which chimes every hour.
Cannot be resolved between the parties.
I
These
think they
families, I
sat-
mean, they are very well-known
That this
families.
really should not have come to court either.
Yes, yes.
But Lordship, I think both of them tried,
Must
but
have.
these things like your Lordship had on the last week. Okay.
If a new generation has come in, it will be easier, Mr. Banerjee, probably. Or the new generation is creating the trouble. We don't know.
No.
Generally, when the new generation comes in, it's easier to resolve.
So, my lord, I'll take Mr. Banerjee's suggestion. He wants that both of us should sit once. This really can get settled outside
Yes,
court.
absolutely. CCTV and all, I mean, these are
Pointless to have.
Yes, yes. We can keep it 1 week after and we'll take up the injunction and
Banerjee
decide.
and I can sit once and we'll try and na location hai na bahut my.
Need to be on Thursday, my lord, subject to, of course, my lord.
Whenever you say, both of you.
My lord, we'll see it, my lord, today or tomorrow, subject to his convenience.
My
Of course.
No, your clients also have to be there. The people who are in charge of the litigations, without them, it's useless. You can resolve between yourself, but your clients won't agree. So today we are on 13th.
Next weekend, next Monday, if we can
Next
come,
Monday
lord, we can all sit and congregate and finish this.
Yes,
In the meantime, can we, my lord, subject to, of course, my lord's kind approval, maybe, my lord, put those cameras on which are, my lord, projected towards, my lord, the corridor, not corridor, my lord, the common lawn and, my
But
lord,
unless those are identified, I mean,
he can.
or Mr. Banerjee, we can do this also. We can direct an inspection in presence of both parties.
Yes.
Advocates will be the special officers.
And identify the
And
position of the
identify
CCTV
the
cameras.
CCTV cameras
Yes,
which
yes.
face the
And, my lord, we are
face
aiming-
what? The their
outside of the property.
the outside of the
property. So corridors can be safe.
That can be
Outside
done
they can
today.
have it on.
That can
We'll
be-
direct that right now.
Yes, that can
So
be
we'll
done
take up the matter within a week, and it will be left open to you to also explore possibilities of mutual
The
resolution.
settlement in the meantime.
So that inspection should be held when?
My lord, I'll indicate, my lord, why, if at all, my lord, that, my lord, situation occurs, my lord, to travel your
But
lordship's
I can
father.
sit with him, not a problem.
We'll sit.
But your lordship will appoint someone who will go and do that exercise.
In the meantime, that can be done.
Yes, outside cameras. My lord, that
Outside cameras can be identified.
Outside cameras can be identified.
And if they're shown in a diagram, which of the learned advocates can draw good pictures?
Lordship will appoint somebody from the court, some member of the bar.
Ms. Lahiri, we can appoint Ms. Lahiri.
Miss Lahiri
And
can
if you
draw.
fail in drawing good pictures, then your next matter is gone. Very well. So we'll appoint her.
The difficulty is that 1 week, the next week I am not there.
Not today, may not be today also. Yes, if you can go today, then today.
Tomorrow.
I will fix that up with them.
Yes, right. Well, the dispute between the parties revolves around the installation of certain CCTV cameras, apparently within the premises where both parties reside. Push up next para. Whereas the appellant raises privacy issues, the respondents harp on their apprehension regarding security of artifacts, valuable artifacts, which are lying in the premises. Push up next para. During arguments, a possibility of resolution has arisen to the effect that the CCTV cameras which face the entrance, face the outside of the entrance of the building may be kept operative, whereas those facing the inside would be shut down. Push up, shut down for the time being. Push up next para. Without prejudice to the rights and contention of the parties, this court is of the opinion that an inspection to identify the exact CCTV cameras which face outside the premises can be done by appointment of a special officer. Accordingly, Ms. Deblina Lahiri, a learned advocate of this court, is appointed as the special officer to hold an inspection by tomorrow upon prior notice to the learned advocates for both sides, to identify the CCTV cameras which face outside the premises as well as those which are focused towards the inside of the building. Full stop. Next para. A brief report indicating the above shall be filed by the learned special officer on the next returnable date with advance copies to the learned advocates for the parties. Full stop. The remuneration of the learned special officer is fixed at rupees. What should be?
Whatever, we'll leave it to you.
Tell us. Some.
Commensurate with her stature, my lord, of course,
Stature
and
and
the time she would
kind of litigation. After all,
50,000.
to be shared, my lord.
Yes. Remuneration is fixed at rupees 50,000 to be shared between the parties and payable before the next returnable date to the learned special officer. Full stop. The matter shall next be listed on January 20, 2025 under the same heading. Full stop. It is made clear that nothing in this order shall prevent the parties from exploring options of resolution of the main dispute between the parties in the meantime.
The interim order which expired on the 10th, if that could be
The interim order which was granted earlier stands extended till
Then
January
this outside CCTV, my lord, that will be not.
No, that they're
No,
not
no.
using.
Extended till January 31, 2025 or until further order, whichever is earlier, full stop. However, it is made clear that for the limited purpose of the inspection by the special officer, the parties will be entitled to switch on the cameras for such limited period of inspection.
The
Two
week,
more things.
starting from 20th, I'm not there in Calcutta.
Oh.
Only allow us to come back on Thursday, not
Thursday,
subject to
worship.
my lord's calendar.
You will come back on which date? Thursday means 22nd.
Thursday. Tomorrow I'm going to do.
We'll keep it. We'll keep it on Thursday then.
The lordship says that.
তাহলে very well. The returnable date যেটা করলাম সেটা তাহলে করে দিন January 16. January 16 returnable January 16, 2025 under the same heading. আর interim order যেটা বললাম বাকি যা আছে থাকে.
We have a demerit point with regard to maintainability, my lord, of the suit and the appeal.
The issue of maintainability of the suit
Also of the appeal naturally.
as well as the appeal is left open for being argued at later stages of the matter.
And my lord, may the learned special officer also inspect and ascertain, my lord, the exact, my lord, location of the installation of the CCTV cameras and the angle of the CCTV cameras. My lord, it will solve the dispute once and for all. Whether, my lord, the CCTV cameras are.
Ms. Lahiri, you indicate in your report whether those have swivels.
Okay.
Those have are 360-degree cameras or are fixed cameras.
But we are agreeable to fix it at a particular angle so that it does not peep into.
Argue that on the next date. But she'll just ascertain as it is.
Yes. Very grateful. Yes. So grateful to you.
Who? Very good.
Very great.
My lord, let the affidavit of service be kept.
Right.
And two.
All the respondents have been, you are appealing for all? Yes. Yes.
Can two is section 5, 39 days delay.
39. Yes, what do you say? In view, can 2 of 2024. In view of sufficient cause having been shown for the delay, comma, can 2 of 2024 is allowed, comma, thereby condoning the delay in preferring the appeal. To sub FAT 173 of 2024 be accordingly deemed to stand registered and admitted. To stop, no address to cost. Sub next para. About can 1 of 2024. This is against which what decree?
My lord, decree for partition and recovery of cost position.
Preliminary degree.
My lord.
So this is stay.
My lord.
We'll pass the usual order. Final degree proceedings will continue. No final degree will be drawn up.
I have a decree for recovery of khas position also that will be stayed also.
That portion
Yes,
cannot be.
that
Yes.
portion.
Yes.
Only that they do not create any other third party interest.
But there is no injunction.
Yes.
So we are not passing an injunction order at all. Only this. Since the appeal arises out of a preliminary degree of partition and also a decree of recovery of possession, comma, can 1 of 2024 is disposed of by directing the learned trial judge to continue with the final degree proceedings, but not to draw up any final degree without the leave of this court till disposal of the appeal, full stop, insofar as the eviction component of the impugned decree is concerned, comma, the operation of the same shall remain stayed till disposal of the appeal. Full stop. Next para. The appellant, in view of appearance of the respondents through their learned advocate, comma, service of notice of appeal on the respondents is dispensed with. Full stop. The trial court records be brought by special messenger at the cost of the appellants to be deposited within a week from date. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, who have liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing. You for the respondent. You for the appeal.
My lord, of the last two questions.
Yes.
Same part to remind your lordships. My lord was kind enough to give an opportunity to file a supplementary affidavit. That has all been done.
Affidavit of assets and all.
Yes. Now, for your lordship's convenience.
Reply, my lord.
You have also filed your affidavit of assets here.
I have filed
Previously.
earlier. So I replied to the affidavit of asset, my lord, and also to the supplementary affidavit of assets. In supplementary affidavit, my lord, they have enclosed their bank statement. My lord.
Oh, yes.
That, yes.
अरे कॉपी कोई है कॉपी दे
Supplementary affidavit of
my lord, for the convenience of the honorable court, I have just prepared short chart, 2 pages, 3 pages. That will help.
Mr. Banerjee, this is can 2. This is can 2.
This is my application, my lord, praying for maintenance.
কপিগুলো দিন না ওখানে দিতে হবে না দিয়ে করা যাবে
May I indicate one thing, my lord?
Yes.
It is in my reply, my lord, with regard to the affidavit of assets and supplementary affidavit assets filed by the applicant husband. But in the affidavit of asset, my lord, first, my lord, I have indicated in my reply that in paragraph number 5C, my lord, under the heading, my lord, dependent members, they have mentioned their 2 sons, my lord. So in my instructions, my lord, they are, my lord, major, and they are also, my lord, working. This is number 1, my lord. Another thing is, my lord, know it very well, my lord, well aware about that judgment, my lord, Rajneesh versus Neha, reported in, my lord, there, my lord, it has been categorically indicated that, my lord, income tax return of the person who is filing the affidavit of asset at the time of filing the application for maintenance has to be enclosed. There is no income tax return.
Another thing is that, my lord, bank statement, my lord, has to be filed for 3 years. In the instant case, they have filed for 3 months, September, October, November. So, my lord, their affidavit of asset not.
Have you got a copy of Rajneesh?
My lord, my lord.
Just cite, hand over.
Do
you have photocopies? No.
I have in my phone, man. I have another copy.
So you are not employed.
I am not employed.
And the children have been residing with the father, but they have attained majority, as you see. And they earn also. Both the children are sons.
Both the children are sons, twin sons.
Yes?
Twin sons.
Twin sons. Above 18.
Now I'm 25.
Yes, we'll hear Mr. Banerjee first, then.
Yes, I'm grateful.
We take note of your this objection.
I have another.
What is that objection? Yes.
My lord, in the lower court, my lord, in the year, my lord, 2022, the appellant husband filed his affidavit of asset, my lord. As I was earlier on the last occasion, I was indicating, my lord, that the income of the appellant husband was my lord 11 lakhs and odds, my lord. My lord, it was fallen from your lordships, my lord, whether any document pertaining to that amount was indicated on it. My lord, I have got the, my lord, affidavit of asset, my lord, which was filed by the husband, my lord.
Mr. Banerjee, you please take your seat. We'll hear the wife first, then we'll come back. That will be easier.
My lord, I have taken the photocopies from the civil revision application, my lord, they have filed, my lord. This is from their copies. I am handing up another copy to my lord.
What was the CO number?
CO number is, my lord, CO 2645 of 2024, Sudip Dotto alias Sudip Kumar Dotto versus Mitali Dotto. It is, my lord, pending, my lord. My lords are looking at the. My lords are looking at the starting from page number 79.
Yes.
Yes, my lord. My lord, kindly come to the middle of the page, my lord. Lordships will see that monthly income as mentioned at serial number 45.
Yes.
11 lakhs 85,730. It is on admission, my lord. It has been affirmed by the appellant husband in the lower. In the Malad district court. Now, my lord, kindly turn over leaf. My lord, will find at page 80, non-dependent. The sons now names are there, my lord. Non-dependent member, but in the instant case, they have been made.
Where?
Lord,
Which item number?
My lord, page number 80, my lord.
Item? Oh, acha, the first two.
My lord.
Non-dependent. All right.
Then we will kindly come to page number 83 of that bunch. My lord, we find that serial number 7, Roman 7, my lord, income tax paid, page number 83 of that copy.
Yes.
Income tax paid 11 lakhs 63,969 rupees.
Yes.
There, my lord, income tax return was filed. Here, no. Net income is also, my lord, indicated 1 crore 40 lakhs 8,824. Then, my lord, page number 85. The last serial number, my lord, gives monthly income at the left side. 11 lakhs 85,730 admitted by the appellant husband. The signature is also, my lord, there. So, my lord, they cannot, my lord, turn back and say now that the monthly income is, my lord, 3 lakhs.
Is it his case that he has retired in the meantime?
He is continuously in, my lord, service, and, my lord, he will be retiring
Later,
within 3 years.
within 3 years. Actually. Very well. So let us see.
Now, my lord, I just handed over
Yes.
the chart.
Hmm.
It was a question of how much money I'm earning. The question is how much money I'm spending. তোরা কপি দিয়েছি তো? Kindly take trouble with this chart, my lord.
Yes.
First, an analysis of affidavit of assets by the petitioner. Particulars per month, per annum, remarks. Salary, 3 lakhs. Per annum amount, 36 lakhs.
Affidavit of asset, this should be by the respondent, by the opposite party. Petitioner in the application is them.
Is my affidavit, my lord, Sudip Datta.
You have stated analysis of affidavit of assets filed by the petitioner. You are the appellant, but not the petitioner, the opposite party.
Absolutely correct.
So we'll correct this. So you are the opposite party. You are the, this is the husband's affidavit.
Yes. Husband, which is better, husband.
Yes, yes, you have noted. Yes.
So salary 3 lakhs, that will monthly bonus. Kali marked it, is very relevant. 2,70,000. Total come minor 30,76,000. Ad hoc payment based on the projected business. Kali marked it, very relevant. In X month, I may earn some few lakhs. But the next month, there's no certainty. There's no certainty. Is a bonus.
Not telling with your copy.
I have the analysis of the affidavit of asset filed by the respondent.
না না এই তো তোকে একটা দিন এই তো দুটো পেয়েছিস ঠিক আছে দেখে নে
আপনি বলছেন পিটিশনার এই কপিটা নেই স্যার
ওইটা এইটাই তো
This is it, like this.
এটাই আর এটা দুটো কি একই
First page, no.
No, these are different. So Banerjee, these are different.
এই তো নাও না উপরে ঠিক দিয়েছিস তো এবার দেখে নে তো বাবা ঠিক আছে এটাও রাখ আচ্ছা এটা লাগবে I will also got it, my lord.
We have got it already.
I'm grateful. I've also handled it. Monthly bonus, annual bonus received 80,76,000. Gross received 1,49,52,000. Then next, expenses incurred for the financial year 2023-24. Tax paid 30%. Obviously, minus more than one course per month. No question. As a per annum amount 44,35,000. Monthly expenses 6,78,649. My lord certainly can ask me, Mr. Raji, why are you spending so much money? Whatever money I borrowed for the education of my 2 sons, and God, I am liquidating the money. Not the great wife didn't pay right to the nothing. 6,78,649. Total 81,43,000, sir. Net income 1,90,555. Per annum 23 lakhs, sir. Loan liabilities, Kali marked it, minor. Banking details particulars. HDFC house loan 80 lakhs 62,784. ICCI car loans 1,80,000, sir. Student loans for my 2 twin sons. Artito Orco 14 lakhs 14,888. 20 lakhs 70,835. The petitioner is a partner of such a company. The income of the petitioner is a mix of remuneration and drawings. While the monthly salary remuneration is fixed, the drawings is completely dependent on the profit, income, and collections. Currently, monthly salary is 3 lakhs and 2,70,000 is drawings. Being a partner, there is substantial expenses that is to be incurred by the petitioner. Additionally, the petitioner has to pay 2 lakhs per month as EMI. Total closing balance as on December 1st, 2024 and November 2024 is to be 20 lakhs 30,026 in respect of 2 bank accounts of the petitioner as evidence. Then can you come to wife statement? I've handed out to losses, my lord.
No, you haven't.
Huh? কি বলছিস সব ভুলি
This is against a divorce decree obtained by you or their dismissal.
Now, what should dismiss me? I'll come to that, my lord. One matter will be taken up for hearing for here. Kindly see the assets. Analysis of the affidavit, the assets of this one. How many FGs are there? 1, 2, 3, 4, 5. FD means, yes, whatever I'll spend, that is deducted. Then what is saving? And this is additional savings. Then Other investment, more than 4,11,000 has been invested from January. Very interesting. When the case was filed, they removed that 4,11,000 to show and prove that really a meager income here amount. January 23 to April 2024 as evidence of page 65, 67 of the affidavit of assets filed by the respondent. More than 13 lakhs has been transferred to other accounts from December 4, 2023 to June 13, 2024 as evidence from page number 70 and such. The aforesaid statement go to show the respondent has made false declaration in respect of paragraph F such and such appearing in page 9 of the affidavit of assets filed by the respondent. Loan liability is nil. Average withdrawal per month is very interesting. She is claiming 1 lakh per month for maintenance, everything. But how much money she is withdrawing? 10,000 not per month. So where from she is getting the other money? She is not doing anything. That reflects that is actually the requirement. From January 21st, 24 to September 24. The total medical expense of the year 2024 is 65,000 expenses for the year. Kali marked in minor. 65,686 approximately. Whereas in paragraph 8 answer, the annexures of the affidavit of assets filed by the respondent, she has stated that her monthly medical expenses is 58,000. Balance, as on said, 14,20,000 as evidence.
Where do you get this total medical expenses for the year 2024 is 65,000? It's disclosed in the affidavit of assets?
Yes. Yes.
All right.
Now, my lord, question is this, my lord. I am saying something, he is saying false. He is saying something, I am saying false. So obviously, my lord, each of us are blaming to other sides. Question is this, my lord. I didn't get any degree for divorce. So still I have seized my wife. I've got some obligations. I cannot deny that. That's why. And on the last occasion, my lord put me very rightly poor questions. What about the son? All along they are with me. And dependable as has been defined, not only financial, how much loan I've taken for them. And still I'm paying. I can ask my son, go and pay your loan, refund your loan. I'm a father. Now, my lord.
Why can't you ask them?
Huh?
In all foreign countries, that is done. The student loan is repaid by the student.
My lord.
That's the meaning of student loan.
No, my lord.
When you go to work, you repay the money.
My lord, question is my lord.
That's our perception, but that perceptions, they are not your dependents anymore.
My lord, what I'm on, my
In
lord.
law, they are not your
Maybe it is loosely used, maybe. But he thought that, well, they are not married. Still, they are with me, number one.
But because they are males, they don't have that advantage of unmarried girls. If they were an unmarried girl, they would have been your dependent.
Now, one thing.
But since they're male, Mr. Banerjee, they're unmarried or married or they're majored, they're not your dependent.
One thing very clear, my lord.
For
I
themselves.
never said that well. Because I'm maintaining them, I have to spend. I said.
You're showing their deductions, their loan, student loan.
Only loans, nothing more. Loans.
That's on their account.
I agree to
For them.
That's true, but at the same time, I being the responsible father of the Indian culture, my lord, I must say my offspring should not suffer.
Indian culture also says that the wife should not suffer.
That's why I say, my lord.
Be a responsible husband also. You're earning 11 lakh. Now it has
This
come
totally
down
wrong, my lord.
Your own statement in the
I'll
court.
clarify. That is for 1 month, and
You
that
are
is
a cost and management accountant, Mr. Banerjee. Your income in the trial court was 11 lakh 85,000 per month. It has decreased to 3 lakh.
No,
Is it credible?
No, not 3 lakhs. 6 lakhs and not.
And bonus.
3 lakhs and 3 lakhs. Down to 6 lakhs.
5 lakhs something.
Then down to 6 lakhs.
It has been reduced to half. You are becoming more experienced.
Because of this, that it is not fixed like salary. It is depends on certain factor. Maybe in 1 month.
Close monthly income was 11 lakh 85,000.
Maybe in 1 month or 2 months that was one. But that is not regular. Can you see, my lord? If
monthly
I say
income,
something,
you disclose monthly income. You did not say you did not qualify it as 1 month's monthly.
No. Question is, my lord.
Your monthly income was 11 lakh 85,730 per month.
Yes.
That was when? This was
in the year 2000 and
even if you have annexed in the year 2024 in your revisional application. So till 2024, this last year only it was 11 lakh 85.
One aspect, my
now
lord.
it has become 5 lakh.
No, my lord. No, 6 lakhs. But even if it is so, my lord, is the how much they require? That is a very vital aspect. I cannot be. She cannot use this. Well, I am a non-working lady. I am helpless. Unless, but how much she require? That's very vital aspect.
No, she has to have commensurate status with you also. You earn 11 lakh something per month.
But is-
Rule of thumb is 1/3 to 1/5.
My lord, she is staying alone with,
So what?
with her sister. And is there any allegations that, well, he's actually the same status? I'm not going to on controversy. In the trial court, I say very well, I'll pay. And my mother is also there. I'm maintaining her. And
They have asked for 1 lakh maintenance here.
yes,
They should have asked for 3 lakh. That would be Mr. Banerjee 1/4.
Lord, kindly see,
Yes, 1/4. Even less than 1/3 we are saying.
kindly appreciate one aspect, my
You
lord.
earn 11 lakh something.
My lord, no, that is regular, not
You have
regular.
suppressed your income.
That is not regular. I can assure losses, my lord.
Cannot qualify your
This is
statement.
not regular. I have stated an oath. Let them deny. I will face the consequence. Then 340 I will not really come.
Then you will be guilty of 340 before the revisional court.
My lord, let him file that. I'll clarify that.
We
But
cannot
here,
go on
kindly
technicality.
appreciate
It's your
my-
own statement in the same year.
Well,
Last year only. No.
kindly appreciate one aspect.
What
my-
change has occurred? Your designation has been, you have been demoted from
No,
the
no, no, no.
designation.
It all depends. My lord, it is actually depends upon the company's position and status and business. Business. I've stated on oath this statement.
You have stated that also on oath. 11,85,000.
That is why I say that is total.
One must be a lie then.
No, that is why my lord says subsequently, kindly appreciate. I could have understood that well. That is a standing, my lord, or regular income. No.
You have not
Salary is
qualified this in your divisional application is still pending. There, this the averment is still there.
pending at your. No, dispose of.
When? Show us the order. Show us the order.
Pending.
Show us the order.
No, pending.
So very convenient for your learned junior.
Pending. The question is this, my lord, how much they require, that is very vital aspect. That is very rational approach.
No, how much you earn is also important.
No, I'm not denying.
It has to be
At the same
commensurate with
time,
your earning.
if it is compared, so but I'm concerned right from the beginning, I'm maintaining two twin sons.
Even if it's 5 lakhs something, Mr. Banerjee, they're claiming only 1/5. 1/5 has to be allowed. 1/5 is a bare minimum which is allowed since long time back. Mr. Banerjee, you know 1/5 to 1/3 is the thumb rule. Nowadays courts are leaning towards 1/3, but we take a lenient
No,
view.
the net income is not like that. My salary, my bonus, amount that. After that is deducted. Kindly appreciate.
Have you shown the bonus of the last 2-3 years?
Here.
You have said that your monthly bonus is 2,73,000.
Yes.
And that varies from month to month.
Month.
Let us see the last 3 years bonus.
I can
Have you
highlight.
disclosed? No, we won't grant you further time. Show us that you have disclosed. You say it varies. It may increase also then.
Of course, I cannot deny.
Then you are showing only
unfortunately,
1
not
month.
been increased.
This is only 1 month you are saying, and you say it varies. If you say it varies, Mr. Banerjee, you have to show how it varies.
Absolutely correct. Well, one
If
thing
you
is
have
very-
not shown, then we take
No,
you
my lord,
take
one
it
thing
as
is
your
very
income.
clear, my lord. Kindly appreciate one aspect.
You have suppressed, Mr.
No. That I just.
Palpably
My lord, when the record is there, the question will be suppression.
Yes, the record is there in the CO also.
Yes,
11 lakhs
then no question of suppression. Had it been any malintention, I would not have disclosed this fact because it was not possible for them to know that.
You are saying in the same breath that you earn 11 lakh, that revision is pending. And in the same breath, you are also saying you earn only rupees 3 lakh and bonus of 2,73,000, which varies monthly, which comes to half of that amount.
That's
One
true.
must be correct, two cannot be correct together.
That's true, but today
You
what
choose
I've
which is correct. You are choosing this, we choose that.
no, today what I have stated, that is correct. Because that will appear from the record itself. I can assure losses, my lord. That is correct. Because he cannot take the risk. Having a responsible man, having 2 sons and his old mother, he cannot take the risk. So that's why can't he consider this aspect, my lord? The way he asking, my lord, he has said this is my claim. Claim, there's a basis of that claim. That I have also explained, my lord. Kindly see. And my monthly withdrawal 10,000, that's 11,000. Then from the bank, how much money is actually in hand? And to show the court that I am very poor, within such a short time, the huge amount is.
Mr. Banerjee, she is cutting corners because she doesn't have the money. She may have a requirement, more requirement. If she doesn't have the money, what does she take from? She has to
Absolutely
withdraw
correct.
from whatever she has.
But once he says she requires more money,
Yes.
for what purpose you are asking for money? I can appreciate. She may, but from his own record and document, it appears.
You are earning 11 lakh per month.
Why
1
not?
lakh
No,
for
this
your
is
wife
not
is
correct.
meager. Even if it's 5 lakh, 1 lakh is meager. 1/5 of that.
Kindly appreciate.
They are 1/5 of that.
Kindly appreciate, my lord.
We go by your statement. If it's 5 lakh, More than 5 lakh, actually almost 6 lakh. So pay her 1 lakh out of that. It is nothing.
My lord, it is really something. Kindly appreciate total income is like that. After that expenditure, how much kindly take trouble?
You have taken HDFC loan for house loan, car loan. You know, Mr. Banerjee, very well that these are not to be deducted. These are not compulsory deductions. Your choice, you took house loan, car loan. Nobody compelled you to. So these are not compulsory mandatory net deductions. Definitely not. Student loan of Oritra and Orco. Yes, but they are no longer your dependents. They have to repay their own loans as per law.
Your Honor, kindly appreciate, my lord, when the loan
And you
was
cannot
taken.
use these as a premium to
No, I'm
deprive your
paying
wife.
for that. I'm paying.
Your wife is your dependent. Your sons are not.
Malu's perfectly my dependent. I'll socialist. He'll depend. She'll dependent so long she'll with me. After he after
You cannot blackmail her for that.
my lord, the way my lord she has done.
You have filed a divorce suit. She wants to go back to you. Take her back.
Compelled. She left the house long back, leaving their two sons.
Mr. Banerjee, you not press your appeal and let her go back. You have preferred the appeal against the dismissal of your divorce decree, and you are saying she's not coming back. I'm not.
No, I'm not saying coming back. I'm saying she was never been there. She never took any care of her two sons. All along I did it. I also
She's
sacrificed
entitled
my
to
lord.
alimony, Mr. Banerjee. Unfortunately for you, she's entitled to alimony even then.
My lord, 1 lakh is too much.
1 lakh. When, as per your disclosed income, 5 lakh.
My lord, kindly
take it to your disposed
no, my
income.
lord, kindly come to 1 second my statement, my lord.
Yes, Mr. Banerjee. Let us come to that.
The petitioner is a partner as such. While the monthly salary remuneration is fixed, the drawing is completely dependent on the profit, income, and collection. Current monthly salary is 3 lakhs and 2,70,000 is drawings. Being a partner of the substantial expenses, 2 lakhs. Total closing balance as on such and such is 23 lakh 83,000 in respect of such and such. And this is actually total income out of the expenditure. So if it is divided 12, my lord, it comes to how much? I have got no pension. Within 2.5 years, I'll retire. But still, I'll have to continue the pay. I'll have to pay the money.
Yes, Mr. Banerjee.
My wife will not pay anything. I can't expect. So kindly do at least some. I agreed to pay 50,000. I agreed to pay. I agreed to pay 50,000.
Let us pass on. Yes, sir. The present application bearing Can 2 of 2020, Mr. Banerjee, please take your seat. Bearing Can 2 of 2024 has been filed by the respondent wife in the appeal, claiming alimony to the tune of rupees 1 lakh per month. Push up next para. Learned counsel appearing for the appellant for the respondent wife contends that in a civil divisional application which is still pending, comma, at the behest of the appellant husband, comma, the husband annexed personal information on the basis of affidavit of assets filed in the trial court, wherefrom the husband is seen to have admitted his monthly income to be rupees 11,85,730. Pushed up next para. The income tax paid as disclosed therein, comma, is rupees 11,63,969, and the net income has been shown by the husband yearly to be rupees 1,40,08,824. Pushed up next para. The said statements have been reiterated throughout the said affidavit, and in the final analysis, comma, the total income has been shown by the husband in such affidavit to be rupees 11,85,730, comma, in consonance with the personal information disclosed at serial number 45. Push up next para. Thus, comma, the income, the monthly income now pleaded by the husband, comma, which is to the tune of rupees 3 lakh per month with variable monthly bonus of rupees 2,73,000, comma, is a gross suppression of the actual facts of the income of the husband. Who's up next para? It is next contended by learned counsel for the respondent wife that in the self-stem affidavit in the of the husband in the trial court, comma, annexed to his divisional application, which is still pending, comma, both the sons of the parties have been comma, who have been residing with the appellant husband, comma, are shown to be non-dependents of the husband. Full stop. In fact, comma, both the said sons, within bracket twins, bracket close, having attained majority since long, comma, cannot be termed as dependents of the husband anymore. Full stop. Next para. Learned Counsel next argues that the propositions laid down in Rajneesh versus Neha and another, reported at 2021 2 SCC 324, comma, by the Supreme Court, comma, have not been adhered to in the present case, inasmuch as the appellant husband, comma, in his affidavit of asset, comma, has failed to disclose his income tax returns for the relevant period. Moreover, comma, bank statements have been disclosed only for 3 months instead of the 3 years as indicated in the said judgment of the Supreme Court. Full stop. Next para. That apart, comma, it is argued that the respondent wife has substantiated her requirements from the averments made in her application and her other pleadings, and having no independent income of her own, comma, is entitled to alimony of at least rupees 1 lakh per month as claimed. Next para. Learned Senior Counsel appearing for the appellant husband, comma, while opposing the application, comma, points out that the monthly salary of the husband, comma, as disclosed in the affidavit of asset filed in the present appeal, is rupees 3 lakh with monthly bonus of rupees 2,73,000, which is ad hoc payment based on projected business of the company where the appellant husband works. Full stop. Thus, comma, such monthly bonus is a fluctuating figure and cannot be a reasonable basis of ascertaining the monthly income of the husband. Full stop. Next para. Learned Senior Counsel next contends that the appellant husband has several loan liabilities, including an HDFC Bank loan, which is a house loan to the tune of rupees 80,62,784, and a car loan with the ICICI Bank to the tune of rupees 1,85,544. Full stop. Next para. That apart, comma, the student loans of the 2 sons of the appellant also have to be serviced by the appellant, which are respectively to the tune of rupees 14,808 and 20,17,835. Push up. Next para. Learned Senior Counsel for the husband also contends that the petitioner, comma, as a partner of Ernst, ERNST, Commercial and Young, LLP, comma, has substantial expenses to be incurred. First up, also, comma, the husband has to pay rupees 2 lakh per month as EMI. Full stop. Next para. Next, focusing on the averments of the respondent wife stroke petitioner, comma, Learned Senior Counsel for the husband argues that the wife admittedly draws a monthly amount to the tune of rupees 10,909 from January 21, 2024 to November 2, 2024. Full stop. Next para. Moreover, comma, the total medical expenses for the wife for the year 2024 has been disclosed to be rupees 65,686 approximately. Full stop. However, comma, despite the same, comma, she has stated that her monthly medical expenses is rupees 55,000, comma, which is thus not credible. Full stop. It is argued that if the average withdrawal per month of the wife is rupees 10,909 for a period of 11 months between January and November 2024, comma, it is not understandable as to how and for what expenses she requires the huge amount of alimony to the tune of rupees 1 lakh per month. Full stop. Next para. Upon careful consideration of the materials on record, comma, we find that the appellant husband himself has admitted in his affidavit of assets filed before the trial court, comma, which is a part of the annexures of the pending revisional application filed by the husband before this court, comma, that his monthly income is rupees 11,85,730. Full stop. Next para. Till date, comma, there is no modification to the same. Full stop. Next para. The husband admittedly is a cost and management accountant working in a reputed firm as disclosed by himself. Full stop. Next para. Hence, comma, it is not understandable as to how, comma, with the lapse of time, comma, the income, the monthly income of the husband gets reduced from rupees 11,85,730 to rupees 3 lakh, along with monthly bonus of rupees 2,73,000 per month. Pushed up. Next para. Moreover, comma, the husband, comma, although arguing that a major part of the monthly income comes from monthly bonus, which is the fluctuating amount, comma, has utterly failed to disclose the monthly bonus earned by the husband at least over the last few years for the court to come to a conclusion as to the average monthly bonus actually earned by the husband. Pushed up. Next para. A professional of the stature and qualification of the appellant husband, comma, in the present case, comma, a cost and management accountant, comma, cannot go down with time unless there is some specific and categorically disclosed reason for the same. Push up. Next para. Thus, comma, the plea now taken by the husband to the effect that his monthly salary is rupees 3 lakh and monthly bonus rupees 2,73,000 as opposed to rupees 11,85,730, as disclosed in his affidavit in the trial court, comma, is not credible and is hereby disbelieved. Push up. Next para. Insofar as the alimony is concerned, comma, it is a rule of thumb that the monthly alimony granted to the wife is between 1/5 and 1/3 of the monthly salary of the husband. Full stop. In the present case, comma, if we go by the monthly income disclosed by the husband himself, comma, the amount claimed by the wife is even less than 1/5 of such salary. Full stop. Next para. The question is not what are the actual daily requirements of the wife, but as to what is the perceived requirement of the wife, comma, taking into account not only her daily bread and butter, but her other necessities commensurate with the status of both spouses. Full stop. Even if the status of the husband and his professional qualification is taken into consideration, comma, monthly alimony of rupees 1 lakh is a meager nothing. Full stop. Next para. Moreover, comma, there is no logic behind the argument that since the wife at present draws an amount of rupees 10,909 at least between January and November 2024 per month, comma, her requirements are restricted to such amount. Full stop. In view of meager financial means, comma, a person may very well be restricted to limited drawings from her confined resources. Full stop. However, comma, that does not necessarily means that her necessities, comma, in particular commensurate with her husband, comma, is required to be restricted to that amount. Full stop. Next para. Hence, comma, upon a perusal of all the materials on record and taking into account the contentions of the parties, comma, we are of the opinion that the husband has an income of rupees 11,85,730 per month, which even if it is taken that his income, comma, including salary and bonus, comes to the tune of rupees 5,73,000, comma, the alimony of rupees 1 lakh per month is less than 1/5 of the same. Push up. Next para. As to the payments made for the student loan of the sons of the husband, comma, since both the sons have attained majority long back, it is their incumbent duty to repay their student loans, as is the purpose and premise of the principle behind student loans. Full stop. Next para. Hence, the husband cannot take shelter under the student loans payable by his major sons to deprive the wife of her legitimate alimony. Full stop. Next para. In such view of the matter, can 2 of 2024 is disposed of on contest, thereby directing the appellant stroke opposite party husband to pay alimony to the tune of rupees 1 lakh per month to the respondent stroke petitioner stroke wife, payable within the 10th of each month, full stop. The first of such payments shall commence from the month of February 2025, which will be payable by February 10, 2025, and thereafter by the 10th of each of the succeeding months. Full stop. When did you file this application? September 20. The arrear alimony for the months of September 2024 till January 2025 shall be paid by 2 equal monthly installments, the first of which shall be paid by January 31, 2025, and the next by February 28, 2025. Full stop. Any other application is pending, Mr.
No.
You are the appellant, so are the paper books ready? Otherwise, no.
Yes, as I'm ready to that. Yes, yes, ready.
It's out with one information.
Paper books.
Yes.
So we can direct the appeal to be listed in the monthly list.
Mine, let it be decided once for all.
Push up next para. Since it is submitted by learned counsel for the parties that the appeal is otherwise ready for hearing, let the same be listed in the monthly list of February 2025. Grateful. Thank you.
Thank you.
Thank you. বইটা ফেরত হবে,
পাঁচ লাখ ধরলে এক লাখ করতে
চাইলে আরো বেশি চাইনি কি করা যায়
লাখ করেছে
না 11-12 লাখ টাকা আছে
Item number 22. Time for the appellant.
Yes.
Can to is my application for condonation of delay in preferring of the appeal. There is delay of 107 days, my lord. 107 days.
107 days.
107 days, my lord.
What is the reason?
My lord, the appellant, my lord, handed over the brief to the learned advocate.
Come closer to the microphone.
Appellant handed over the brief to the one of the learned advocate who is appearing in practicing in the junior lower court. He could not prepare the appeal within time, and that's why, my lord, thereafter brief has been taken from that advocate and handed over to another advocate.
But if you cast an aspersion against an advocate, you should have a copy of the application on him. We would like to hear him also. He is unheard. Have you named the advocate?
Yes, my lord. I have.
Then you should have serve a copy of him. Unless you serve a copy on it. Whenever advocates allegations are cast against advocates,
So what
our practice is to give a copy to them. They have to come and defend themselves.
my lord, copy was given. My
If the same advocate was retained, we wouldn't have anything to say. But you are casting an allegation against an advocate who is not there before us.
My lord, she is advocate on record in the lower court. My lord, who could not prepare, my lord, at all. Within
No,
time.
she has to come and say to us. Since allegations have been cast in the application under Section 5 of the Limitation Act bearing Can 2 of 2024 against the learned advocate appearing for the petitioner in the court below, let a copy of this application be served on the said learned advocate and a receipt in that regard be filed on the next returnable date, full stop. In a covering letter to such service, the appellant stroke petitioner shall indicate that the application shall be listed on February 10, 2025 under the same heading. Please come back with that.
Before that, I could serve the copy of the learned advocate who is.
Oh, you have not yet served on them?
No. I have served to them. The learned advocate who could not prepare, my lord. I can serve, my lord, to her.
We'll keep it before that.
Yes, my lord, because
আচ্ছা তাহলে returnable
execution is pending.
returnable টা ডেটটা February 10 না করে today on 13. So can you come back next Monday?
Next Monday, my lord.
We'll keep it next. তাহলে ওই we'll list it on February 20, 2025. Next Monday. Sorry, January. Thank you. January 20, 2025. Yes.
My appeal.
Yes.
For parental liberty granted, we have prepared and supplementary affidavit. In connection with the Section 5 application, the supplementary affidavit. An ex parte decree is under challenge.
What is the delay?
The delay of 51 days.
Supplementary affidavit, why?
Because in the section for condonation application, I've averred that I came to know of the ex parte decree by a postal article sent by the learned advocate for the husband. That postal article is annexed in the supplementary.
Have you given a copy to them?
Yes, my lord.
Right now? Previously? You got it previously?
Oh, my lord. Condonation application served, but the supplementary is served.
Yes, what did you say? This is your communication only. I mean, your clients, your advocate. 51 days delay. Yes. What do you say? We'll allow this condonation application. The application for condonation of delay has been filed on the premise that it was an ex parte degree office. That the appellant came to know of the ex parte degree against which the present appeal has been preferred only subsequently on a communication being made at the behest of the respondent husband. Full stop. The supplementary affidavit filed today be kept on record. Full stop. Upon hearing learned counsel for the parties, we find that sufficient cause for the delay has been disclosed. Accordingly, Can 1 of 2024 is allowed on contest, thereby condoning the delay in preferring FAT 377 of 2024. Full stop. The appeal is deemed to stand registered and admitted accordingly. Full stop. Since we have invited no affidavits in the matter, it is deemed that none of the allegations made in the application are admitted by the respondent. Yes. A divorce degree obtained.
No, my lord, restitution.
Restitution. Restitution, unless it is stayed, I mean, what will remain in the appeal?
Order has already been passed finally.
What is your ground in the appeal?
The ground is, my lord, what happened, my lord, when the suit of restitution was filed, it was filed in the court of learned court in Paschim Mendipur. My lord, we have filed an application under section 24 because we were living, my lord, in other places where for the inconvenience caused, my lord, we could not reach to the court. Now, my lord, section 24 was allowed contest upon contest. And my lord, there were other proceedings under 498A, my lord, and Domestic Violence Act. And this court in civil revisional application directed the matter to be transferred before the my lord, Barakpur court. Now, my lord, additional district judge Barakpur. Now, additional district judge received the order from the Honorable High Court and my lord, placed it before the my lord, concerned court, which passed the ex parte decree. Now, my lord, when it was placed, my lord, no notice was served upon me. So, my lord, after it was placed, it went on ex parte. But when it was in Paschim Mendipur, we entered appearance. So, my lord, one ground is, my lord, no notice was served upon me. My lord, I could not know, my lord, of the proceedings in the transferee court. My lord, this is one of the ground. And, my lord, the order itself, my lord, will find, I would satisfy, my lord, that the order itself is unreasoned in the sense, my lord, examination is taken on oath of the husband. Court says there is no, my lord, contradiction to the, since it is ex parte.
That only.
That allowed.
Case will run stay. The present appeal, it has to can 2. Stay the restriction হয়ে গেলে ফিরে গেলেন।
Involved is very short. If your lordship to fix a date for
Hearing.
all the papers are there. Informal paper.
We'll direct you to file informal paper books. Do that. File informal paper so that it is not in their hands to delay. So you'll file the informal paper books. Trial court records you put in special messenger immediately.
I have annexed the entire certified copy because my point is non.
Without trial court records, it can be done.
Yes.
Because there is no your evidence only, no cross examination, nothing. Exactly, your evidence only. So there is very well. We'll do that. The Can 2 of 2024 has been filed for stay of operation of the impugned decree of restitution of conjugal rights. Full stop. We find that certain arguable questions have been raised by the wife stroke appellant inter alia to the effect that the suit could not have proceeded ex parte without prior notice of the transferee court after a transfer being directed under section 24 of the Code of Civil Procedure, comma, to the appellant wife. First up, next para, the appeal will be heard on all the grounds taken in the memorandum of appeal. First up, next para, accordingly, can 2 of 2024 is allowed on contest, thereby granting stay of operation of the impugned degree till disposal of the appeal. First up, next para, there will be no orders to cost. Next, at this juncture, learned counsel for both the parties submit that the relevant documents are all a part of the memorandum and the application connected applications in the appeal. Pushed up, since the parties are also equipped with certified copies of all relevant documents and or photocopies thereof, comma, it is submitted that the appeal may be heard out expeditiously without calling for the trial court records. Push up next para, in view of the above submissions and since the appeal, comma, being a matrimonial litigation having implicit urgency, comma, we are of the opinion that the trial court records need not be called for. Full stop. Next para. Accordingly, comma, in view of appearance of the respondent through his learned advocate, comma, service of notice of the appeal is dispensed with. Full stop. Since the trial court records are also dispensed with, comma, the respondent is directed to file the requisite number, prepare and file the requisite number of informal paper books without comparing with the records within a fortnight from date and serve advance copy of the same on the learned advocate for the appellant. Full stop. Next para. Upon such filing of paper books, comma, the appeal is treated to be otherwise ready as regards hearing. Full stop. The appeal shall be listed for hearing in the monthly list of February 2025.
Instruction from my client, if he acceded for remanding back the appeal, may I upon notice can.
No, even if you accede to that, we have to pass a formal judgment because if appellant does not press the appeal, we can do it as a matter of course on your asking. But even if you concede, we cannot set aside a judgment and send it on remand, even if you concede. But probably in this case, that will be the fate of this. Very well. If you have instruction, you can mention before us. We can put it as to be mentioned and do it within. Yes, we'll record your consent as well as pass an order on merits also.
Okay.
Fair enough. Good approach. Very good. Very fair approach. This is what it should be. Right.
The affidavit of service may be kept.
Pratham line affidavit of service filed. Great. Thank you. I'm not 24.
Yes, it's my appeal. If you're there was a direction for filing of paper books on 12th December by your lordships, Lord. The paper books are ready. An advance copy, I understand.
Yes, I have received. I've received and I'm ready in that.
These are the two.
Orders are.
My lord, this is
Mr. Rai is appearing for whom?
Lord, he is with me.
Oh,
but I'm being led by my learned senior Mr. Mukherjee.
Yes.
My lord, the brief conspicuous of the facts of the matter is this is an order.
Paper book gulo কি করছেন বসে বসে একটা আমার প্রবলেম
My lord, suit for partition.
If this was I mean we knew this, we would not have directed appeal to
My lord,
the
all the papers were there in the stay application, your lordship said.
On the ground of limitation.
Yes.
The point is very short.
In a partition
Now,
suit.
whether the limitation can be imbibed from the plaint or not. Lord, I'll be
Naturally, you are the defendant. Yes.
Right. My lord, suit for partition of certain properties, Order 7, Rule 11 filed, as has been pointed out by my learned senior. And the Order 7, Rule 11 decree passed dismissing the suit on the prima facie point of limitation. My lords, the point of limitation culls out from a simple one document which has been referred to in the plaint, which is a 1997 deed of family settlement of the mother-in-law of the original plaintiff. On the basis of that 1997 deed of settlement registered document, which has been pleaded in paragraph 15 of the plaint, on that the learned trial judge comes to a conclusion that the suit having been filed in the year 2010 or 11, 2011, is now a suit which is hopelessly barred by the laws of limitation. And on the basis of the 5 paragraphs of the plaint, which has been considered by the learned trial judge, the suit was dismissed.
Did you also ask for any declaration regarding any deed?
No, no
Only partition?
declaration, no declaration for cancellation of that family settlement. Well,
You
just
have asked for
to be-
cancellation?
No, I have not asked for cancellation.
Nothing regarding that sort?
No cancellation.
Nothing
for-
regarding any document?
No. There was
You
only
rely on
suit-
those documents and you ask for partition?
I rely on, no, I say that that document I was not aware. The plaintiff, the original plaintiff was not aware of that family settlement. And it is only in 2010 when my husband, who is entitled to a share, I'm claiming through my husband, in my mother-in-law's property. And the deed of family settlement was executed by the mother-in-law in favor of one of his 2 sons.
Mother was the original owner, exclusive.
Mother was, my lord, it
Part owner.
comes from, no, she was a part owner. If, my lord, 2 minutes of
This
facts.
is Mitakshar. No.
No,
This is Dayabhag.
Dayabhag.
Dayabhag, she has become Chamari.
Yes. So, my lord, just briefly stating the facts so that the ownership, the title devolution, how it comes to the mother is clarified. My lord, one Annakali Devi was the sole owner.
Have you got
of
anything on paper?
My lord, I have not prepared.
Annakali then?
Annakali Devi was the sole owner, my lord, of 27 kathas on Hillcart Road in Darjeeling, my lord. Thereafter, one K.N. Chatterjee, who was the son of Annakali Devi, he got, as by way of gift, 11 katha property out of the 27 kathas.
Demarcated 11 kata.
Demarcated 11 kathas. Now, from K.N. Chatterjee, the entire title devolution flows, my lord. K.N. Chatterjee.
Up to that, Mr. Mukherjee, there is no difficulty. Up to K.N. Chatterjee.
The entire difficulty, my lord, I'll just cut short
Yes,
the
yes.
matter so that
Yes,
my
yes,
learned
yes,
friend can
yes.
answer. I'll
Yes,
not,
yes.
blood, just
No, understood, understood.
Their contention is blood that the property is blood, that is the subject matter of partition, is blood the schedule B and C. Schedule B and C is the subject matter of a family settlement executed by the mother in favor of my client, the son. It is a registered 1997 partition blood, a settlement deed. Suit was filed in blood 2010 after the demise of my brother. The point was taken blood about that if they set up an invalidity of the deed, they have to do it within the period of 3 years. They are having not done so, but the partition suit consequent upon blood the declaration of the deed is an invalid. That
They have
is not
sought
the-
for a declaration regarding that deed? No.
Blood, that is your lordship will kindly come to.
But unless if that deed is there, there cannot be any further partition.
That's right. And because there was a previous partition.
So they have to avoid that deed.
Yes, because there is a contention in the plaint about the previous partition. Degree for partition of the suit property in preliminary form declaring that the plaintiffs are jointly entitled to 50% share of the suit premises. And blood degree declaring that the defendant never acquired any right title interest in the entire suit premises on the basis of the deed of family settlement dated 24th December 1997.
Somebody that family settlement was executed by the mother. The mother had exclusive right regarding that portion
By
of
virtue of the partition. That is a registered deed of partition.
that by virtue of that settlement itself.
Yes.
But she had other co-owners.
No. In respect of whatever the property that devolved upon the mother, mother settled in favor of blood my client, the defendant. And that is not they are setting up a plea of invalidity by not challenging that particular deed.
Yeah, the other brother.
Yes.
His wife.
Years of other brother. During the lifetime of the brother.
No, understood. Yes.
Yeah.
She's the wife and the other. Yes.
The brother died in 2010.
Very
The widow and the daughters, they challenged in 2010.
Very well. So
Proper deed of the year 1997.
if
So
the
that
deed
is
stands, very. What about knowledge of the deed?
But that is not stated anywhere in the plaint, subject to what my learned friend says.
Mr. Mukherjee, if the knowledge is not stated, can it be done at
But
the
I will
reception?
rely on the judgment.
And my lord,
One judgment, let my learned friend
So we have almost wrapped up after recess. Just
I shall rely on one judgment passed in December 2024 by the Honorable Supreme Court on knowledge of a registered.
give us the paragraph of
Yes.
the plaint and then cite the judgment.
Absolutely.
So we'll continue after recess. Thank you. Yes.
Without wasting much time, I shall take your lordship straight to the plain.
Right.
Before your lordships see the plain, just one statement. It's with regards to an Order 7, Rule 11. In an Order 7, Rule 11, your lordships are well aware, my lords, it is only the averments made in the plaint which has to be gone into. And unless the plaint on the face of it shows that the cause of action pleaded in the plaint is hopelessly barred by the laws of limitation, the limitation being a mixed question of law and fact has to be adjudicated at the time of trial. Lord, so my threshold to prove that this plaint is not hopelessly barred by limitation is much lower than my learned senior's threshold to prove that the reading of the plaint in its entirety shows that this cause of action is hopelessly barred. Lord, in light of this, Lords, if your lordship straight away takes the plaint, which is the first annexure in the paper book, and your lordships comes to page 4, paragraph 12 onwards. 9 paragraphs of the plaint I shall trouble your lordships with. May I place?
Yes.
That Dr. Kiran Chatterjee owned and possessed certain other properties, including Ramapada Bhavan at Hilkart Road, Siliguri, and by virtue of deed of partition of 1993, executed on 8 July 1993 by and between Shefali Chatterjee, Deepak Kumar Chatterjee, and Vidyapati Chatterjee, and registered in the office of the sub-registrar at Siliguri, all the properties of Dr. K.N. Chatterjee, including the said Ramapada Bhavan and the ground floor of Gayaram building, were partitioned amongst the said Shefali Chatterjee, Deepak Kumar Chatterjee, Vidyapati Chatterjee. But just for context, I pause here for a moment. Shefali Chatterjee is the wife.
You are claiming through whom?
I am claiming through Deepak Kumar Chatterjee. We are the heirs of Deepak Kumar Chatterjee, the younger son. But now paragraph 13, that by virtue of the said deed of partition being such and such, SM Shefali Chatterjee was inter alia allotted one room in the ground floor of said Ramapada Bhavan, tenanted to Silver Arts, mentioned in Schedule B hereunder written, 2 premises rooms in the ground floor of the said Gayaram building, of which one tenant, Messrs. Roy and Sons, and the other tenanted to Sardar Nihal Singh, more fully mentioned in Schedule B. The entire first, second, and third floors of the Gayaram building, mentioned as serial number 3 in Schedule B, was acquired by Shefali Chatterjee in the manner as described in paragraph 5 and 6 above. Apart from the aforesaid room in the ground floor of Ramapada Bhavan, Shefali Chatterjee was also allotted certain other portions of the ground floor, which she disposed of during her lifetime. The said Shefali Chatterjee, Deepak Kumar Chatterjee, and Vidyapati Chatterjee remained the joint owners of the land measuring 2.5 kathas, more fully described in Schedule C hereunder written. The properties described in Schedule B and C are the suit properties of the present suit. Lord, now, that Shefali Chatterjee, purportedly as settler, executed a deed of family settlement on 24th December 1997, which was registered in the office of the Registrar of Assurances, Kolkata, in 1998. In the recitals of the said deed, it has been mentioned that Vidyapati Chatterjee, the younger son of the settler herein, who all along with member of his family looked after and is still looking after the settler, and in view of many good reasons, and due to the attitude of the elder son Deepak Kumar Chatterjee, and for avoiding future complication and family dispute, the settler is now desirous in declaring and executing the deed of trust of the properties belonging to the settler, more fully described in second schedule of the said deed of family settlement, for the sake of brevity, referred to as the trust properties, for making provision for herself during her lifetime, and after her death, the trust will come to an end, and her younger son, Vidyapati Chatterjee, will be the absolute owner of the trust properties. That in the deed of family settlement has been mentioned that Shefali Chatterjee had decided to grant transfer. Your lordship can skip
this pertain to which of the schedule?
These are Schedule B and C. Admitted position.
The entire suit property.
Entire suit property. Lord, paragraph 17, I'm not troubling your lordship with. This is an admitted position, Schedule B and C property. Lord, now paragraph 18. That said, Shefali Chatterjee died in the year 2002, leaving behind her 2 sons, namely Deepak Kumar Chatterjee, Vidyapati Chatterjee, as her only legal heirs and successors. That after the death of Shefali Chatterjee, the said family settlement, the so-called deed of trust, has come to an end, and on the basis thereof, the defendant never acquired right, title, and or interest in entire Schedule B properties, but such right, title, and interest in the Schedule B properties devolved upon her legal heirs, namely Deepak Kumar Chatterjee and the defendant jointly, each having equal share therein. That following the demise of his mother, Deepak Kumar Chatterjee claimed 50% share of the rents which were being collected by the defendant from the tenants, namely Life Insurance Corporation of India and Silver Art, and the defendant, after collecting such rents, used to pay 50% thereof to said Deepak Kumar Chatterjee. The said Deepak Kumar Chatterjee died on 11 January 2010, leaving behind his wife and 2 daughters as his only legal heirs and successors. And after the demise of Deepak Kumar Chatterjee, the plaintiffs have acquired right, title, and interest in and over the properties left by Deepak Kumar Chatterjee, including the suit properties, up to the extent of his 1/2 share therein. That the said deed of lease, which was executed by Shefali Chatterjee in favor of my lord, paragraph 22 is also perhaps a factual matrix, my lord, not relevant. Paragraph 23, my lord, that after the death of Deepak Kumar Chatterjee, the plaintiffs in the month of March 2010 claimed 50% of the rents of the first floor of Gayaram building tenanted to Life Insurance Corporation of India and rent of ground floor room of Ramapada Bhavan tenanted to Silver Art, which were being collected by the defendant from the said tenants. But the defendants told the plaintiffs that he will not give any share of the rents to the plaintiffs. And he also declared that on the basis of the deed of family settlement dated 24th December 1997, he became absolute owner of the properties left by said Shefali Chatterjee described in Schedule B of the plaint after the death of Shefali Chatterjee. But for maintaining good relation with his elder brother Deepak Chatterjee, he had given 50% share of the rents to said Deepak Kumar Chatterjee during his lifetime. So let's pause here for a moment. My lord, my cause of action, if any, is paragraph 23, which I just read out. My lord, it is a situation where my husband, during his lifetime, was all along honored by 50% of the entire rents collected. And as such, either by good relation or just for a fact of a gift, that relation was maintained till his lifetime. Suddenly, upon his demise, when I claim what he used to get from his younger brother, I was refused. And there is a declaration which I plead in the plaint. It may be incorrect, it may be correct, my lords, but that is for evidence. That is for facts to be led in evidence. My lords, I say in the plaint that on the day when I went to collect the rents, I was told that the deed of 1997, the entire right has devolved upon him. My lord, nowhere in the paragraphs that I have placed before your lordships have I stated that my date of knowledge was in 1997, 1998, or any date prior to March 2010. The day when I approached the defendant and asked for my right in the property. My lord, in the absence of a positive statement in respect of the date of knowledge from my end as the plaintiff, and my lords, in the situation of reading the entire plaint as a whole, my lord, in my respectful submission, all that comes out of these paragraphs of the plaint is that there existed a deed of 1997 registered with the sub-registrar of Siliguri. My lord, I have not suppressed that fact. But a plaintiff who has come to court with clean hands claiming right, title, and interest in a property, by not suppressing a valuable material fact, which is the deed, which has to be fought for by me whenever the plaint goes in trial. And I may not get a decree eventually. But my lords, today we are before your lordships from a situation where my right to go into trial and prove whether any right devolves from that deed, or whether today I have any right in the property remaining after that deed, has been taken away by the learned trial judge in dismissing the plaint on the ground that 1997 registered deed mentioned by me in the plaint, plain reading of the plaint suggests that 1997 deed is still valid and operative. I don't seek for cancellation. Be that as it may, 3 years from the date of registration, under Section 59 of the Limitation Act, my limitation period stops. And the cause of action period is barred. My lords, my respectful submission is that 1997 deed, till such time that I do not admit, it cannot be taken as my admission in the plaint. My lords, they file an Order 7 Rule 11 application. In their Order 7 Rule 11 application, their point is the same, that deed has been mentioned and 3 years from 1997, and my date of knowledge was from the day when the deed was registered, or my husband's date of knowledge was from the date it was registered. During his lifetime, he never came up in challenge, and it is only after his death the heirs have come up in challenge. Milords, I file an objection to that Order 7 Rule 11. Although, Milords, I will not delve into that because the plaint has to be seen and not the objection filed to the Order 7 Rule 11. But, Milords, for the sake of completeness, it is relevant what I state in my Order 7 Rule 11 denial. I deny that I knew it in 1997. And I continue my case that it is only later that my cause of action happened. The moment there is a denial on record, and when the Order 7 Rule 11 is being considered on the basis of the pleadings of the plaintiff, Milords, if there is any iota of doubt that it is a triable issue which has to be decided after leading evidence, Milords, my respectful submission is that the plaintiff deserved to be taken into trial and not rejected at the preliminary stage under the principles of Order 7 Rule 11. Milords, as far as the impugned order is concerned, the impugned order delves on the same fact that 1997 did 3 years 59, section 59 limitation. Milords, I am accompanied with a recent judgment.
Let us first see the impugned order once.
Yes, the impugned order is at page 314. 303. Stand corrected. Second. Milords, perhaps from 310 is the operative portion after stating all the facts. The learned trial judge had endeavored into setting out the paragraphs, relevant paragraphs of the plaint as well, before coming to his conclusion. And the operative portion starts from a careful reading.
Yes.
Of para 25 and 33 of the plaint, it will appear that the date of notice in local daily is contradictory. In para 25, it is stated 28/9/2010, while in para 33, it is stated 27/9/2010. So the actual date of notice published in local daily is best known to the plaintiff. Now, on the face of the plaint, it appears that there has been a delay in filing the suit. It is admitted by the plaintiffs that the deed of family settlement was executed on 24th December 97, and the cause of action they has shown in the plaint as March 2010, and thus there is a delay of more than 12 years in filing the suit. Let us take to be true that as per the plaint, the trust deed came to an end after death of Shefali Chatterjee. The death of settler Shefali Chatterjee was in the year 2002. But no suit was filed praying for partition after death of the settler. Now, even if the suit was filed after the death of the settler, there would have been a delay in more than 4 years, whereas period of limitation is 3 years. Be it mentioned herein that the plaintiff did not challenge the validity of the trust deed, family settlement after its execution, nor even during the lifetime of the husband of the plaintiff number 1. Perhaps the plaintiffs thought to proceed after the death of the settler in view of clause so made in page 9 of the deed of settlement, but by that time, the period of limitation had already expired. Let us again go back to the plaint. In paragraph 13 of the plaint, it is stated that by virtue of the deed of partition being such and such of 1993, apart from the aforesaid, room in the ground floor of Ramapada, this is the set out. So there is an admission on the part of the plaintiffs that there was a deed of partition in the year 1993. The plaint has been cleverly drafted and bypassed the exact date of deed of partition, which was 19th August 93. Be it mentioned herein that in the said deed of partition, apart from the share of Shefali Chatterjee, the shares of the predecessor in interest, Deepak Chatterjee and the defendant had also been allotted, but the same also cleverly bypassed. In the said deed of partition, the deceased Deepak Chatterjee was the second party and his shares were allotted in the following manner. Let's turning the page. So the plaintiff's predecessor in interest, Deepak Chatterjee, has already been allotted his shares, which now devolved upon the plaintiffs by way of deed of partition dated 19th August 93. Subsequently, the deceased Shefali Chatterjee delivered her share to the defendant by the deed of family settlement dated 24th December 97. And here, the provisions of section 16 of the Hindu Succession Act 1956 will apply. Milords, after that, the certain judgments which have been relied upon. And Milords, straight at 314, after quoting the judgments in final order, in view of the foregoing discussions, I find that the suit is barred by law of limitation and the same is liable to be set aside, to be dismissed. Accordingly, the application under Order 7 Rule 11D of the CPC is thus allowed on contest, but without cost. The suit fails accordingly. My lords, if your lordship comes back to page 312, in that one paragraph, there are two deeds which he refers to. Well, the first deed referred to is the deed of 93, which has been referred to, relied upon, explained. My lord, that deed is not on the basis of which I come forward. That deed is a partition deed of K.N. Chatterjee's property.
Yes.
Thereafter, Shefali and the other heirs of K.N. Chatterjee received the properties. Then Shefali Chatterjee bequeathed her property to one son, ousting the other in the family deed of settlement. Because the family deed of Shefali Chatterjee, or the deed of settlement, which has been referred to, that has signatures of Shefali Chatterjee as the settler, and beneficial trustee is the son who is the sole beneficiary in that trust. There is no signature of Deepak Chatterjee in that deed. My lords, be that as it may.
Shefali transferred her share only.
Yes, her share.
So why was Deepak Chatterjee's signature necessary?
Yes, my lord, it wasn't, my lord, just for the fact that Deepak Chatterjee was not aware. That is my case.
What is your premise of challenge to that deed? Because you state in your one of the paragraphs of the plaint that it came to an end after her death.
Yes.
But even if the trust came to an end, the trust ended as per the trust deed with Deepak getting the property. So you have not even disclosed any cause of action for challenging it.
No, that's not my case.
You're not challenging.
I'm not challenging the deed. As it is, as it
See, if
stands.
the deed remains, then you don't get a share in her share.
My lords, that's perhaps in trial.
That is the only subject matter of the property.
Yes.
Shefali is that 97
Yes,
subject
Shefali.
matter.
My lords, in respect of that, if today, my lords, if I am to address on that, there is a paragraph in the plaint where I say that no right, title, and or interest devolved on the basis of that family settlement. How I prove that in law, whether it transferred or did not, that is something that has to be decided in trial. My lords, today the question is whether the limitation clock began in 1997 on the date of registration, or it began in 2010. And whether today I am out of time in filing my suit to claim my right, title, and interest. My lords, my case, for the sake of repetition, my lord, my case is that 2010, after the death of my husband, when I go to ask for my right, my claim is rejected, and I come forward in court to get my right, title, and interest in the property. As far as 1997 is concerned, I mentioned that deed in my plaint because that I came to learn in 2010. It may not be, my lords, in so many words written in the plaint, but my lords, my respectful submission would be that if a plaint can be interpreted, or the statements made in the plaint can be interpreted in two manners, my lords, it has to be the manner in which the plaintiff would interpret it, or the relief that the plaintiff claims would be granted is to be interpreted at the stage of Order 7 Rule 11. And at trial, perhaps, my lords, everything of the plaint has to be looked into before the final decree is being passed. My lords, may I just show one judgment, my lords? It's a recent judgment of the Honorable Supreme Court, wherein, my lords, similar fact situation, Order 7, Rule 11. No, not Dahi Ben, Dali Ben. It's that was Dahi Ben on Order 7 Rule 11. This is Dali Ben. My lords, this has considered two previous judgments of the Honorable Supreme Court. Similar situation, a registered deed. My lords, paragraph 2 and 3 are the facts of the case. The appellants as plaintiffs instituted a suit for cancellation of an alleged registered sale deed dated 4th December 2004, said to have been executed by them, conveying the plaint scheduled property in favor of the respondent defendants on 10th April 2017. They have alleged that the said sale deed was brought about through fraudulent means, and the plaintiffs came to know of it only on 31st March 2017, when the deputy collector issued notice to the appellants on an application filed by the defendants for correcting the revenue entries. After receiving the said notice, the appellants claimed to have applied and obtained a certified copy of the alleged sale deed, and have realized thereafter that their signatures were forged. They instituted the suit on 18th April 2017 for declaration and cancellation of the said deed. Within 1 month of the institution of the suit, the defendants filed an application under Order 7 Rule 11 for rejection of the plaint on two grounds. The first being that the plaintiffs have not joined the sub-registrar as defendant number 2, and that the mandatory notice under Section 80 was not given. We are not concerned with this ground. The second ground for rejection of the plaint, which has given rise to the present litigation, is that the suit is barred by limitation, as the registered sale deed was executed on 2004, and the suit came to be filed only in 2017 after a period of 13 years. Well, let's now paragraph 7 and 9, straight away. Suit was rejected by the trial court, thereafter appeal, my lords. then second appeal, and now in Supreme. Plus paragraph 7 and 9. Paragraph 7. From the tone and tenor of the judgment of the High Court, it appears that the High Court was proceeding to decide the case on merits rather than an application under Order 7, Rule 11. The High Court referred to and extracted relevant portions of large number of precedents on the subject of Order 7, Rule 11 of the same High Court as well as the decisions of this court. Having recorded the principle that operation and impact of Order 7, Rule 11 being a drastic remedy, courts must adhere to the discipline of confining the scrutiny to the plain averments. The High Court, however, proceeded to consider other aspects of the matter. The fact that the High Court relied on and has in fact drawn inferences that were possibly only after trial is evident from the following findings. Now, my lords, paragraph 9, the operating portion. Having considered the judgment of the High Court in detail, we are of the opinion that the findings of the High Court are primarily factual. The High Court seems to have got carried away by the fact that the suit was filed 13 years after the execution of the sale deed. The question is whether the plaintiffs had the knowledge of the execution of the sale deed. The High Court expected that the plaintiffs must have given meticulous details of the fraud perpetuated in the plaint itself. The first appellate court came to a conclusion that the defendants made an application for correcting the revenue records only in 2017, and on the said application, the deputy collector issued notice to the plaintiffs in March 2017, and that was the time when the plaintiffs came to know about the execution of the sale deed. It is under these circumstances that the suit was instituted in the year 2017. While the High Court came to the correct conclusion that under Article 59 of the Limitation Act, a suit can be instituted within 3 years of knowledge, it proceeded to return a finding that in cases where the document is registered, the knowledge must be presumed from the date of registration. But thereafter, the two judgments of the Honorable Supreme Court, one of 2015 is quoted, and the other one of 2018 Supreme Court on similar points of knowledge being essential for calculating limitation. Because thereafter in paragraph 13.
I could probably proceed on the premise of this transfer property act.
Yes.
Notice.
Notice on
Notice
the date of
is deemed to be from the date of 3. Registration or possession as the case may.
Milords, in this situation, Milords, it is the registered deed of family settlement, which on the basis of its registration perhaps obtains a notice to the public at large. Milords, my limited submissions to that effect is that till such time that I do not have knowledge, or my plaint does not espouse that I had knowledge in 1997, Milords, this plaint could survive. Milords and Milords, if your lordships just takes the plaint once, Milords, Schedule C, B and C are two separate schedules which I have marked in my plaint, Milords, at internal page 13. Milords, Schedule B, B is the entirety of the property which has come from Shefali Chatterjee, which was given in deed of settlement to one of the brothers. Milord, Schedule C on instructions, Milord, as far as we understand, Milord, it's 2.5 kathas which has come from K.N. Chatterjee. Milord, there's two parts, that's hence two schedules separately. And perhaps, Milord, what we are trying to argue before your lordship is that the plaint cannot be rejected in part. If anything in respect of Schedule C,
where have you stated that?
My lords, if your lordship take
in the plaint,
paragraph 14 and 15 of the plaint, where I describe the scheduled property.
Remain joint owners of C.
Yes.
Paragraph 14 and 15.
14 and 15.
Yes.
My lord, but this would be subject to correction by my learned.
B is that Shefali is 97 deed property.
My lord, that's perhaps that
Because
is
the paragraph 15 itself says
No.
properties described in Schedule B and C are the suit properties of the present suit.
Yes, they are suit properties, but they say in paragraph 14 that C remain joint.
At that, Lord, I need to show, Lord, the C is, Lord, the subject matter of the settlement.
My lord, if your lordship takes page 6, the next page, where the entire property is defined and B and C are once again defined.
Yes.
If your lordship takes para 17, 10 lines from the bottom, at numerical 4, all that 1/3 share of vacant and measuring 2.5 kathas along with her other properties, which are described in the second schedule of the said deed of family settlement dated 24th December 1997. The said properties are also described in Schedule B and C.
That is the vacant land of 2.5.
2.5
four.
kathas.
No, the 1/3 share of vacant land measuring 2.5 kathas along with her other properties.
Yes.
So that 1/3 share in the vacant land was also her property. But if it's 1/3, it's undivided 1/3.
Undivided one, not meets and bounds. That's 1/3 in 2.5 kathas vacant land. It may have been a part of the deed of settlement of Shefali, where the shares have been allocated, but the description does not entail demarcation.
So if this 1997 deed prevails
Yes.
and you don't get any, and you have not sought for any decree of declaration regarding that, then also C survives.
That's
You can get a partition regarding C.
Milords, perhaps the alternative argument in respect of the, and Milords, if that be the case today, Milords, then the Order 7 Rule 11 application perhaps failed.
Partial rejection.
Partial rejection.
All right.
And Milords, this is only my alternative case, Milords. My primary case is that even otherwise, even if it's one cause of action, Milords, and it's not two separate causes of action, and the second part does not contemplate a separate partition, Milords, still this plaint ought not be rejected for the want of date of knowledge, which is not categorically stated by the plaintiff or the draftsman of the plaint at the time of making this, instituting this plaint, Milords. And it is a subject issue of trial.
Yes.
Number in the plaint, your lordship has seen the relevant paragraphs, but it has been suppressed as to the date of knowledge of the registered deed of 1997. The learned trial judge, rightly, relied upon the judgment of 1977, the age-old judgment of clever drafting, relied on that you are under an obligation to state before the court, even if you plead that a particular deed is outcome of fraud or it does not convey any title, that the date of knowledge. But what that has been stated is, is at page 5, that Srimati Shefali Chatterjee, Deepak Kumar Chatterjee and Dr. Vidyavati Chatterjee remain the joint owners of the land measuring 2.5 kathas more described in Schedule C here underwritten. The said properties described in Schedule B and C are the properties of the present.
Yes.
Now, then, at paragraph 17, thereafter, when they come to know about this particular deed, at paragraph 16, it is not stated. It is stated when it was registered and the deed number for the year.
But in para 14, they say that they remain joint owners regarding C. B is the subject matter.
I'm coming to that.
Achha.
Because the learned judge said that because you are setting up your title based upon the deed, and the deed is not time, but therefore your partition is not sustained.
But Mr. Mukherjee, if you please come back to para 13 once. By virtue of the deed of partition being 93, Shefali Chatterjee was internally allotted such and such, more fully described in within bracket Schedule B, and the next bracket also says, all the three brackets say Schedule B. So as per 93 deed, Shefali's exclusive share was confined to Schedule B apparently as per para 13.
But I'm just
and 14 says C is joint.
Yes, but so far as C is concerned, but there was a previous partition that is not of the year 1993 at paragraph 13.
That is not regarding C, that is regarding the entire thing. Out of which partition B was allotted to Shefali.
I will check, because that is annexed. That is also annexed. The tripartite deed of partition, that is at page 84.
Kirat Chatterjee owned and possessed certain other properties that is said in paragraph 12.
Lordship.
And by virtue of deed of partition of 93, this is in para 13, Shefali was internally allotted such and such all of B. And para 14 says Shefali Deepak Vidyapati remained joint owners regarding 2.5, which is C. apparently C is culled out of that. I mean, separated from
Sir,
that.
I understand that whether 2.5 cutters still is not an undivided property or
Yes,
not.
yes.
Then my
Then the
learned friends
partial
argument-
rejection.
partial rejection,
argument.
that I will concede.
Right, right.
If that be the case.
Yes.
Now, I have asked my learned friend to find out from the partition deed whether the 2.5 cutters is not part of it or not.
Lord, I'm also endeavoring to just find
But
if that is
I
actually.
saw it somewhere, because this was not a point taken in the trial.
13,
but
14
nevertheless,
cumulative.
I'll not be shying it.
Yes. That is the probably the reason for distinguishing between B and C. B was
If
Cephalus.
that is the case, then I'll be conceding to the fact that it will be confined only to C, so far as the one.
At the plain stage, when plain rejection stage, we cannot say it
No,
is
your lordship will confine the inquiry of the suit only to
partial rejection of plain.
No,
cannot
I
be.
don't say reject. Your lordship by an observation can restrict.
Then
the
we'll be
inquiry.
deciding a preliminary issue, Mr. Mukherjee.
But there's no issue on the fact, that so far as the prayer under B is concerned, that
Either
is
you
time bar.
either you can reject the plaint as a whole or you cannot.
That is a settled law.
If,
No
if,
doubt
if
about
you
it.
have a good point in regarding one of the subject matters, one of the schedules, then also we cannot reject. We have to hear the order 7 rule 11 only. We are in judgment over the order.
Bow
7.
down to your lordship.
So we cannot say anything of that sort. You should be confined to this. At best, that would be an arguable case, which you have. I mean, good arguable case maybe. But we cannot confine the inquiry of the court to one of the topics, even if we find
One
that.
of the purpose, is to just shorten the tenure of the litigation. If it is found,
Order 14 rule 2, yes. If it is order 14 rule 2, yes. But order 7 rule 11, probably Mr. Mukherjee, you just give your thought over that also.
Lordship. Now, so far as if your lordship is only willing to hear on the 2.5 cutters, then I'll have to come
No,
back
the
to
entire thing. Yeah.
the entire thing. Then I'll be relying upon two judgments.
Absolutely, yes.
Now, one of the judgment is by on the point of limitation, that 59, Article 59.
Yes.
There are 2 pages to this. But that is reported in 2020, volume 16, Supreme Court cases, page 601. But your lordship will kindly come to paragraph 6.1 onwards. And the paragraph 8 is not the ultimate paragraph, which says that about the clever drafting, and the period of limitation is from the 3 years from the date of execution. That's it.
'59 is relied on. It does not say that it will be from the date of
Paragraph
execution.
8.
8, yes.
Paragraph 8. If such a prayer would have been asked, in that case, the suit can be said to be clearly barred by limitation, considering Article 59 of the Limitation Act. And therefore, only a declaration is sought to get out of the provision of the Limitation Act, more particularly Article 59 of the Limitation Act. The aforesaid aspect has not been considered by the High Court as well as the
বইগুলো কোথায়? বইয়ের লিস্ট পাঠিয়েছিলাম তো 2 সেট করে রাখতে। Mukherjee is when the fact
That is exactly how not pleaded in the plaint, and that's the reason the learner just said I am entitled to the benefit of that clever
first
judge.
became known to him. But then this date of execution is not stated in para 8 of your judgment also.
No, it is said that it has been.
It says that if such a prayer would have been asked, the suit can be said to be clearly barred by limitation considering Article 59.
Yes. And Lord, in the second judgment, which I'll be relying upon.
This does not say from date of execution.
But I'll just Lord.
59 says knowledge.
But 29.19 of this judgment.
This is another judgment.
Another judgment relying upon and explaining this judgment.
Give the citation, Mr. Mukherjee.
But that is not 2020 volume 7 Supreme Court cases 366 paragraph 29.19.
But this
that is at page 385.
Mr. Mukherjee, with utmost respect, this observation is not correct.
But that is what it is. I can't improve.
This is not even obiter because this is not a proposition of law.
This is blood.
This is a wrong reading of fact.
What? And this is a judgment blood which has been passed by the Supreme Court on Order 7 Rule 11 concerning blood Article 59.
True, but the ratio decidendi is only a binding precedent.
Maybe if your lordship blood reads blood the other judgment blood that Raghavendra.
Somewhere else it might have been stated.
But it is blood at paragraph 6.1 to blood paragraph 8.
Somewhere in between must have
blood that paragraph 7 blood. If your lordship sees blood the facts stated out, but the intention of the blood the Supreme Court blood while blood coming to that ratio was. Number paragraph 7, therefore, considering the averment in the plaint and the bundle of facts stated in the plaint, we are of the opinion that by clever drafting, the plaintiff has tried to bring the suit within the period of limitation, which otherwise is barred by law of limitation. Therefore, considering the decisions of this court in T. Aravindandam and others, as stated above, as the suit is clearly barred by law of limitation, the plaintiff is required to be rejected in exercise of powers under Order 7 Rule 11. But maybe blood from paragraph 7 and paragraph 6 blood. This has been blood summarized by the blood the Honorable Court, because blood the judges blood who constituted blood the other bench blood. One of the judge was here also.
But it was authored by the other judge.
No, authored by the other.
Both the cases the second judge is authored, and this is one of the reasons, Mr. Mukherjee, why I request you not to cite my own judgment. One of the very reasons I'm telling you. This is one of the glaring reasons. Because this will obviously be said. But here both the learned the second partners of the bench authored the judgments. Justice Indu Malhotra and Justice Amar Shah. And but Article 59 itself says otherwise.
Yeah, blood in the facts of this particular
because
case.
if it was held that yes, as per Article 59, execution date of execution is not even date of registration, Mr. Mukherjee.
When the fact comes to the knowledge.
Here it is said in your second judgment, if it was filed beyond 3 years of the execution of the registered deed. So the registered deed might be executed prior to the execution, might be prior to registration also. So date of execution is neither here nor there. Not even section 2 scenario.
But may I just
section 3 scenario TPI.
If your lordship kindly comes to the statutory language of Article 59.
Yes.
Well, let us go by not what the statute says.
I'll go by your book, which is with me. Section
yes.
Article 59.
Yes.
Limitation Act, your Limitation Act book is with me. That's why.
Lordship. When the facts entitling the plaintiff to have the instrument or decree cancelled or set aside or the contract rescinded first becomes known to him. This is not what the Raghavendra Singh says, that you have to say.
Yes, that is said. Clever drafting and all.
Has to be stated. In this particular plaint, nothing is stated.
No, not stated.
So that is the reason the trial judge said, by reference to Lord 77 judgment, that it is a piece of a clever drafting. Now, my lord, I come back, my lord, to what, my lord, the Supreme Court says on Article 59. Raghavendra, my lord, has been, my lord, explained in Dahiven to say that it is within 3 years of date of execution. Although, my lord, I don't find that from, my lord, the statutory language.
Neither do I.
We're unable to, my lord, comment further on that. But, my lord, that what it stands as of now.
We will distinguish.
Now, my lord, so far as, my lord, 58 is concerned. Well, let us not fall back to 58 because, my lord, the prayer B is, my lord, my lord, the prayer B is, my lord, directly, my lord, seeking a declaration concerning, my lord, that the defendant never acquired right, title, and interest in the entire suit properties on the basis of the deed of family settlement dated 24th December 1997. So, my lord, then Article 58 comes into play.
All right.
For, my lord, a declaration has been sought for. My lord, now if declaration is sought for, your lordship will kindly, my lord, fall back upon 58. When the right to sue first accrues.
Yes.
Now, my lord, in a case of when the right to sue first accrues, is, my lord, essentially, my lord, the plaintiff is to plead, my lord, the date of knowledge. The entire, my lord, the pivotal, my lord, the argument of mine is, my lord, that there has been a suppression of a very vital fact in the plain, which goes to show, my lord, when the knowledge was derived by them. Because, my lord, the statute says under section 3 that there is a presumption of knowledge of, my lord, a registered instrument. Then, my lord, the law of limitation says that the limitation commences from the date when, my lord, that particular fact comes to your knowledge under 59. Then, my lord, 58, if we fall back to when the right to sue first, my lord, accrues. In the absence of, my lord, the necessary pleadings, the vital pleadings, my lord, that is what, my lord, the tenor of the judgment in Dahiven as well as Raghavan, paragraph 7. That the learned judge should, my lord, reject the plaint because of suppression of a vital, my lord, the statement.
Mr. Mukherjee, there is a clear distinction in this particular case. Why? As per the plain pleadings, paragraph 19 and 20, if you please come to para 20 at page 7. Now, they say their pleading is that even after the execution of that 1997 deed, after the demise of Saif Ali, Deepak was given his share by your predecessor, apparently. If he was given his share, therefore both the parties, according to them, as per para 20, proceeded on the premise that that was not acted upon.
But that is never their case at all.
But para 20 says that following the demise of his mother, Deepak Chatterjee claimed 50%, which are being collected, and the defendant, after collecting such rents, used to pay 50% thereof to said Deepak Kumar Chatterjee. Then Deepak died. After the death of Deepak, they went to collect the same thing when it was. So their cause of action is not exactly that 97 deed even, because they don't say that 1997 deed we are challenging, because this, as per their plaint on the face of it, especially now, despite that 97 deed, 50% was being given to them. So if that be so, their cause of action for the suit is pay para 23. That when that was refused.
Cause of action was, my lord, when there was a demand and there was, my lord,
refusal.
Refusal. The cause
but
of
it was after the death of Saif Ali also that after the 97 deed, after death of Saif Ali also, that 50% was being paid to their predecessor. So their cause of action for the suit is this 50% being refused to them, not the 97 execution, because after 97 execution, their share was being paid to their predecessor. That is their plaint case.
No, my lord, this was based upon their demand. If lord, in my respectful submission,
Based on their demand,
that is paragraph.
That was
33.
acceded to. That was acceded to according to the plaint. We go by the plaint. So order 7 will 11.
Let us, my lord, that the cause of action arose in the month of March 2010, paragraph 33, when the plaintiff claimed 50% share.
No, but
50% of the rents
that is
as
preceded,
aforesaid.
that is preceded by para 20. Mr. Mukherjee, if you please read once para 20.
Para 20 I have.
The following the demise of mother, Deepak claimed 50% and defendant, after collecting, used to pay 50% to Deepak.
Yes, but they,
So that is after 97 deed. So
Very
they did not have any cause of action of challenging 97 deed.
so my lord, even after, my lord, if this be the statement,
Yes.
now, my lord, they know about the mother's, my lord, the settlement deed.
Yes, but it was never the cause of a litigation because 50% was being paid to them.
That was, my lord, might be voluntarily, my lord, to my brother, not as a matter of right.
But then it goes into the realm of arguability,
My lord, so far as, my lord, if
not
we cull out,
especially rejection.
if we cull out, my lord, that what their prayer is and what their statement is.
Yes.
Now, my lord, this is a straight statement that they have made about, my lord, the 50% rent. Nobody knows how much was the rent, how much has been collected and given. Now, and there is no statement.
No,
in that.
that is subject matter of proof. We are at the
But
order
what
7 rule 11, we take this as sacrosanct.
Yes, yes, for this purpose. Now, my lord, there are two things. So far as, my lord, my learned friend's contention about the 2.5 cutters, my lord, that I'll find out. My lord, that is one part of it.
That is one part.
And my lord, so far as, my lord, the challengeability, my lord, to the deed itself, which forms the basis of, my lord, the partition suit, whether that can be sustained, because, my lord, until and unless, my lord, the prayer B is allowed, there cannot be prayer A granted.
Regarding Schedule B, if
Schedule
C,
B and
if C is not,
if C
if
is not,
not
Lord,
within-
partition. If C is, Lord, not covered
then
under
another
the
ground comes up.
another, Lord, then I will concede to what my learned friend says. By
Then another ground.
ওইটা একটু দেখ না বাবা আড়াই কাটাটা না পেলে বলিস আমাকে আমি দেখেছি ওটা কোথায় একটা আছে এ থেকে দেখ ওই পেজ এটা থেকে পার্টিশনটা থেকে দেখ পার্টিশন ট্রাইপার্টাইট পার্টিশনটা আছে পেজ 59-60 ওটা থেকে
You can see from the schedule also probably.
But it's a schedule, my lord, my learned friend has shown, my lord, that paragraph, there are, my lord, two schedule 4s. My lord, the last one should be 5, paragraph, my lord, page 6, paragraph 17. My lord, the second 4 is all that 1/3 share of vacant land measuring 2.5 cutters along with her other properties which are described in the second schedule of the deed of family settlement.
So different, Mr. Mukherjee, because one schedule B1 is piece and parcel of one room measuring 300 within this. Two is 2 shop rooms measuring such and such.
These are squarely covered. Now, my lord, the last one, the
last one is 2.5 cutters vacant land. So
which are described in the second schedule of
same
the deed of
property,
family settlement.
same property maybe, but
no, this is the vacant, because if your lordship
not a part of schedule B. That is what we are trying to say. Not a part of schedule B.
No, lord, your lordship will kindly come to, lord, paragraph, lord, 2 first. Annakali was the owner, 27 cutters.
Yes.
Now, lord, constructed 3-storied building, lord, I am not on that.
The distinction starts from your 97 deed, because up to 93 deed of partition or 93 maybe.
Because they are to say, lord, with reference to the 93 partition deed, whether 2.5 cutters, lord, they retain, lord, any share in it or not. Lord, going by there, lord, the
para 13 and 14 is very clear, but Mr. Chatterjee. Para 13 says, by virtue of the said deed of partition, 93, Shefali was internally allotted 1 room, serial number 1 of B, 2 rooms, serial number 2 of B, and then say entire first, second, and third floors of Goyaram, which is different.
Lordship.
We are only concerned with Ayaram here. So serial 3 is Goyaram, which is somewhere else probably. Siliguri market and all. So therefore, they say, and para 14 they say, Hefali Deepak Vidyapati remain joint owners regarding 2.5, which is distinct and different.
Yes, but my lord, thereafter it goes to say at paragraph 12.
Yes.
My lord, that all the properties of Dr. Kirodnath Chatterjee, including Rampada Bhavan and the ground floor of Goyaram building, were partitioned amongst the said Shefali Chatterjee,
Yes,
Deepak Kumar Chatterjee, Vidyapati.
All B, C, entire thing was part of Kirod Chatterjee's estate. Yes.
So it is by meets and bounds.
After that meets and bounds, what was given to Shefali was, they say, schedule B only.
That was not what was allotted
as per
to
the plaintiff.
Shefali. Therefore, Lord, what that remained by virtue of the 1993 partition
That is
was
C.
a separate, Lord, the share of Lord Deepak Kumar Chatterjee. My client is
No.
Dr. Vidyapati Chatterjee.
B was given exclusively to Shefali, they say. But C remained joint. They admit that. Para 13, 14, 12 says entire property belonged to Kirodnath Chatterjee. 13 says 93 deed comes and gives entire B
Lord, paragraph 12, Lord, subject to correction.
Yes, yes, absolutely.
Lord, kindly see, Lord, there is a reference of that partition deed. In that,
Yes.
Lord, the 5th line, yes, all the properties of said Dr. Kirodnath Chatterjee, all the properties,
Yes.
including Rampodo,
Everything. Rampodo, Goyaram,
partitioned among
2.5,
Shefali
shop
mother,
room, yes, everything.
Shefali, Dr. Deepak Kumar, Sri Deepak Kumar Chatterjee, my learned friend's client, and Dr. Vidyapati Chatterjee, my client. So, Lord, there are 3, Lord, the divisions of all the properties. Shefali, Lord, in 1997 executed, Lord, her share in respect of my client. So, Lord, already Deepak Kumar Chatterjee's 1/3 share stood, Lord, partitioned by meets and bounds in 1993. I'll clarify that. আর partition deed টা দেখ না রে বাবা আছে।
It says that it was entire property was partitioned among Shefali Deepak and Vidyapati by meets and bounds. By that, then next paragraph they say that meets and bound partition was that B was given entirely to Shefali and C was left joint for all these 3. So that was the nature of partition.
Milord,
It can very well be, Mr. Chatterjee, Mr. Mukherjee. It can be that
otherwise, Lord, I'll just check, Lord.
may not be separate shares allocated to Deepak and
Very well.
Vidyapati.
If, Lord, 2.5 cutters is, Lord, that remained, Lord, joint between the 3 owners and now between the 2 owners,
then
that can be, Lord. But I just need to, Lord, just
yes, you need to ascertain definitely,
So
definitely.
that partition টা দেখ না
Milord, if your
দেখলেই তো হয়ে
lordship
যাবে।
reads this with page 67 of the
Client
first
bold.
volume.
That 97 did.
Yes, 93.
Client bold.
The first one, which
Yes, yes,
Mr.
sorry,
Mukherjee-
93 did, yes.
that
Page
starts at page 48. If your
67.
lordship takes page 67 one,
Yes, yes, that is what we want.
it refers to a 3 katha, not 2.5. That is exactly why I did not point it out till now, whether it's the same property, because this remains unpartitioned in that
No,
deed.
that the 2.5 kata is the residual portion of the property that we have found out.
My lord, if your lordship takes the explanation of this 3 katha, this is the same vacant 3 katha land, which that deed records that remains to be partitioned. People will use it as a common passage.
Where is
with the
that?
fact-
Where is
At
that?
page 67. Your lord. If this is the same property, my lords, perhaps this has not been
There
partitioned.
exists a vacant land.
Yes.
Yes, yes.
This is 2 and 7 katas.
Goyaram is situated in the same plot.
In the front.
In the same plot as the vacant.
27 katas, Lord, one there
Yes,
was
1348 or
Lord,
1438 something. The plot is given.
Yes. Well, it's the same plot, 127 katha plot, out of which
No,
there
the
are two
plot
parts.
number is given 8325. 8325 is the plot number. Now Goyaram is situated. Yes, yes.
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 Schedule B.
So this may be that.
My lords, at the last 3 sentences at page 67.
Remaining portion, yes.
My lord, so by Shefali Chatterjee's deed of settlement executed post this deed,
Yes.
what was joint could not have been partitioned by her amongst the remaining.
No.
So this perhaps remains joint as far as Schedule C is concerned.
Hard deed is covered. Hard deed covers B. Your B.
Yes.
Your suit B.
আড়াইকাটা কোথায় দেখাচ্ছে রে?
Oh.
Alright,
Page 66, the last paragraph. 3 tenanted premises in the ground floor of
That is
Goyarangi.
not B. That is B. Those are the tenants
is B,
recorded and
yes.
all. Look, I'm
That
trying to
is-
find out from here that 2.5 katas, Lord, if there is marked anywhere.
No. Mr. Mukherjee cannot be B. Because
Vacant land.
66 last paragraph, there are at present 3 tenanted premises in the ground floor of Goyaram. One is tenanted to SN Bose and Company, other is tenanted to Omuk. And the third one is tenanted to Nihal Singh since deceased. With respect to his premises, eviction of the aforesaid 3 tenanted, the premises now tenanted to SN Bose has been allotted to Deepak Chatterjee. So that's exclusively for Deepak. That's not the subject matter of this partition suit at all.
No.
So that's a different
What
SN
Deepak
Bose.
has, he has.
He has.
What
So
now
they
he
have
is
not.
asking for is, Lord, that
So
what
SN
father
Bose,
gave to me.
yes, SN Bose goes. Other 2 premises has been allotted to Shefali. So the other 2 premises is B.
Lordship.
Now, and then third is, we continue to page 37, 67.
Lordship.
There exists a vacant land.
Lordship.
Last 3 lines say remaining portion of vacant land. Among the vacant land also some allocation was made probably. On the said vacant land, a room will be constructed adjoining such and such.
That is a 3 cutters
Yes,
behind Goyaram building,
yes.
which is
Till
always
that
been
room is
treated as a part
constructed,
of
yes.
Goyaram building.
First party. So probably within that half cutter, that room was constructed maybe.
My lord, may I be at the liberty to say something, my lord? Kindly does not take me amiss. My lord, if this exercise
Yes,
is having to
we
be
were
under-
thinking that also.
my lord, then trial becomes redundant, my lords.
No, but
What
even
is being partitioned, what has not been partitioned.
nah,
and
on
what
the
is-
face of it, if it is found out, but this document has been relied on in the plain.
Yes, this is a
So
partition.
if your face is complicated, what can we do?
That-
It has had at
that-
least 2 plastic surgeries, one in 1993, the other in 1997, and it's for the poor surgeons to suffer.
The only thing that I may say, I was the same boat as I was 5 years old when this plane was perhaps drafted. So, my lords, this is a situation
Yes,
that we
yes.
all are facing.
So the face is so obscured that on the face of it also, to do that also, we have to undertake this exercise.
But may I just do one thing, Lord? May I just go through it, come back tomorrow and assist your lordship about the 2.5 cutters? How it devolved?
Tomorrow we'll forget everything, Mr. Mukherjee. Let us
Because
continue.
Lord, I really,
Page
Lord,
66 and 67 are very clear, Mr. Mukherjee. No, we'll go by their plain. Let us not go into this. We'll go by their plain. They say B is Shefali and the rest is joint. Para 13, 14.
Lord, whether blood that even blood the C is blood something remains blood to be partitioned, that is where blood I am. If blood it is found that C blood there is nothing to be partitioned and it was already partitioned.
But Mr. Mukherjee,
therefore,
we
blood,
cannot undertake probably that exercise by going into his right on that, or going into the meat of the matter as far as the agreements are, the deeds are concerned. Because para 14 clearly says 13 and 14 combined together says B exclusively to Shefali by 93 deed, and 14 left joint between all three of them. And then 15 says properties described in Schedule B and C are the present suit properties. B is exclusively of Shefali, but they say that it was not exclusively of Shefali. Rather, they say B, para 13, they say B was subject matter of that 97 deed, and C was all along left open.
But in 17, they go to say that
Yes.
in the said deed of family settlement,
yes,
it has been mentioned that then Lord, they are referring to the deed
B.
of family settlement, and we go back Lord to the second 4, all that.
Yes.
So this is where Lord, exactly
Oh, you
where
are right.
confusion
You
comes.
are right,
My
because
confusion is coming from there.
right. Item 4, as you said.
Second item 4. So Lord, they are referring
Yes, second
to the
item.
family.
You are right.
Lord, that's the reason, Lord, I was Lord,
All
before
right, all
making
right.
a positive statement before the
All
court.
right, all
I
right.
wanted to Lord check it out.
All that 1/3 they bring within this hotspot.
Yes.
I mean, the Shefali is.
Yes.
No, but they say all that 1/3 share of vacant land. 1/3 share of vacant land. Mr. Mukherjee, they don't include the vacant land. She has 1/3 share there.
Lordship.
So that 1/3 share also. That was the subject matter.
But I'll do one thing, Lord. If my client says that they're entitled to Lord, the 1/3 of the 2.5 cutters, I'll concede Lord and I'll finish off the matter in fact.
My lords, may I say this? My lords,
My learned
perhaps we
friends-
have gone too deep into that 2.5 cutters. My lords, I am at no moment.
We have got what is
Yes,
there.
yes, my lords.
Mr. Mukherjee, let us conclude the argument today itself. You cite your judgments, we'll just look into it.
Let's just differentiating the judgment cited. my
No,
lords.
he has not finished.
That's distinct. Oh, distinct.
Shefali says regarding that vacant plot, 1/3 of my share, 1/3 of which is my share.
That your lordship will find, Lord, if it is not the 2.5 cutters at all, but that your lordship will find at page not 64 of the partition. But although Lord, it says about the area is more,
Yes.
2 cutters, 7.
Probably something was left for that room which was to be constructed on that. That dispensary or something like that. No.
না এটা 4
No, no,
কাঠা
not
থেকে
this.
আসছে,
Not
4
this.
কাঠা থেকে আসছে, এটা হবে না। 2.5 কাঠা টাকা তো আছে কিনা এখন। এটা বরঞ্চ page 67 এর ওটা is much more মানে
Yes, 67 is the thing which is to look.
My lords, the answer perhaps lies here. My lord, either that 2.5 kathas I get or I don't at page 117. Let's kindly take this page. It is 1/3 undivided share in 2.5 millions. This is 117 is a part of the document of the deed of family settlement of 97. What is Shifali bequest?
1/3, yes.
1/3.
That is
1/3 of that vacant.
Not meets and it's not
Because
divided till that.
Yes.
This 3% they inherited. There's no doubt about it. Shefali's share is being given to me.
So she does not make a demise of that entire 2.5. She deals with hard 1/3 share
Or
in that.
1/3 share.
So therefore that remained common as per 97 deed also. Because she admits that she has 1/3 share in that.
That's it. But it appears so.
Yes, sir. Any other judgment you have to cite?
No, but these are the two judgments, not on the point of the clever drafting.
Yes, answer.
Just 2 sentences. Because that the judgment that has been relied upon, citing section 59 or the 3 years period, because the judgment that I referred to contains 2 judgments which the Supreme Court refers to. One is the 2015 one and the second one is the 2018 judgment. But I have just taken it out. The 2018 judgment, 2018 6 SCC, is a 3-judge bench. Because I do not say that today it is a situation of that sort that somebody has to say whether what Supreme Court has said in that particular judgment is correct or incorrect. It's a 3-judge bench of 2018 which says otherwise, which has been followed by a 2-judge bench in 2024.
No, those judgments do not deal with, do they deal with the limitation from execution?
Yes, Phillips. The 2 judgments that has been referred to in the...
Yes, para 11 and 12.
Yes. Para 12, Milods.
Yes.
Order 7, Rule 11D. Knowledge on 26 December 2012. Milods, it's the same.
No knowledge of execution.
Yes, it's the same. And relying on these 2 para
Yes,
13,
underlined portion of
yes,
page 10.
para 19. Quoted para
Before that also, just before para 19. According to the appellant,
Yes.
suit has been filed within time after acquiring knowledge.
Yes. And Milods, on fact, just one rebuttal, Milods. Your Lordship said, asked Mr. Mukherjee to see paragraphs 18 to 20. If your Lordship also takes paragraph 23 with this, 23 is the meat paragraph, Milods, where we say that we went, it was denied. That is the first averment in para 26. There is one more averment contained in para 23 of the plaint. Internal page 7 of the plaint. If I may place this 4 lines once again. For the
Yes.
That after the death of Deepak Kumar Chatterjee, the plaintiffs in the month of March 2010 claimed 50% of the rents of the first floor of Gayaram building tenanted to life insurance and rent of ground floor room of Ramapada Bhavan tenanted to Silver Arts, which were being collected by the defendant from the said tenants. But the defendant told the plaintiffs, Milods, if at all, this is my date of knowledge in my plaint, if there is any. There is no other date of knowledge other than this one statement made in the plaint.
Yes.
It should go under order 14 rule 2.
But then also, if it's a mixed question, then you have a
So the preliminary issue will be framed on that. Evidence
mixed
will be
question.
laid
You
on.
cannot decide it before the other issues.
But not the preliminary issue is not the question of limitation.
Has to be framed. Has to be framed. But probably cannot be heard in isolation of the others, like the second part of order 14 rule 2. Because if it's a pure question of law, then only that can be done. Here it's a mixed question. Interpretation of the deeds comes in. That is a difficult. Anyway, we'll reserve judgment on this. Probably Mr. Mukherjee will lose. In all probability,
I understand.
your client will lose. Probably, but we don't. We are not sure.
Your Lordship is not. There is a suit of the year 2010.
Yes,
The partition suit.
that
I
we have
was
noticed.
trying to talk with my client. If we can agree to something, otherwise that will give a quietus.
Agree to the entire dispute being resolved.
That dispute maybe not the properties covered in the family settlement, because that is I have a good case. So far as the 2.5 cutters are concerned,
yes,
I can convince my client, or I'll try to convince.
In any event, even if they win here,
Lordship.
they have to establish their case on evidence.
True.
And also, we can only say that limitation is a mixed question at best.
But
we
that
cannot
is one. And
conclusively say anything.
And second, the other hurdle for my learned friend is to show that by the registered settlement deed, no right has been conferred on my client. That is
very difficult.
More
uphill
task. Because 1997 it was executed, never challenged during the lifetime of the executrix.
Yes.
And after the death of her Lord husband, then
No,
only
but
Lord
she
the
has
suit
made
was
out a
filed.
case that their 50% was being given.
That is only in respect to the rent. That is what they
Yes.
have stated.
Yes. And as you said, it may also be gratis. I mean, yes.
Yes.
That does not necessarily mean in pursuance of that or in contravention of that 1970.
Lordship.
But if that was so, they need not have made this prayer be at all.
Lordship. Lordship.
Maybe on merits, you may have a point.
Because just I wanted to point out one thing, because the injunction application perhaps remains pending. There was an
There was
an
an interim order, I'm
interim
told.
order that had been
The
passed
interim
on the
order-
last occasion, and the interim order is expiring on 31st January.
We are disposing of the injunction application right now till disposal of the appeal. We will reserve judgment on this as soon as possible.
That
we
is
can.
still up to 31st of January.
No, then we will have a compulsion. No, 31st of January before that. No, but the injunction has to be decided.
I just
Yes, it's definitely before that, but injunction has to be disposed of. That will be kept pending, and then we'll dispose of
Kindly
the.
confirm the interim order, my lord. And
Yes, yes, we are. Can 1 of 20? Can 4 of 2023? Acha, can 4 of 2023 is opore caption to can 4 of 2023. Upon hearing learned counsel for the parties, we find that there has been no change of circumstance after the interim order was passed earlier on the present application. Full accordingly, the interim order granted earlier is made absolute till disposal of the appeal. Full next para. Appeal number FMA numbers, FA numbers. It was initially registered as FMA and then became FA.
Yes.
The FA 38 of 2025 is taken up for hearing. Heard learned counsel for the parties at length. The matter is the appeal is reserved for judgment.
And blood, only one point, blood, in the written objection, the point that my learned friend has taken was never taken.
We cannot look into
Therefore,
the.
court
We
did
shall
not delve into that question at
Mr.
all.
Mukherjee, we shall not look into the written objection. We are being very candid
Very
because
well,
they cannot make further pleadings in written objection. As
No,
rightly.
the point, blood, that about blood the partyability of blood the 2.5 quarters. And that
Written
is-
objection we are not bothered with. Whatever is there in the plaint, and at best your order 7 will live in whatever point you have taken.
only the point of limitation.
Even apart from that, if any point was available, if the court decided we had to look into, because court suamoto could also.
Court
But
has
here
decided
only limitation.
on blood,
Court
section,
has, I've seen,
Article 59.
found the easy way out. Like we were inclined to do also.
Deeply obliged.
Thank you very much.
Blood, if there is a blood, in the likely event that I'm losing, blood, there may be a direction for the learned court blood to dispose of blood.
Yes, definitely. Absolutely. No, but we are not final on that. I mean,
but still,
apparently till now. But we'll have to look into all the documents also.
Yes.
Despite what you say.
Yes. Deeply obliged. That I am for the appellant petitioner, Malad.
Yes.
In terms of your lordship's last order, Malad, I have prepared a supplementary affidavit disclosing what is the admitted due on part of the appellant, Malad.
1 minute. Let us get the file first. Yes. This is a supplementary affidavit to your application.
Yes, Malad. If your lordship kindly takes up the last order passed by the lordship on 23rd December, Malad.
Yes.
Page 2 of the order. Can 2. Can 2 is now taken up for hearing by virtue of the present application. Stay of operation immunity has been sought for. The learned counsel for the appellant submits that the entire award amount has been deposited with the Employees Commission. It is submitted that in event the entire amount is withdrawn, the respondent. However, the court of the opinion that the appellant should clarify as to what, according to his admitted compensation payable,
Right.
even if the appellant is successful. That is the supplementary.
So here the entire you disputed a portion because that was regarding what?
Only portion that is disputed.
Interest.
No. Malad, there is loss of earning in respect of the disablement. Our intention is that as per the medical report, the disablement is temporary in nature. It is not permanent. The learned commission held it is permanent in nature and awarded 50%. But there is a schedule in the act which says that there has to be an amputation or that kind of an injury. But here is a swollen elbow. So we say it will be
swollen elbow.
Yes.
So that is curable.
Malad, that is a.
We don't know whether it's permanent or not.
Malad,
we will have to go into the evidence.
Malad, that is the. We say it is 25%. The learned commission.
So 25% you are at.
Yes. Rest of the portion remains same. Malad.
That is the thing. Matlab, only difficulty is, matlab, I have served on the respondents. Respondent 2, I have got the delivery report. But the respondent number 1 shows it had gone to Murshidabad, matlab. I think there is some mistake, matlab. May I?
One is the main.
Yes, may I
Yes.
serve again and come back, matlab?
Please do that.
Yes,
You
I
take
have.
this,
I'll have to.
serve this also.
Yes, I'll serve that only. Matlab, because earlier there is a affidavit of service in respect of all the applications. but-
Application has been served.
Yes, yes, yes. That is there. Matlab, your lordships directed me to serve this as an advance copy.
Have you got an affidavit of service regarding this?
No, matlab, since I did not get that tracking report, I
Very
could not. Matlab, I'll just serve again and come back, matlab, if your
Very
lordship kindly cancel.
Learned counsel for the appellant files a supplemented affidavit to the appellant, primarily disclosing the admitted quantum of compensation payable by the appellant to the respondents. Push up next para. The said supplemented affidavit is kept on record. Push up next para. Learned counsel for the appellant, comma, in his usual fairness, comma, submits that proper service could not yet be effected on respondent number 1, and as such, he may be directed to serve afresh a copy of the supplemented affidavit on the said respondent. Push up next para. Accordingly, the appellant shall serve. Appellant shall ensure that proper service, because you have already served the number 2, the appellant shall ensure that proper service is effected on both the respondents, comma, if necessary, serving afresh on the respondent number 1, and file a complete affidavit of service on the next returnable date. Which of the matter be listed on 27th?
Can it be 28th, matlab?
Be listed on January 28, 2025.
I'm grateful.
Under the same heading.
I'm grateful.
When such affidavit of service shall be filed.
I'm grateful. Thanks.
Thanks for the respondent, my lord. On the last
Respondent.
on the last occasion, my lord, your lordship had passed an order.
Please use the microphone.
Well, I know do not have a right of say in this matter.
No, but
my lord, on the last occasion, kindly seize your lordship's last order, my lord.
Yes, yes. When the dismiss for default করছি বারবার ওকে টাইম দেওয়া হচ্ছিল ইচ্ছে করে ডিলে করছিল when the matter is called on for hearing, none appears for the appellants. So although the respondents do not have a present right of hearing at the order 40 on rule 11 stage, comma, however, comma, the respondents are represented through counsel at the time of call. So next para, we find from the previous orders, comma, particularly the order dated January 7, 2025, comma, that the matter had been repeatedly adjourned previously due to absence stroke adjournment sought by the appellant. Even on the last occasion when the matter was taken up for hearing, comma, we found that a defective vokalatnama had been filed on behalf of appellant number 1 according to the learned advocate having instruction to appear for the appellants himself. Next para, we had further recorded in our order dated January 7, 2025 that already a last chance had been given to the appellants. However, comma, a further chance was given to the appellant to file proper vokalatnama. Next para, since the appellant chooses to abstain from the hearing even today, comma, SAT 498 of 2013 along with can 1 of 2013 within bracket old number can 10578 of 2013 bracket closed, comma, can 2 of 2013 bracket old number can 11422 of 2013 bracket closed, and can 3 of 2015 bracket old number can 4414 of 2015 bracket closed are dismissed for default without any order as to cost. Thank you. 13 ম্যাটার ফেলে দিচ্ছি। 11 বছরে যদি টাইম না থাকে দেখি দিন শুধু অর্ডার। হ্যাঁ consecutive occasion when none appears for the appellant at the time of call. Full stop. In our order dated January 9, 2025, we had given a last chance to the appellant to appear and argue the case. Full stop. However, even today none appears for the appellant to argue the case at the time of call. Full stop. Accordingly, FMA 1292 of 2022 is dismissed for default. Full stop. Interim order, if any, stands vacated. যদি অর্ডার করতে স্টেজ তখন অনেক সময় ভুল করে দিয়ে দেয় অর্ডার করতে এটা একটা লিস্ট অফ ম্যাটার এটা সেম অর্ডার ওই এক্স্যাক্টলি এটা ওই যে অসিত ভট্টাচার্যের দুটো অর্ডার 24 appeal. আচ্ছা আপনি সেম লাস্ট চান্স দিচ্ছেন থাক করে যখন রেজিস্ট্রেশন করতে আসবে শুনে দেবো সেম অর্ডার তখন ফালতু লিস্ট বড় করে রাখিস Thank you, man.
I'm for the appellant. Coming below under the order 41, below refusal of my ad interim prayer for injunction. So the association is being called below Association of Physicians of India. It's relating to doctors. Below this association is being formed. Below the apex body is below the Association of Physicians of India, which in short called below API. It is the apex body, but in every state, there is a the other committee that has been framed. It's basically for promotion and for holding conference to promote the other ideas of this doctors fraternity. Ideas and the ideologies of these doctor fraternities, for which every 4 years or 5 years there was a procedure for holding conference in every states. But what is the procedure that for the purpose of holding this conference, the state of West Bengal, they will send the name, proposing the name of for holding this conference and organizing president and organizing secretary.
Mr. These West Bengal branch and the branches are also registered societies.
Yes, they have other bylaws.
The branches are also separate registered societies.
The procedure suggests that the state will not recommend the name of the organizing president and organizing secretary to the apex body, and thereafter they will hold a meeting and approve the name of who will be ultimately selected as an organizing president and secretary for holding this conference.
Yes.
But for that, I should apprise before your lordship the rules first. That has been annexed the constitution. Your lordship's brief that starts with page 48 in the CAN application, CAN 1.
Yes.
Page 48, your lordship straight away comes to rule 17, that is at page 57 of my lord's brief. May I place rule 17?
Yes.
API West Bengal branch from time to time may get the responsibility to organize EPICON annual conference of API. Under such situation, the names of organizing secretary, organizing chairman, and organizing committee has to be proposed by the EC committee to API West Bengal branch. It is also to be confirmed by the general body meeting of the API West Bengal branch. So, ultimately, this has to be ratified.
It has to be proposed by the central owner, the EC committee of the EPA.
Yes. Now, if your lordship takes up the next page, it is for holding conference for the year 2024 initially.
Right.
But due to this COVID pandemic, this has been postponed now in 2025.
Sorry. Yes.
In the month of January, it's now going to be happen. The
pandemic. There was no pandemic in 2024.
No, it has been
2020.
Yes, this committee has been approved sometime in 2020.
Right.
I will place this This is to inform this email communication. This is to inform you that a meeting of API governing body of API will be held on Sunday, 5th January 2020 at Hotel Joypai Palace and the Convention Center, Faridabad Road, Tajganj, Agra, UP. Agenda for bidding.
This was the West Bengal meeting to be held there.
No, Milord, it's
Central.
the West Bengal. Yes, Central. Milord, thereafter the ratification I shall place. The agenda for bidding Epicon 2024 has your lordship got, Milord. This is we'll discuss. You are requested to be present and such and such. Now, Milord, if your lordship turns over, ultimately, Milord, this Milord, page 50, page 66 of my lord's brief. I do not know, Milord, how much legible is this. Milord, in my copy, it's
more or less legible.
Milord, may I read for your lordship? Milord, this is to
yes.
This is to certify that as per the decision of 75th Annual General Body Meeting held on 6th January 2020, held at Agra, considered the application received from API West Bengal chapter for the venue of Epicon 2024 at Kolkata, West Bengal chapter. The organizing chairman will be Dr. Mrinal Kanti Roy and the organizing secretary Dr. Shubhendu Ghosh, the appellant before your lordship. This has been fixed, Milord, and ratified by the apex body sometime in 2020 for the purpose of holding conference in 2024.
Right.
Now, the purpose of filing my suit is, Milord, kindly takes up, Milord, page 112. Two letters, Milord, prompted me to file this present suit. Now, the existing secretary of the West Bengal, Milord, state of this body, Milord, is writing as per Epicon norms. Has your lordship got, Milord? This is our communication, Milord.
Yes, got it.
As per Epicon norms, headquarter API is supposed to send a letter to the state chapter asking the name for organizing secretary, which will be adopted in governing body meeting on 24th February at New Delhi during Epicon 2024. API West Bengal chapter will decide the name of organizing secretary in its EC meeting, which will be held only after receiving letter from headquarter about the same. Therefore, declaration of name of the organizing secretary does not arise now. Further, you may send document as attachment why you are saying to declare you now as organizing secretary. So, Milord, they are, Milord, denying whatsoever that has been happened, Milord, in 2020. They want that, yes, now the name has not been proposed. So there is no question. We are sending name and ratification is far less. Now, Milord, we wrote letter, Milord, to them in pursuant to this, Milord, communication that this has been done long back. And ultimately, in reply.
No, this was ratified by the general body. This page 66 was ratified by the general body. As per your norms, it has to be ratified by the general body.
General body, Milord, it has to be ratified by the general body of API.
No, page 57.
Page 57, Milord.
Organizing chairman and organizing committee has to be proposed by EC committee of API West Bengal. It is also to be confirmed by general body meeting of the API West Bengal.
Yes.
So all these were over.
All these over. Thereafter, it has been sent to API, Milord.
And they have also confirmed.
They have also, Milord. This is, Milord, what communication I have shown before your lordship. Kindly takes up, Milord, page 66 for the sake of verification.
Yes.
It's the top, your lordship will get the Association of Physicians of India. So it's the apex body. So after,
as per the decision of the
yes. So initial stage is from Milord West Bengal.
Consider the application received from West Bengal chapter.
So they are ratifying, Milord, they being the apex body, they are ratifying and they are selecting us being an organizing secretary and organizing, Milord, chairman.
Very well. So they are trying to reopen that.
Reopen the issue. I wrote letter in reply to such, Milord, the page 139 is, Milord, the last cause of action for filing my suit. Third line, Milord, third paragraph from page 139. That API West Bengal has its executive committee meeting on 21st September 2023, which was attended by your client and unequivocally concluded. Letter mentioning approval of your client as organizing secretary has not been approved by the executive committee prior to or after 5th January. that your client ought to have apprised you that all about the happenings that taking place in the executive committee meeting on 21st September 2023, as also the special general body meeting of API West Bengal chapter held on 12th of October 2023. My entire case is based on, if according to the rules you have already selected, you have exercised your right, send it to the apex body and apex body approved it. Without cancellation of that, you cannot go on again appointing someone else. Kindly see now, Milord, what Milord I have prayed for in the Milord injunction application. Only the prayer portion, Milord. Page 85 it starts. Basically, Milord, prayer B.
Page 85.
Page 85, Milord, the prayer starts, Milord. Application starts, Milord, of my injunction application from page.
The suit is for what? Whatever.
Yes, Milord. Suit, Milord, I have annexed the plaint. Plaint is at page 29, it starts. Prayer, your lordship will get, Milord, at page 42. I prayed for a declaration that the communication that has been made by the Apex Committee on 15th of January 2020, whereby I have been selected as an organizing secretary, is a good and will not permanent and consequential injunction will not apropos to that.
When is the conference scheduled?
Conference, Milord, now after this, Milord, this has been scheduled on 24th, 25th and 26th January 2025. This is, Milord, during the pendency of this, Milord, appeal before this. Now kindly once looks at, Milord, the order impugned.
We have no time at all.
Kindly see, Milord, once the order impugned, Milord, because I must be candid before your lordship being an officer of
If you grant an injunction, Mr. Mukherjee, there would not be any representation of West Bengal there.
No, Milord, representation of West Bengal has to be there because my name is being ratified over there.
That would be allowing the suit.
Milord,
what has been held by
page 137, kindly see, Milord.
Yes.
The perused injunction application from the middle, its enclosure and case record consider having regard the learned advocate, plaintiff, petitioner, and taking into entire facts and circumstances into consideration, this court has come to a conclusion that it would not be appropriate to pass any order at this stage without hearing the other side.
And the injunction sought was?
But the injunction sought for that I was placing from the injunction application, if your lordship takes up page 86, prayer B.
This will be granting the main relief.
Milord, this kind of suit, Milord, I can say, Milord, this is something, Milord, which can be asked for at the threshold. Because if had it been a case that they could be able to satisfy to us that yes, they have, Milord, altered the name and that has been further ratified by API.
They have not yet been heard.
No.
Have you deposited the requisites in the court below?
Lord, I believe, Milord, since that order is being challenged before your lordship, that is, Milord, I have to take instruction. Milord.
If you have not, then Mr. Mukherjee, no.
May I serve and, Milord, try to come back, Milord, prior to 24th?
Yes, definitely.
That much, Milord. If they can throw light on it, yes, there is a ratification by API, Milord. There is, Milord, I will be out of court, provided that they will have to say that why, Milord, they have not changed, Milord, the earlier ratification. That is the small scope.
The present appeal arises out of the refusal of an ad interim injunction prayer of the plaintiff petitioner appellant. First of the appellant claims to have been nominated as the organizing secretary for the conference of the API to be held at the national level for the year 2025. It is informed to us that the said conference has been scheduled between 24th and 26th of January this year. January this year. Full stop, next para. The learned trial judge refused the ad interim injunction primarily on the ground that it would not be appropriate to pass any order in this case without hearing the other side. Full stop. We are faced with a conundrum, since on the one hand, grant of the relief as sought here might tantamount to decreeing the suit itself, due to identity of the ad interim prayer in the injunction and the relief sought in the suit itself. And on the other hand, that unless the injunction is granted, the suit itself would be rendered infructuous. Push up. In order to obviate such situation, we deem it proper for the appellant to serve a copy of the application along with a copy of the memorandum of appeal on the how many respondents? On the respondents. Obviously, they have not appeared in the today.
5 respondents.
On the respondents, by whatever mode, and file an affidavit of service to that effect on the next returnable date. Full stop. Learned counsel for the appellant shall also produce before us the necessary documents to substantiate that requisites have been put in terms of the order, impugned order dated February 20, 2024 in the code below for service of notice on the defendant stroke respondents in the code below, also on the next returnable date. First up, the matter shall next be listed on 20th, we are keeping
20th.
On January 20, 2025 under the same heading.
Would it be your lordship's pleasure to admit it under order 41 so that on that day we can not deliver on this application itself?
No, no, we are not. We make it clear that because this may be
Yes, that's why we not.
You're right. It is made clear that the appeal has not yet been admitted under Order 41 Rule 11 of the Code of Civil Procedure, but we intend to give an opportunity of hearing to the respondents even at the stage of admission under Order 41 Rule 11 of the Code of Civil Procedure as an exception, in view of the peculiar nature of the relief sought.
I'm grateful. Otherwise, not on that day they can come.
They don't have a right.
Say,
yes.
Order 41.
And they don't have a right, but we
yes,
can.
Yes, still clarifying that.
Great. You're right, Mr. Open. Thank you. সেই অসিত ভট্টাচার্য ম্যাটার আবার তন্ময় আগেরগুলো যেগুলো ডিসকাস করছিলাম যে নান অ্যাপিয়ার্স আমি বলছি কোনটা এই 28 29 যেগুলো যাচ্ছে হ্যাঁ
Lordship, item number 32. I appear for the petitioner appellants. Lordship, I have just been briefed. 30 minutes.
No, it was the last chance given to you.
My lord,
on the last order, it has been recorded.
Only 1 day's time to prepare, my lord. I did not appear.
Learned counsel for the appellant seeks an adjournment for a day, full stop, although the matter was fixed as a last chance, since it is submitted by learned counsel that she has been briefed today itself, we grant an opportunity to the appellant to argue the matter under Order 41 Rule 11. Full stop, accordingly, let the matter stand adjourned till tomorrow.
Be obliged, my lord.
Lordship, I appear on behalf of the appellant.
Yes. What is it?
Lordship, this is my appeal. Lordship, challenging the from the refusal of ad interim order of injunction, Lordship.
Application is appearing today?
Yes, sir.
Yes, yes. Refusal of ad interim, what is the matter about?
Lordship, if I may kindly encapsulate the facts, Lordship. This pertains to a club, Lordship. The club primarily their activities are into football and cricket. It's called the Bengal Sporting Club, around 105 years old. It's a non-registered club, but
Then,
affiliated with the CAB as well as the Football Federation.
So then the club cannot maintain a suit. You are not the club.
No. Lordship, what had happened is there was already a committee which was representing the club and which was operating. Suddenly, what happened? There has been an infight between the members, and
there is one string of members who now operates the club from a different address which was not known to the other members. The appellant before this honorable court and the plaintiffs before in this trial court below are the two members of the club, my lord. Now, what has happened, Lordship, it appears that that there are a lot of funds which has been given to the club over a period of time from CAB as well as the Federation of Football, Lordship. And now what the present or the incumbent members are trying to do, or the members who are part of that board, they are trying to withdraw money from the account of the club and not acting in the welfare of the club. Lordship, I have the impugned order, Lordship, would start from page 72. Effective is from 74, Lordship. The learned court below takes note of my submissions, and straight away at page 75 comes to the finding that upon consideration of the submission made by the learned advocate of the plaintiffs, as well as regards to the copies of the documents furnished on their behalf, I do not find presence of any exigencies involved in the matter.
We also don't find any exigency. Why should you interfere with this?
Lordship, what has happened is this particular
First of all, we have some doubt whether the suit is maintainable. You are trying to defend the interest of a club, which is not a registered body even. So it is not a juristic entity. So you can file the suit in your independent capacity, but that cannot be to espouse the cause of a club. That club does not exist in the eye of
member, Lordship, I as a member, because what has happened.
Member of what?
Lordship, the member of a club who had its address in a particular premise. Now, certain members of the club are now claiming to be.
Don't have a right. The club does not have a right to have an address even. And there is no legal right which you are espousing. You, as an individual member of a club which is not a registered body, is not a juristic entity in the eye of law, cannot espouse the cause of the club even. Because the club is not a juristic entity, your entire cause of action is on the, you are trying to espouse the cause of a non-existent juristic entity. If you had a personal axe to grind, we could have understood. But this is not anything personal about you. You are espousing the cause of the club. You are saying that the club's address has been removed elsewhere. There is no club in the eye of law. Where is the question of, where is the bar in its address being shifted somewhere else? I say I am a club.
Lordship,
I say I am a cauliflower, and I say
Lordship,
I have grown elsewhere. I mean, if I am not a cauliflower, registered cauliflower, I cannot be recognized as a cauliflower in the eye.
It was recognized.
Although I may look like a cauliflower, but I can't be recognized as one.
No, Lordship.
You may look like a club. You are espousing the cause of a club which is not existent in the eye of law. How can you, as a member of a non-existent juristic entity, espouse a cause? Better to say that we don't find anything to interfere rather than say these things. That will hit your suit at the root.
Lordship, the club has been in operation for over 105 years.
A group of people. A group of people.
Because I could not find anything to
suggest group of people passing off as a club. If it was registered, your plaintiff should refer.
Yes,
should refer to it.
It is registered with CAB, Lordship, that it says, which would appear at page.
It has to have an independent identity.
Lordship, at page 22, the club is registered as an associate club with the CAB, an Indian Football Association.
What injunction we want now? We won't touch the maintainability of the suit here. That will, I mean, ruin your suit unnecessarily. You may have a case, you may have, sorry, Lordship, the pleadings may be insufficient.
Lordship, all that, Lordship, my prayers are at page 51, Lordship, the prayers which I had made before the learned court.
Yes.
Restraining the committee members who have been illegally appointed by way of a resolution dated 9th of August.
No, the club will be then non-operational, defunct.
Lordship,
this injunction, if granted, would
Lordship, the alternative
paralyze the club.
Lordship, there was already a board, Lordship, my prayers at B, prayer B, Lordship, an order of temporary injunction restraining the defendants number so and so from interfering with the discharge of duties and functions of the previous surviving committee members.
Have you challenged an election?
Lordship, there was no election.
How can they be previous surviving committee members?
That is, Lordship, there was already a body which was functioning, the resolution suggested.
How was that formed? Without any election also?
Uh,
There is
that-
nothing mentioned here.
No, it does not find.
You are only members of the club. You are not the previous surviving body.
No, I am.
You have no locus standi. The more we proceed, we see that is nothing in the suit. Intent should be rejected. Non-disclosure of cause of action,
Lordship,
not
because-
maintainable at the behest.
Lordship, now what has happened, the new management is
What
issuing.
management?
Issuing-
Your management, new management, the old management was not properly elected. You have articles of association.
Lordship, since I
Since you are not registered, you cannot. Then what is the law which governs you? There is no law which governs you. You are not an entity at all. So if there is no law, there cannot be an infringement of a law. Unless there is an infringement of a legal right, there cannot be an injunction or a suit. Basic jurisprudence, section 34, injunction. So you cannot file a suit even. We'll just say that we don't find any reason to interfere with. The present appeal has been preferred against refusal of an ad interim injunction at the behest of the plaintiffs stroke appellants. Full stop. The plaintiffs claim to be members of a club. Full stop. Next para. It is argued by learned counsel for the appellants that the learned trial judge ought to have granted injunction in order to ensure that the illegally appointed committee members cannot represent the club, alternatively, the discharge of duties and functions of the previous surviving committee members cannot be interfered with by the defendants. Full stop. Next para. However, on the materials on record, we are not convinced about the rules and regulations governing the election process and or the validity of the so-called surviving committee. Full stop. Unless there is a legal right on the strength of some law and or bylaws stroke articles of association, there is no question of any infringement or breach of any legal right to justify grant of injunction at this stage. Full stop. Moreover, the learned trial judge was justified in recording that no pressing urgency is found from the averments made in the injunction application. Full stop. Hence, we do not find any illegality in the impugned order so as to justify the admission of the appeal. Full stop. Accordingly, FMAT 1447 of 2024, FMA 1447 of 2024 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, Can 1 of 2025 is also dismissed. Full stop. There will be no address to cost. Full stop. Next para. It is made clear that the merits of the disputes between the parties have not been gone into by this court. Sorry. Yes.
I am appearing for the appellant, my lord.
Yes, on the last occasion, we were given the impression that it was against a preliminary degree. It is not.
As a matter of fact, my lord, that day I was very perturbed due to the death of Mrs. Kajuri Dhar.
Yes,
And
we
she
did
was
not
the-
even look
she
into
was
the
the
papers on
member
your
of the
submission.
Bar Library Club, and she was the mother of my junior.
Oh, achha. No, we appreciate, but we did not even look into the papers on the basis of your submission only.
That file
And we
was-
passed the blanket order, but
That file
later had
was
to
not
recall.
here. On that day.
No, the
it
main file was
indicated
here.
in the-
Main file was there. Can was not here.
Can was not there.
Anyway, let us hear you on the appeal. Order 41.
It is arising out of the order passed by the learned fifth bench City Civil Court in order 40 Rule 1. There is a rejection. that
What is the
was
suit?
rejected
What is the suit for, Mr.
appointment
Mukherjee?
of a receiver.
Mr. Mukherjee, what is the suit for?
Suit is for partition, suit for partition and accounts and declaration. That is the
Where is the receiver application?
receiver application is I have
Achha, the
Annexure A. Annexure B. my lord.
It was an ex parte dismissal.
No, my lord. It was
Oh,
contested.
both, acha.
And may,
And she's
my
entitled
lord,
to the
I
share.
invite the attention of your lordship at page 15, initially. That is Farizanama. That is Farizanama according to, may I please, my lord?
Please, yes.
According to Muslim personal law,
Yes.
that is the question. What is your opinion, verdict, direction, Islamic
This is
order?
from the Qazi.
Yes,
From the Qazi.
no, from myself, my lord, I applied before the.
No, this is issued by the Qazi. Faraznama has to be issued by the Qazi. Yes.
Yes. Shahi Imam.
Shahi Imam, very.
Shahi Imam.
Yes.
Shahi Imam. It was issued. And I applied. What is your opinion, verdict, direction, Islamic order regarding the deceased late Muhammad Nazir? Muhammad Nazir is my father.
Hmm.
And of 7C, Maulana Abdul Razak, Maliabad Street, Calcutta 16, is the suit premises.
Right.
Died and left behind his successor, heirs, Varishan, one wife, Rasida Begum, one son, Muhammad Zahid. Rasida Begum is respondent number 2, and Muhammad Zahid, my brother, is respondent number 1. And 3 daughters, one Nasimara, that is myself, that is appellant. 2 Nurjahan, my sister, and 3 Farida Begum, my sister. These are them. And answer according to Muslim Farizanama, Muslim personal law, as per statement, deposition, question, and circumstances. After the payment and clearing of all the dues and funeral expenses of late Muhammad Nazir, entire properties will divide into 100%. One wife, Rasida Begum, will get 12.50. One son, Muhammad Zahir, will get 35%. And 3 daughters, namely Nasim Ara, will get 17.5. Nurjahan will get 17.5. And Farida Begum will get 17.5 out of 100%, according to Muslim Farizanama, Mavanla Muslim personal law. That was the issued by Shahi Imam and Mufti Azam, West Bengal. That is my share.
So they filed, what is the written objection? Why haven't you annexed the written objection? You only annex the order 40 rule 1 application. Written objection is vital.
Comes to the impugned order passed by the.
No, where is their written objection? You have annexed only your receiver application. But their written objection is equally important to us, at least, not to you, maybe.
Objection is not there.
We don't know their stand. You have to annex their written objection, at least. Part of the pleadings. Pleadings for the purpose of the receiver application.
Lordship, I have annexed the.
They have filed a written objection.
Impugned order passed by the.
No. You filed your receiver application. We are required to look into their version also. The defendant's version was put by way of a written objection. Why haven't you annexed it even? Have you got a copy of the written objection? Without the written objection, how could you write the appeal?
In that case, kindly give me the opportunity.
And now we don't find any irregularity in the order. They make a claim that there was an oral hiba, which is a conflicting claim that will be decided in the suit. Why receiver should be appointed?
Receiver for the prevention of my right and to preservation of the property. My property is getting dilapidated. Kindly comes to the.
Receiver will oust the possession of somebody. No, you ask for receiver to collect rent.
Kindly comes to page number 24. That is it is a G+4 building, my lord, and number of tenants is 25 tenants.
Very well, yes.
25 tenants.
So you have
Therefore,
the entire thing.
It is very difficult to preserve the property unless it is looked up and administration and management is being taken up by
no defendants are in
court
possession
officer under the
defendants.
supervision.
They are paying their rents to the defendants.
No, I am not getting the fruits of the rent.
Where is the plaint? Where is your plaint? At least let us see your the plain prayer.
Plaint is, I
What is the suit for? We don't even know that. Let us see the plain reliefs once.
is the plaint. Okay, the plaint. Huh? Okay, sorry, my lord. I'm.
Well, lucky that we have got one copy. Please search. You will find the written objection also there. Please search well. You will find your written objection there. Partition. Share claim করেছে accounts ওখানে ডিক্লারেশন চেয়েছি অ্যাকাউন্টস চেয়েছি ইনফরমেশন ঠিকই অ্যাকাউন্টস তো শুটেই চেয়েছি রিসিভার বসিয়ে দেওয়া মানে উচিত হয় না অবজেকশন নেই কিছু নেই inclined to admit the appeal because it will be premature to appoint a receiver. They have taken a counterclaim that by an oral hiba your predecessor had transferred the property to them. So unless both sides establish their cases on evidence, and in your suit, in any event, you have asked for accounts also. So if you get those accounts, you'll get everything.
Well, kindly
interference.
Kindly protect me.
No,
I am a helpless.
You can file an
I am
injunction application. You
helpless
can file,
minor.
you can file an
Kindly protect.
application for accounts also.
Minor sons, son and daughter.
Maybe, but you are already in possession of a flat. You are not helpless.
By virtue of a property, I purchased that property. I purchased that property. My lord.
No. Your plaintiff case is the plaintiff has filed this petition on the ground that though the plaintiff is in possession of one flat in 4th floor of the suit premises, being co-sharer, the defendants are not paying her share of the rent.
I have.
It is not your independent purchase property. As per your plaintiff, you are a co-sharer there also.
My lord, kindly take up the matter.
No, we have taken up the. We have seen no interference.
My lord, kindly.
No. You
kindly appreciate
the suit will be decided on this matter. No receiver.
The predicament of the appellate.
There is no predicament. What is the predicament? You are enjoying your flat. Enjoy. Go on enjoying it.
By virtue of the purchase, I'm enjoying the flat, my lord. I shall furnish everything before your lordship. Kindly give me an opportunity to furnish all the documents.
What document? Tell us.
The documents by which I have purchased the property. I can. I can show your lordship.
No question of purchase of property. We are not on your flat, Mr. Mukherjee.
Yes,
we are on the common property, which you are saying is joint property. You have only just produced. You have obtained a faraznama under Muslim personal law from the Shahi Imam, and that is your only document to show that it's a common property. Whereas they rely on an oral hiba.
My husband has purchased that
maybe
flat.
Keep it with you. We are not concerned with the flat.
Flat number 26 is.
Because you don't understand at all. We are not bothered with the flat. You be happy with your flat. You may have purchased it. You may be a co-owner. Your relief is not regarding that flat. You have sought relief for appointment of receiver regarding the other flats, the other properties. You have given a list of those properties. Why should a receiver be appointed at this stage? You could have asked for accounts also. Receiver is an extreme relief. Unless you can show that they are trying to siphon off those funds or doing something else, mismanaging the property. Receiver is not readily granted. Receiver is a higher relief than injunction. Because you know that.
My lord, I am the co-sharer of the property.
As a matter of right, injunction maybe yes, but as a matter of right, you are not entitled to receiver. Definitely not.
Well, no cogent reasons have been assigned, and no
oral hiba, that
no judicial notion has been displayed.
No.
In the order.
No, Mr. Mukherjee, sorry. The present appeal has been filed against an order whereby against an order whereby the petitioners
This is the observation, not assigning any reason.
আবার গোড়া
my
থেকে
lord.
বলছি the present appeal has been preferred against an order whereby the plaintiff stroke appellant apostrophe s application under order 40 rule 1 of the code of civil procedure comma for appointment of a receiver to collect rents of the subject property comma was rejected. Who's up next para? The learned trial judge proceeded on the basis that the defendants submitted that the share of the plaintiff is not admitted by the defendants. Full stop. Moreover, comma, it was observed that the defendants numbers 1 and 2 claim that during the lifetime of the predecessor in interest of the parties, comma, the said predecessor, namely Muhammad Nazir, had executed an oral hiba, thereby transferring the property in favor of the said defendants. Full stop. Next para. The learned trial judge proceeded on the premise that the respective contentions of the parties cannot be substantiated unless the suit goes on trial and evidence is adduced by the parties. Full stop. Next para. Learned counsel appearing for the appellant submits that in terms of the Faraiznama, FARAIZNAMA, obtained from the concerned Shahi Imam, comma, the parties have joint shares in the property in dispute. Full stop. Learned counsel also relies on a list of the alleged tenants as per Schedule B of the receiver application, comma, to indicate that the rent of the property is required to be collected by the receiver. Full stop. Next para. We find from the impugned order that the learned trial judge has taken one of the plausible views possible in the facts and circumstances of the case. Full stop. It is well settled that the appellate court does not substitute its own views for that of the trial court, comma, merely because another view might be possible in the factual matrix. Full stop. Next para. That apart, comma, it would be premature at this juncture to appoint a receiver to take control of the rent collected from the subject premises only on the basis of the Faraznama and in the absence of any evidence being laid to corroborate such Faraznama and the contents thereof. Full stop. Next para. Also, comma, the tests for grant of receiver stand on a much higher footing than even injunction, and the plaintiff, comma, as a matter of right, comma, is not entitled to get an order of appointment of receiver, comma, displacing the existent persons who might have control over the property. Full stop. Next para. Hence, comma, we are of the opinion that there is no scope of interfering with the impugned order. Full stop. Accordingly, comma, FMAT 477 of 2024, sorry, FMA 1753 of 2024 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, Can 1 of 2024 is also dismissed. Full stop. It is made clear that we have not entered into the merits of the disputes between the parties, and it will be open to the learned trial judge at all further stages of the suit and interlocutory stages to decide all issues independently in accordance with law without being unduly influenced by any of the observations made above. No address to question. Thank you.
Excuse me, kindly bear me for a moment.
Yes.
Leave may be granted to ask for the accounts only.
Nothing in your order shall prevent the appellant to approach the learned trial court to seek other reliefs such as injunction, comma, accounts, etc. Full stop. If such relief is sought, comma, the learned trial judge shall dispose of the same in accordance with law upon giving adequate opportunity of hearing to the contesting defendants. Full stop. Thank you.
I'm grateful.
Thank you, sir. Next.
May I take back?
Take back what?
Copy of the
Plaint ফেরত দিন। Thank you. Yes.
I am for the appeal.
It was bartered.
It was part of.
Yes.
At the very outset, my lord, in this matter, I am led by Mr. Banerjee,
Mr.
Haradhan Banerjee. My lord, he was hospitalized in the last week.
Hospitalized?
Just today morning, he has been discharged.
Actually.
But if my land defense completes his argument today, your lordship may kindly be pleased to take up this matter next Monday.
My lord, I would rather, my lord, pray for my lord taking up it on next Monday. Otherwise, my lord, it was, my lord, taken up by your lordship, my lord, before, my lord, the
continuity will be lost.
Continue, my lord. Again, my lord, I have to, my lord, recapitulate.
Start again, yes.
My lord, next Monday, my lord, on consecutive days,
On the prayer of the respondents, the matter is adjourned till January 20, 2025.
Great.
Thank
Great.
you.
My lord, I'm appealing for the appellant.
Yes, said.
But plaintiff is the appellant. Before my lord, in a suit.
Take the microphone.
In a suit for my lord, specific performance of contract. Now, my lord, in a suit for specific performance of contract. Now, the suit, my lord, is dismissed ex parte, my lord, on the ground that, my lord, the specific performance which is sought cannot be allowed on the ground that the vendor, my lord, is not having title. So, my lord, I cannot allow this performance of the contract. Now, my lord, what happened, my lord, here is, my lord, originally the property was leased, my lord, by the original vendor in favor of, my lord, a person named Khimjis, my lord, for constructing over the property a multi-story building, my lord, for 75 years. Now, my lord, with a condition that it will be further extended. Now, my lord, a multi-story building came up.
Other side is not appealing.
No, my lord, I have filed an application CAN 3 that was allowed because the other side had not contested, my lord, for dispensation of service, my lord, upon the other side. They have never appeared. They have never filed written statement.
All right, very well. Yes. So Khimjis, 75 years lease for Khimjis.
Khimjis.
Before your agreement.
Before my agreement.
Yes.
Khimjis constructed, my lord, the building.
Right.
My lord, with a partnership with, my lord, Padma Balwani, Gulbari, and my lord, others. And my lord, the property which was constructed, it was named as Gulmohar Properties. Now, my lord, in the Gulmohar Properties, my lord, my vendor,
yes,
my vendor's predecessor, my lord, engaged into, my lord, an agreement for sale from those Khimjis and Balwanis. Now, my lord, though that agreement, my lord, that though it was not registered, but there was a condition, it can be assigned to third party. My lord, my vendor's predecessor, my lord, assigned it to my vendor, who is, my lord, Mr. Singh, Mohan Singh, my lord, who is the respondent hearing. And, my lord, deed was executed in favor.
Khimjis, your vendor's vendor.
Yes.
What was the name?
My lord, there were 4 or 5 persons.
Anyway, vendor's vendor had agreement for sale with Khimji.
Yes.
Who gave the lease in the first place? Those vendors?
No, original owner, they were, my lord,
You said your vendor gave 75 years.
No. First, my lord, it was in the year 1964. Lease
were not, your vendor were not in the picture.
Not in scene in 1964.
So 1964, first owner gave 75 years lease to Khimji. Khimji built Gulmohar apartment.
Yes.
Your vendor's vendor entered into an agreement for purchase from Khimji a particular flat or what?
Flat number 60.
Flat number?
61.
61. So then
along
vendors,
with car parking.
Along with?
Car parking.
Yes. So there was a clause in that agreement for assignment.
Now, my lord, my vendor's vendor, my lord, assigned it to my vendor. And, my lord, a deed was executed, agreement for sale was granted in favor of my vendor.
The vendor's vendor assigned to your vendor?
Yes.
By way of a?
My lord, registered deed of sale.
Deed of sale?
Yes, my lord, he assigned in my favor, and, my lord, that assignment was accepted by that vendor, and an agreement for sale was entered into. Deed of sale was conveyed.
Vendor's vendor assigned to, you have reached up to vendor's vendor assigning the property to your vendor's state.
Yes.
That was done by UEFA registered deed of sale.
No, that was, my lord, intimated to them. They accepted it, and, my lord, that my vendor's vendor directly sell to my present vendor, Mr. Mohan Singh, respondent. He assigned-
Vendor assigned their rights to your vendor.
Yes, my lord.
Your vendor again assigned it to you.
My vendor will not sold it to me by, or rather entered into the agreement for sale, which is sought to be enforced now. And my vendor's vendor, Milord, he, or rather my vendor, Milord purchased it from Milord, the Balwanis and the Khimjis, from the rather Gulmore properties.
When did he purchase?
Milord, he
What was
purchased-
the name of your vendor?
My vendor is Milord, Mr. Singh. Yes, Mohan Singh
ভুলে
Chopra.
গেছি। ফাইলটাই ভুল। Vendor, then we would have understood that this is a wrong thing.
Milord, my vendor is Mohan Singh Chopra, the respondent.
ও আচ্ছা। Mr. Chatterjee,
Yes,
we have
sir.
got up to this.
Yes,
If
Milord.
clear up to that, your vendor's vendor had an agreement for purchase, got a right to purchase the property by an agreement from Khimjis. Now that vendor's vendor,
Milord, may I just start once again, Milord? This Khimjis in the Milord dates, Milord, 3rd August 1964, Milord, Khimjis were given lease for 75 years by the original owners.
Got it. Yes. Next.
Now, Milord, this Khimjis, Milord, with a partnership agreement, Milord, with Padma Balwani, Gulwari, Kisen, and Arjan, Milord, constructed the Gulmohar property.
Yes.
Now, Milord, in 1968, 1st of September 1968, Gulmohar Properties agreed to sell Ashok Balwani and Sri Padma Balwani the flat number 61. Now, Milord, what happened, Milord? In 71, Milord, in that agreement, there was a clause that the Ashok Balwani and Padma Balwani could assign the Milord sale to his person of his choice. Now, Milord, in 71, 12th of November 1971, in a tripartite registered agreement, Milord, my vendor was sold the flat number 61 from the Gulmohar properties, keeping Ashok Balwani and Milord, my vendor as a Milord purchaser.
By tripartite registered?
Registered deed of sale. That was Milord done,
Sold
Milord.
to whom?
Milord, my vendor, Mohan Singh Chopra.
All right.
Now, Milord, Mohan Singh Chopra in 1977.
Tripartite between whom?
Gulmohar Properties, who constructed the building. The Balwanis, with whom Milord Ashok Balwani and Padma Balwani, with whom it was originally agreed to
And
sell.
Mohan.
And Mohan Singh Chopra.
Right, very well. Then Mohan Singh entered into an agreement for sale to you.
To me. This agreement was sought to be enforced.
What was the date of that?
21st of January 1977.
7.
So
now you seek this specific performance.
Yes.
Why refused?
Milord refused on the ground that my vendor, Milord, that the Khimjis, Milord, traced from Khimjis didn't have the title. So, Milord, the title.
Right. How can a lessee sell a property?
Now, Milord, yes. Now, in the agreement, what was sought to be it was nomenclatured as agreement for sale. But in the contents of the agreement for sale is whatever right Mohan Singh Chopra had.
Let us see the agreement.
Yes. Now, Milord, kindly takes up the agreement.
Yes.
Paper book, Milord, page 34.
Yes.
Now, Milord, I'm not troubling with the Milord recital parts.
No.
Milord, directly. Kindly comes to Milord, page 42. Now this presents witness and it's hereby agreed. Milord, I'm skipping over the first part. It records flat number 6 with easement right to park together with Milord. Lastly, Milord, I'm.
But vendor agrees to sell.
Yes, Milord.
Purchase agrees to purchase the flat. How can
Yes.
this be?
Now, Milord, kindly cease. Last portion, my lord, taking continuity.
Page 42 itself.
Yes, last line. And also together with.
Yes.
Rights and benefits reserved by the said conveyance dated 12th November 1971 to use the lift, staircase, open space, main entrance and other common paths or passages in common with owners and occupiers of other flats of the said Shalimar apartment for the purpose of access to the municipal road subject to, this is important, subject to the rights and privileges reserved by Gulmohar properties. So, my lord, whatever right Gulmohar properties had, my lord, I will be conveyed this. My lord, at least he is conveying today upon me, my lord, by this agreement, the whatever right Gulmohar property reserved it.
And also together with these rights.
Also together with these rights.
So together with these rights, he sells the entire flat to you.
Yes, my lord. Now, my lord, the question is, my lord, he has a right, my lord, if it's taken as a lease for 70.
After all, specific performance is a discretionary relief. Court can refuse.
No, my lord.
Court has refused.
No,
and on valid grounds. You cannot sell what you don't have. You don't have title. Your vendor does not have title to the property.
Now, my lord, vendor can give the lease. My lord, my lord
Residuary lease, yes.
Yes, residuary lease. My lord, lease is for 77 years.
He does not do that.
My lord, he gives all the right with the Gulmohar properties.
No, he says agrees to sell and purchaser agrees to purchase. Purchase all that flat number such and such. Then whatever comes next is with the adjunct together with.
Yes, absolutely.
Together with this together with continues. So he gives all this. He sells the property to you. Sells the Taj Mahal to you.
Yes, Taj Mahal.
And then says, and yes, I also together with rights and benefits reserved by the conveyance, which is confined to using the lift, staircase, etc. for the purpose of access to the main municipal road. That is subject to whatever Gulmohar properties.
Yes.
So that limited right of access, that is subject to what Gulmohar had. But the entire flat he has, before that he has sold to you.
Because, my lord, if my lord takes up the recital, my lord, when tripartite agreement was entered, Gulmohar properties, my lord, sold the flat to my lord Mohan Singh Chopra.
Same thing, Gulmohar also had
my lord, whatever right he had, Gulmohar, it transpired or fall into my lord Mohan Singh Chopra.
Right.
Mohan Singh Chopra, my lord, whatever right he has, my lord, it falls upon or transfers upon me if I have a right of lease.
So this whatever right goes into an infinite regress into nothingness.
No, my lord,
because you don't have any title. Gulmohar never had any title.
No, title, my lord, but I have a right to, my lord, if it's a lease, my lord, for a which is in a trappings of a sale. My lord,
lease can be assigned, but it has to be an assignment of a lease, Mr. Chatterjee.
Yes.
And it has to be stated so. But what is sold to you is agreement is to sell the entire flat.
Yes. Because, my lord,
along with servants' room, quarter room, nowhere it's written lease or sublease or assignment. We don't find any of these terms, either lease or sublease or assignment.
Yes, my lord.
If these terms were there, Mr. Chatterjee, we would have agreed with you.
Yes.
And we could have construed if there is something superfluous. Suppose somewhere it's written sale and elsewhere it's written we assign.
Yes.
Then also we could have construed in a favor. But otherwise it's absolutely an out and out sale.
Now, my lord, suppose, my lord, today, my lord, this agreement is enforced.
It's the Salt Lake transfers on steroid.
Now, my lord,
like the Salt Lake transfers, but some steroid has been put in. He went one step further and said, I sell you the property,
my lord,
which I don't have.
Section 12 of the Specific Relief Act says, my lord, if I cannot do one thing, but I am able to do something else, my lord, if it is found, my lord, by part performance, I have paid the entire consideration money and I've been put in possession, my lord.
Then what is your relief, Mr. Chatterjee? If you can't get specific performance?
My lord, the execution of the lease for the remaining period?
No, damages. At
my lord,
best. Damages.
The relief, Specific Relief Act, if my lord takes up, my lord.
This specific relief act din আছে ওখানে আমাদের যেগুলো আনানো
Now place, my lord.
Yes, reserved by yes.
Milord, subject to the rights and privileges reserved by the said Gulmohar properties under the said conveyance dated such and such, and subject apportioned or proportionate share of ground rent, municipal tax, and proportionate and apportioned share of maintenance charges and other statutory rates, taxes, impositions in respect of the said land and building to the said Gulmohar properties, and or its successor, assign or nominees, and subject also to the several other obligations, covenants, conditions, and stipulations to be observed and performed by the vendor under the said conveyance dated such and such. So, my lord, here my contention is, my lord, the reading of entire paragraph is though its nomenclature as said, but actually it is condition based on whatever Gulmohar properties reserves, whatever my vendor had. So, my lord, it's not absolutely that by this deed, if my vendor doesn't have title, a title will pass on directly to me. Like something condition imposed or written here, whatever is.
Please come to page 41, Mr. Chatterjee.
41, yes, my lord.
Last whereas.
Yes, and
whereas the vendor has represented that the said flat is free from all encumbrances whatsoever, and the vendor has not created any charge nor has done any act. How can you say it's a freehold property? It's a leased property, leased out property, not even leasehold property.
Yes.
He is the lessee.
My lord, giving an example, my lord, today in Calcutta, my lord, the Kankurgachi or my lord, whatever area, the authority, my lord, initially, my lord, take it in lease. My lord, thereafter, my lord, they have sold the properties by plot with, my lord, lease.
You are not a statutory authority,
No,
sorry.
my lord.
Mohan is not a statutory
No,
authority.
not a
If
statutory
you are a statutory authority.
But, my lord, condition is, my lord, that a lease which is in a trappings of a sale.
No, the state is the owner of those properties.
Yes, state is an owner of the property.
They are the owners of this property.
Now, my lord, if today.
And in those lease deeds, I mean, the statutory authority may very well say that, yes, these can be transferred. That clause may be there.
Yes.
Here, there is nothing of that sort.
Now,
here, the first owner was an individual owner, not a statutory authority.
Yes.
He gave a 75-year-old lease.
So that takes us to 2039.
Maybe.
So, my lord, till 39.
Residuary lease right, yes.
Yes.
But sale, no.
No, my lord, I am not on that. My lord, I am not on sale, my lord. Otherwise, my lord, what happens, my lord, the agreement.
We cannot read something with the court cannot change the terms of the contract, Mr. Mr. Chatterjee.
Yes.
We cannot change the terms of a contract either way.
Yes.
Here it is stated, whereas the vendor is now seized and possessed, etc., flat, free from encumbrances, which is an absolute swindling the whoever.
Yes.
Whereas the vendor swindling you probably your client.
Yes.
The vendor has agreed to sell the above flat for a price of such and such, free from all encumbrances. And only that rider which you are trying to put in, Mr. Chatterjee, it is there. But it's restricted only to the rights and benefits for access to that property regarding lift and it's all this thing. And it's a continuation. And this will be subject to whatever you see, the others are also conditional. Payment of share of ground rent, municipal tax, which may be the incidence of a sale also.
Yes.
In a sale also, these things are there.
Yes, correct. My lord, I bow down. I bow down, my lord, if today Gulmohar properties, my lord,
did not have the right. Gulmohar did not have the right.
No, my lord. Subsequently, after 2039, my lord, this deed says, my lord, further it can be extended by the Gulmohar properties upon renewal. So, my lord, the first preface of this recital says Gulmohar, my lord, can extend it. My lord, subject to renewal. Now, my lord, renewal, my lord, is something.
Lease, yes. Sell, no. Without free of encumbrances.
Even in lease, my lord, if lease can be allowed, my lord, under section 12, my lord, court would, my lord, direct lease to be executed. Because, my lord, past performance has happened. My lord, money has been transferred. I am put in possession, my lord, from 77.
But how can there be a specific performance of an unlawful contract?
No, my lord, kindly takes up.
Someone who does not have title sells the property to you. And you want a specific performance. You want the court's blessings to that. The agreement we can understand, but the court cannot put its stamp on that.
No,
it's seal of legitimacy.
Whatever, my lord, if I cannot perform something, but I can perform something else by virtue of this agreement, my lord, court would direct that to be performed.
Let us see section 12 here. You can read out and just hand over.
Yes, my lord. My lord,
you can read out.
12. Specific performance of part of contract. Except as otherwise hereinafter provided in this section, the court shall not direct specific performance of a part of a contract, where a party to a contract is unable to perform the whole of his part of it, but The part which must be left unperformed bears only a small portion to the whole in value and admits the compensation in money. The court may, at the suit of either party, direct specific performance of so much of the contract can be performed and award compensation in money for the deficiency.
Mr. Chatterjee, you are not wanting performance of a contract.
Today, money has flown.
You are not wanting part of a contract to be performed. The contract has to be performed in its entirety or not. You are not wanting the performance of a part of the contract. You are wanting the performance of a different contract, which was not entered into between you.
No, my lord.
You are trying the court to carve out an agreement for lease where there does not exist any. It's not a question of us. You enter into an agreement for sale, outright sale, on the presumption that it's free from encumbrances. It is not a part. If we now direct you to execute a lease deed, them to execute a lease deed, that would not be a part. A lease deed is not a part of an agreement to sell. It's a different contract altogether you are seeking to be enforced, which is not existing between you.
Milord, when a lease is executed, subject to correction. Milord.
So lease is never a part of a sale contract.
What I'm saying is, Milord, a lease, when a lease is executed for Milord times of 77 or Milord more than 1 year, Milord, what is being Milord transferred is right, exclusive right of possession, interest. Milord, title may not pass on. Milord, in this contract, additional sale, Milord, a title is added. Milord, if I may put it in that way. Other way, Milord, right and interest, Milord, is absolutely, Milord, agreed by Mohan Singh Chopra to Milord to convey to me. Milord, there is no distinction on that. Milord, he accepts money.
Mr. Chatterjee, if Mohan Singh files an eviction suit against you, you can think over that whether he's bound by estoppel. And if Mohan Singh does not file that suit, then you are not jeopardized. If you can claim damage against Mohan Singh.
No, Milord, damages to that extent, Milord, I have paid the Milord 95,000 in 77 was the entire consideration.
And you have enjoyed since 77.
Milord, 90,000 has been paid on that very date. That is recorded by a memo of consideration, Milord, that is being Milord acknowledged.
Like selling the Taj Mahal.
Now, Milord, whatever right, Mohan
you are duped by Mohan. Bad luck for that. You can claim damages against Mohan. And you have been enjoying the property from 77. That is sufficient retribution.
Milord, tomorrow, Milord, kindly visualize the situation, Milord. Tomorrow, 2039, Milord, I have a right to remain in possession. Milord, there is no, Milord, dispute till date Mohan Singh doesn't come up. Milord, to controversy.
Really stay there. But court cannot direct a sale deed to be executed in your
today,
favor.
after 2000.
Mr. Chatterjee, you are arguing a ridiculous proposition. There is an agreement for sale between you. You are asking the court in the name of performing a part of the contract to direct execution of a lease deed on the basis of that. That is precisely what you are asking. You have filed a suit for specific performance of an agreement for sale, and the court will direct execution of a lease deed in performance of that agreement. Can you even listen to yourself?
Yes,
What
Milord,
you are arguing?
Calling from Milord, I understand. Milord, I was only besieging Milord what he could have performed. Milord, the law says, Milord, if an owner, Milord, cannot transfer his title, but he can transfer, Milord, whatever right he has.
He could, he did not.
Milord, a term, Milord, of lease, Milord, if Milord sees the recital,
Yes.
Milord, all along the recital, Milord, he says, Milord, what has been divulged, Milord, from the original owner and what has been executed thereafter by the Gulmohar property. Now, Milord, in this backdrop of recital,
yes,
Milord, he covenants with me with a rider that whatever Gulmohar property reserves with respect to the property and whatever my rights are there in terms of that agreement or registered deed of 12 September 1971. So, Milord, whatever right he had pursuant to that deed by which he became entitled to transfer, Milord, he is reserving his right to that extent.
He cannot rewrite a contract. Sorry. Sorry, Mr. Chatterjee.
The Milord
cannot rewrite a contract. You have tried to level base.
Takes up paragraph 4, page 44 of that agreement once again. Milord, there are certain terms used. Milord, though not specifically lease, but Milord, terms are Milord exclusive possession.
Let us see those.
Milord, 44, paragraph 4. It is recorded that
these are incidents of sale also.
Yes, Milord, but Milord, along with sale also, lease also gives this exclusive right of
lease
possession.
may give, but a sale deed has been, an agreement for sale has been entered into, and these are valid incidents of a sale. So why should you read a lease into a sale deed, sale agreement? The agreement is entirely for sale, and all the incidents are also common to sale. Why should we read a lease into a sale? Court cannot direct performance of something else than the contract which you are asking for. You are relying on an agreement, you seek a performance of an agreement for sale. Court cannot direct in performance of that even if you decree a suit. We have to direct a sale deed to be executed, which the court has refused to do because your vendor did not have title. How can the court direct even a lease agreement? That will be rewriting a new contract between you. In a specific performance suit, we cannot do that, Mr. Chatterjee.
Then, my lord, today, my lord, court ought to have, if my lord had, the court had not directed to, my lord, register, my lord, or grant a decree of specific performance. Alternatively, my lord, court ought to have, my lord, directed the vendor to, my lord, return back the money with interest, because he, my lord, takes and, my lord,
You ask for that.
My lord, subject
Court is
to
not, it appears to be a panchayat, but not a panchayat. Khap panchayat, not a khap panchayat. Till
Lord,
now. Where
Lord,
is that
I-
relief sought? Have you sought that relief?
linked.
Alternatively, damages? See what you have sought. A, B, C, D. You have spent up to G. Receiver engine, not even any prayer for alternative damage.
Not
That
clear.
we saw that, but we gave you a chance.
Now, my lord, there is one.
No, we are
decision-
closing arguments.
No, my lord, one decision of Honorable Supreme Court.
Cite it quickly.
No, I know. Actually,
Cite it quickly, Mr. Chatterjee.
just a minute, my lord. I'm handing over the power. Well, with regard to part performance. If my lord takes up.
Which paragraphs?
Yes, my lord.
Was it a case where there was a sale agreement for sale
No, my lord,
and
the-
lease was directed?
The ratio, my lord, I will rely upon. My lord, the ratio which was held.
Ratio is not applicable, Mr. Chatterjee. You are wasting your time. Anyway, which paragraphs?
My lord, kindly takes up, my lord, from 69.
Give us the
Onwards,
paragraphs.
69 to 74 would be the relevant
Pardon?
paragraph. 69 to 74.
We'll look through those.
My lord, may I just.
Need not place the entire thing.
No, not the entire, but the, my lord, portion which are, my lord.
Was it a case where an agreement of sale was executed
No, my lord,
and the court
there was
directed a
an
lease deed?
There was an agreement for sale. My lord, this is the subject.
Yes.
matter.
And
In
what was
that, my
directed?
lord,
Yes.
my lord.
Sell a part of the property must be.
Yes.
Sell 100 square yard.
Yes. Yes. Yes, absolutely. 100 square yard. Now, my lord, that's exactly, my lord, my point is, my lord. My lord is not rewriting something, but my lord is, my lord, calling out the, my lord, right and interest.
Not only rewriting an agreement, but rewriting the law. Rewriting section 12 also. What other judgment?
My lord, one is, my lord, when part performance has happened, my lord, there, my lord, court would, my lord, grant a specific performance. That part performance has occurred.
Yes, there is no doubt on that, Mr. Chatterjee.
It's, my
Here
lord,
there is it's on a more basic thing.
Yes.
You
And
understand
other
that?
thing,
way.
my lord, three conditions, my lord, of specific performance, if I'm within the limitation, that if the conditions of readiness and willingness pleaded and other conditions are satisfied to the extent that I am ready, my lord, and the vendor, my lord, is not coming forward.
Still, Mr. Chatterjee, you must be knowing specific performance, even declaration is not, the court is not bound to give such relief.
My lord,
It's still discretionary even if you prove your case. The court has to give reasons, but court can still refuse.
My lord, but discretion today, my lord, after the amendment of the Specific Relief Act, my lord, it is shall. My lord, the language has changed from may to shall. But my lord, I will also, my lord, candidly submit, my lord, when the question of title comes in, my lord, court is not, my lord, powerless to inquire into that. My lord, here, my lord, the question of title, my lord, knowing fully well, putting myself in caveat, my lord, I say, my lord, Mohan Singh Chopra, my lord, whatever he had.
Mohan Singh duped you, but you got the possession of the property, you have been enjoying the property.
Interpretation of a contract, if I may take into, my lord, Mohan Singh actually wanted to give whatever he had. My lord, though, my lord, terms of sale Milord, terms of encumbrances.
By that his bank account should be in your name by now. By that logic.
With regard to that flat number 61, Milord, he has divested himself of
Mr.
the right.
Chatterjee, don't waste further time. What is the any other judgment you want to say?
Milord, other judgment is with regard to that, Milord.
Cite.
It's Milord, no more at discretion, Milord.
Yes, that is important.
Milord, that is in 2020 also, Milord. My Lord will find
That
that
is
paragraph 72. Milord, it's no more at discretion.
Para 72.
72 of that 2020 judgment, Milord.
No, 2018. Oh, para 72 of that.
Yes.
Yes, very well. And this para?
And Milord, this
the other one para?
Other one, Milord, if my Lord takes 16 to 20. This is with regard to that part performance, Milord.
No, this is not regarding no discretion.
No, this is part performance that he was put into factual
And
matters.
2020 para 72 is no
Yes,
discretion also.
No more a discretion, Milord. Now, Milord, 19 paragraph, the factual aspect in this judgment, my Lord will find he was put into possession, consideration passed on.
Yes.
There, Supreme Court intervenes and says, since this has happened, specific performance should be granted, whatever there may be. Milord, 19 and conclusion. This is with regard to part performance, 53A, Transfer of Property Act.
Why was it refused in the first place?
Milord, it was refused. It may not takes up the facts. Milord, again, agreements of sale were entered, but later on it was found that if my Lord takes up paragraph 3, Milord, a party died, and Milord, shares, Milord, what was agreed, Milord, was divided into other parts. So, Milord, after the death, Milord, one said that I did not have the title after the death. So, Milord, their Supreme Court went on to say, Milord, in this factual background, Milord, a party has performed his part of the performance. And he has, Milord, put in possession. I was enjoying possession since long. On that very date of execution of that agreement.
If Mohan had filed an eviction suit against you, definitely barred by estoppel
today
because of part performance 53A.
But Milord, even today,
Specific
Milord,
performance is a higher relief.
if Gulmohar Properties today after 2039, Milord, acquires the right, Milord, from the original, because Gulmohar Property reserves its right. Milord, he doesn't forego his right because he has constructed 37 flats.
Post facto. It cannot,
Milord, today if my
cannot
right,
regularize your prior right.
well, if today my right doesn't accrue, Milord, by way of enforcing this agreement or execution of lease, recording, whatever Mohan Singh had is transferred to me. Milord, I cannot pursue Gulmohar Properties for subsequent right what he develops. Milord, kindly visualize this situation.
No, you cannot.
I cannot.
Yes.
So, Milord, today my right, Milord, after part performance, that right has to be reserved. Actually, Mohan is giving an entire thing. Milord, he might not have title today. But today the title, Milord, the original Gulmohar Properties, if acquires title, Milord, after 2039, after
if there was an iota of something indication that it was an agreement for transferring, for executing a lease deed, Mr. Chatterjee, you could have had a say. We don't have any handle to give you relief.
Milord,
we saw the document actually. We were seeing the document when you were
it's only on the based on the
we saw
research.
the other portions also.
Exactly.
It's very difficult
But
on
I
this.
find the relevant part is whatever he had, the right title,
Whatever
with
no
reservation with Gulmohar Properties.
Reservation with Gulmohar, the entire thing that is, I mean, canalized through that right to access that and subject to tax, whatever rights were there.
And Milord, right subject
The
to whatever
substantive rights, no. Substantive rights, he says, and he most importantly says it's a freehold property, and he wants to sell it to you.
Yes.
How can we direct specific performance of this agreement
No,
You are seeking a specific agreement. You are not seeking a general leave. Ask him to execute a lease deed. No, you are seeking specific performance of a particular agreement which says that it will be sold to you freehold. That we cannot direct. The court cannot direct.
My lord can always say, my lord, whatever Mohan has, he has to execute that. If this agreement is enforced even today, my lord, by registering it, my lord, whatever Mohan, even if I today, my lord, I'm not an owner, but I give, my lord, a flat.
We'll consider that, Mr. Chatterjee.
And my lord, lastly, my lord, if the conditions of limitation, my lord, and that is, my lord, occurred.
Why are you keeping it up your sleeve? You should have cited it by now.
That is, my lord.
Paragraph.
Yes. Paragraph, my lord, is 25. My lord, here also balance consideration passed.
Here it was readiness and willingness. Which
Readiness.
was,
Yes, my lord, absolutely pleaded.
that is a different proposition. This is a
My
judgment
lord,
of a
only
different.
points for consideration is, my lord, today if nothing is given to me, if Gulmore gets something, my lord, today I will be nowhere. My lord, and Supreme Court in that decision says, my lord, it has to be, my lord, specifically enforced because I was put in possession, they're also put in possession, and the balance consideration has passed on.
We'll definitely consider that because of your plight. Because Mohan has duped you. There is no doubt on that. But even then, definitely we'll consider if there is some handle, Mr. Chatterjee will try to give relief. But as of now, it's 70-30 against you. Even 75-25 against
you. 25 also, my lord, put
yes,
under
25 is quite a large number. So it's 75-25 against you. We will definitely, I mean, we won't pass this judgment tomorrow. We could have passed the judgment today, but that would be doing you injustice because you have a point on equity. Definitely, you have a good point on equity. And because the other side is Mohan, I mean, who has done this? No, not because of his name, I mean, because he's your vendor and he has done this to you, knowing fully well. We'll consider that. Hard learned counsel for the appellant, full stop. Since service on the respondent was dispensed with, comma, the appeal was heard ex parte, full stop. Hearing is concluded and the matter is reserved for judgment. Good argument.
Well,